Good morning, everybody, and welcome to Law and Crime. I'm Jesse Weber, and thanks for joining us. Yeah, I'm here with you for the next 3 hours to talk all things YNW Melly. The Broward County courtroom was dark last week, but the trial for the murder of my mind rapper is back in full swing. The state is wrapping up their case in which they allege 24-year-old Jamell Demons shot and killed his two friends from inside of a vehicle back in October of 2018. Demons and his co-defendant Cortlen Henry have a very different story than what prosecutors lay out. They say that they fell victim of a hit and run, and that fellow rappers Anthony Sakchaser Williams and Christopher Juvy Thomas Jr. lost their lives that day, and soon it is all going to be up to a jury to decide how exactly this happened. Well, Law and Crime's Terry Austin is back in Florida getting ready to sit on the proceedings today, but first, she is with us. Good morning, Terry. Good to see you. You're outside the courtroom, but inside the courthouse. I think I could see you there. So it has been a long time. I think we all need a little bit of a refresher about what has happened. The jury was gone last week. It's been a week since the jury actually heard testimony in the case. Remind us, what were some of the last things the jury heard before they took that long break?
Well, right before the jury took the long break, we heard from Christopher Thomas's mom, Leandra Phillips, and she was on the stand for the prosecution simply to identify her son. It was a very short testimony. She was up and down in probably less than 5 minutes, but the courtroom was very intense, listening to every word she had to say. I think the expectation was she was going to go on longer. The defense did not ask her any questions, but instead just stood up and said, "We are really sorry for your loss." And that was the last thing the jury heard. There were motions, of course, last week without the jury, and we were hoping that we would get a chance, that jury would get a chance to view the car, but the judge ruled on that motion and said no. Those were the very last two things that happened last week.
We'll get into that in a minute. I do want to ask about what the jury saw. I remember there were these videos that were being played in court with no sound on them. I'm not sure we understood what the context of them were or what the jury was supposed to take away from them. Do you remember that?
Yes, Jesse, I was sitting in there and I thought I must have missed something, but I did not. There was a witness on the stand. She was from the Department of Transportation. She introduced those videos, but she was also up and down in about 5 minutes. And then the prosecution played those videos and there was no sound and there was no description. We saw the highway and we saw cars on the highway, but the cars were very little specks. We have no idea who was driving those cars. And she played 4 or 5 of those videos. She kept going up and down, and when I say she, I'm talking about the prosecution, Ms. Bradley, and she never said anything to the jury about what they were watching. So it's a little bit confusing. I think she just wanted to get it into evidence, and you have to have someone who lays that foundation. It is in evidence, and I suppose if the jury wants to view that video when they are deliberating, they can do that because now it is in evidence. But it had no redeeming value as far as I am concerned, and I don't think the jury understood what the value was either.
You mentioned how on Friday there was these motions hearings that addressed a few of the issues, one of them being the jury view and whether or not they would get to see the car where this took place. Let's start there. You mentioned why the judge is not allowing the jury view. What was the discussion and why did the judge decide that?
Well, Jesse, I was actually a little bit surprised. The car is downstairs on the first floor. We're on the 4th floor here in the courtroom. There's really no reason why, in my view, the judge didn't allow it except for what he said, which is he thought it was redundant. They have the pictures. The jury doesn't need to go down there. But there's no cost in terms of time spent going to view it. I do think security might have been an issue. He didn't allow it that very first day when it was requested by the prosecution, but I thought he would ultimately decide that it was okay because the building could secure the premises there, but ultimately he said no. I do think part of the reason is he's ready to get this trial moving. There's no need to go down there. We had a reconstructionist. We had chairs moved in that courtroom so the jury could understand where each of those individuals was sitting. And I think at the end of the day, the judge just said, no reason to do that. Let's move forward.
Yeah, maybe a little bit duplicative if the jury already has the measurements and they understand the pictures of the car and what the layout would be. What is the significance of them going to see it? What about anything else from that motion hearing other than the jury view, the jury site visit? Was there anything else noteworthy?
there was some discussion in terms of evidence, and they were talking about photographs. All of it was really, I think, process-oriented, nothing substantive. The most substantive decision was to do with that car and the viewing. They also talked about what the trial was going to be going forward, what witnesses were going to come onto the stand. There was some discussion about witnesses who were trying to be subpoenaed and deposed and actually taking the depositions and the timing of the deposition. I do believe one of those witnesses was someone who was in the other car, that red Mitsubishi, but it's unclear to me at this point whether or not that deposition took place and whether or not the witness is going to be called to the stand. So we'll see today. The prosecution is expected to close very shortly, and if in fact the witness was deposed and the witness came, we'll see.
Okay, well, now we're going back into the state's case. They haven't officially rested. Do we have an idea of if they're going to call anybody else, if they're going to rest by the end of the day? What else are we going to see from the state?
You know, it's interesting, Jesse. I don't think there is much else. They had that gun expert in the very beginning of the trial. If you recall, he was on the stand forever. They've had DNA, they've had medical, they've had the gang expert. If you remember, he's the one with the mask on his face. They've actually, I think, done as much as they can, and they had the medical examiner and they had the reconstructionist who actually said the exact same thing that the medical examiner said. And I think the most important point that they made is that those shots that were the shots that killed the two victims came from inside the car. So there's not much else they need to establish. I think if they can get some witnesses who were in the red Mitsubishi, who was the car that was next to the subject vehicle, that might add some final point for the prosecution before that jury. I think that would help. Other than that, I can't imagine what else they need to establish.
Well, remind me of something. I remember in their opening statement, the prosecution mentioned this, I think it's an Instagram message that YNW Melly sent where it seems like he's confirming he was a part of the shooting, responding to somebody's comment and said, "Shh, I did that." Other than the prosecution's opening statement, did they introduce that into evidence, or is that something that they need to amplify a little bit more?
Jesse, I've been in that courtroom. I did not see that video, and you're right. Christine Bradley did say in her opening statement that she was going to introduce that basically because she did exactly what you said. She said that we're going to see Melly say, "I did that." Shh. That did not show in front of that jury. So I'm not sure how she's going to explain that. If it did show, I did not see it. Yep. So it's interesting that she mentioned that. I think it was something she wants the jury to think about, but the evidence has just not been there.
Do you know who the defense plans on calling, other than maybe the defendant himself, which I think is highly unlikely? But are they going to have their own medical examiner, their own pathologist, their own crime scene reconstructionist? Any idea about the defense's witnesses?
I went through that witness list, Jesse, and yes, they do have two medical examiners who are listed on the witness list. They're listed as doctors, so I assume they're going to be able to talk about the autopsies, and I'm certain that they have reviewed the reports, and I think they may try to contradict what was said on the prosecution's case, but I do expect to see that. I also saw a number of other names, and there very well could be an expert talking about how that scene actually occurred. I think that's probably, in my opinion, the most important thing for the defense to establish. They're going to have to say, look, it wasn't an inside shot that killed the individuals, and it wasn't something reconstructed from the inside, that it was possible that those bullets could have come from the outside. We did see the defense on cross-examination saying to the reconstructionist, look, isn't it possible that these bullets could have come from the outside? And the answer was no, but I do think the expert that they call on, if in fact they do, will say, yes, it is very possible that those bullets came from the outside of that car.
Now, I might have been mistaken here, but I think I was looking at the witness list too. Maybe I was confusing the trials, but remember, this is a death penalty case. If he's convicted, this will move into the penalty phase. I thought I saw some potential witnesses for the defense and also for the prosecution if this goes into the penalty phase. Maybe people who know YNW Melly from his life, family, friends, and maybe mental health professionals. Am I wrong, or is that something that you're seeing too as potential witnesses if this moves into the penalty phase?
That's exactly right. On the defense list, there are witnesses listed as family. I think there's one uncle. There might have been a grandfather, but there's some relatives who are listed who would come on, I think, for that penalty phase. I'm not exactly sure if there are others that they didn't put and use a description, but they absolutely did describe some family members there. Other than that, it's really hard. I mean, obviously, you're looking at the list, and it's a long list of names. It's hard to determine exactly why they are coming, but there are definitely several family members, and I would assume that they are coming on behalf of the defense.
All right, Terry Austin, I know that you have to jump back in there, but great reporting and great analysis as always. Thanks so much. We're going to check in with you later.
Thanks, Jesse.
All right, so as Terry gets settled into that courtroom for us here at the network, we're going to take a quick break. But first, stay with us as we watch this very special report from Law&Crime's own Sierra Gillespie.
Everybody get down! Give me all your money! Let's get the buckets! Give me all your money!
A would-be robbery doesn't go quite as planned when a suspect storms into a nail salon demanding money, but no one reacts to his threats.
Hey! Where's the money?
Security video shows what happened on July 2nd in Atlanta, Georgia, when a suspect walked into the Nail First salon. The man calls for everyone to get down and hand over all their money.
Everybody get down! Give me all your money! Let's get the buckets! Give me all your money!
But instead of giving up their valuables, customers and employees don't react at all. The salon's owner even answers a phone call rather than interact with the suspect.
Get out! Where's the money?
One woman does react, though. Video shows her stand up and put her hands out. The suspect then snatches up her cell phone.
Give me the money! Where's the money? Everybody give me everything!
As the woman steps outside, the suspect screams for the others to hand over their money.
Thanks for coming back to Law and Crime, everybody. So we're waiting for day 12 of the YNW Melly double murder trial to begin. And although the trial was dark last week, there was a motions hearing on Friday that we were talking about. And one issue that was addressed was whether or not the jury would be able to view the car where the shootings took place. It's essentially the crime scene. Now, of course, this is the car. This is the car in question where the prosecutors allege that the defendant, 24-year-old Jamell Demons, shot his two friends, Anthony Sakchaser Williams and Christopher Juvy Thomas Jr. Now, again, the prosecution is saying that Demons and his co-defendant Cortlen Henry deliberately staged this as a drive-by shooting, but really they have presented evidence to suggest the shooting came from inside the car. Now, after further investigation, this is why we've heard from medical examiners, we've heard from a crime scene reconstructionist. So it became a question of, should the jury actually see the car? Would they gain something from it? Well, Judge Murphy ultimately denied the motion for the jury view. So let's take a look at how that argument went down.
Relying on the written motion and Your Honor's recollection of the testimony and argument that was made in open court as to how it would benefit the jurors. It is separate and distinct from the other items. In fact, the state would submit that the state could offer the entire car into evidence because it has been preserved. It has been in the same condition since it was initially put forth. And there is no limitations in the evidence code as to the size of the piece of evidence. If it doesn't come in through the courtroom doors, Your Honor, the state would submit that there would have to make arrangements for the jurors to be able to view the item of evidence.
I did file a response, Your Honor. Were you able to read?
Yes, ma'am. I saw it. Anything else?
I would just add that we have yet to view the car ourselves. We're supposed to go see the car this afternoon after court. But as I set forth in my motion, I believe it's overkill. Her witness testified to the specs, the measurements in the car. We actually have photographs that have been moved into evidence that have measuring sticks that clearly show you the distance in the car. Her proposition that we need to see the car so they can see the purview, I guess she's planning on these jurors sitting inside the car, which makes no sense because they don't have the same measurements as the decedents. Moreover, I'd like to point out, we don't even know where the decedents were truly sitting because there are no crime scene photos that actually show them being in the car at the hospital. All the pictures that we were shown are of the decedents, the car being empty. So I would even argue the proposition of what she's trying to say, this person sitting here and this person sitting here. There's no actual evidence.
Judge, there was a motion filed at 9:54 p.m. last night that affects the state's second witness. I don't know if Your Honor wants to address it this morning, in addition to the state's second motion eliminating. Or you want to do it after the first witness? It's going to be fairly short.
Tell me what the issue is now.
So the state on Friday afternoon after Mr. Glass's deposition filed state's second motion eliminating. Does Your Honor have a copy of that?
I have a motion limited filed by the state. I don't know which one we're talking about. I've read it. Yes.
I emailed it to Your Honor's JJ on Friday afternoon. It's titled State's Second.
Yes, I've read it.
That's what Your Honor. So there are three motion eliminations. The first one is regarding the defendant's essentially self-serving hearsay statement during the deposition of Mr. Glass. Counsel asked Mr. Glass whether or not the defendant had ever admitted fault, essentially in the incident. So that would be a self-serving statement that the state would seek to exclude, in addition to any other self-serving statements during cross-examination.
Anything else you want to talk about?
Yes, that was just as the point one. Second, prior bad acts. As to the witness, Mr. Glass, any prior arrests that did not result in any convictions. In addition to, counsel brought up an alleged shooting incident that was denied by the witness, and there was also allegations of him being, just generally involved in bad acts. So we would move to exclude any of those. He does have 2 prior felony convictions, so those would be what counsel's testimony should be limited to. And finally, the drug use, which I cited to Edwards versus State, which is 548 Southern 2nd, 656, Florida Supreme Court, 1989, regarding when counsel can inquire from a witness whether or not he's utilized drugs. The witnesses admitted and did admit in deposition that he did smoke weed on the date of incident. But however, counsel did inquire as to his general drug use, And so the state would seek to exclude any general drug use that's not related to either the date of the incident or, according to Edward versus State, any other testimony that would affect his ability to recall events. And those are the state's 3 motion eliminations.
Well, it's one motion eliminated, but 3 paragraphs.
Yes, 3 paragraphs, yes.
Thank you. Defense, Mr. Chairman.
Good morning, Your Honor.
Good morning.
As to, I'm trying to recall, as to the issue of drug use, I'm not thinking that it's our intention to date his drug use back to birth. However, we know that one of the lasting and long-term effects of chronic marijuana usage is affects one's memory. So the fact that I think when he was asked, do you smoke marijuana, his answer was yes, and how often, the answer was whenever I can. I'm not sure that we should be limited to the day in question, because the impact of such chronic use, whenever he can get his hands on it, impacts his ability to recall matters. With respect to his prior bad acts, there are 2 felonies which are clearly our impeachment. And beyond that, however, he was charged. This is a witness who made himself deliberately unavailable to the parties for years. He then gets charged in May of this year with a crime, and now and then watches the proceedings on television and has suddenly made himself available. That goes to bias his intent.
I don't think the state was suggesting that you couldn't ask questions about whatever current charge he has. Are you suggesting that?
No, Judge, I didn't address that, because he can ask about the charges, about the maximum, minimum penalties, and I would agree that he could ask whether or not he's been incurred in favor in exchange for his testimony as it relates to that.
With regard to the current charges.
Correct.
And well, if the state's position is we can't impeach him with anything beyond the current charges and his felonies, we agree. I can't remember what the first point was.
So it was self-serving hearsay statements of your client.
First of all, it's not a statement. A statement are utterances. The question that was put to the to the witness was whether or not Mr. Demons ever admitted involvement in the activity. The answer is no. There was a time during which the witness indicates that he was inquiring of various people what may have happened. And him saying that Mr. Demons never admitted involvement in the offense is not him uttering a hearsay statement. It's him denying the existence of any statement, hearsay or otherwise. So I don't think there's a hearsay exclusion to the failure to admit involvement in an offense. So I don't think that that question ought to be precluded if, in fact, we decide to put it to the witness.
Thank you. Well, regarding the first issue about the witness's alleged testimony that the defendant, Mr. Demons, didn't admit to him that he was involved in it. That's not something the witness observed or anything. That's in essence an exculpatory statement. I agree with the state. You can't do that. Granted, regarding the prior bad acts and impeachment, we're all on the same page. You can ask about whatever the pending charge is. You can talk about that in the prior 2 felonies. But as to other uncharged offenses that may have happened along the way, those are not, can't inquire as to those. As far as the the drug use, I mean, if he's using marijuana, cannabis at the time, I mean, that's all fair game. I don't see any issue with that. And if he uses it frequently, I don't see any issue with that either. I mean, it's, I don't know that that's the type of, it may have been at one time the type of drug use that was concerned, but it's stayed in your system for a while, it has effects on you. I think all that's fair game. I don't have any issue with it. And I understand Edwards talks about when you're under the influence of something, but if it's over a period of time, I mean, I've heard from various experts how long it stays in the system and how long it can do it. So it can be for a period of time.
Okay, and just to clarify, Your Honor's ruling, period of time meaning from the date of incident to current date, or even predating the date of incident?
Counsel, to me, it's fair game. They can go into it.
Okay, I just wanted to
I don't have
clarify.
any issue with it. All right.
And Judge, the defense did file a motion to exclude Trevion Glass from testifying at all. I don't know if they want to or Your Honor wants to address it at this time.
We can address it at this time.
Sure, go ahead.
Did you have a chance to read my motion and the case law this morning?
I did.
All right.
Thank you.
So it's basic, as I stated in my motion. After 4 years, we're finally able to depose Mr. Trevion Glass. Interesting enough, as I set forth in my motion, and I attached the pages of his transcript, he states that it wasn't until he started watching YouTube, because this case was live streaming, and hearing his name repeated everywhere, that he decided to call up the prosecution. As I further stated in the deposition, specifically questions were asked about his independent recollection of this incident, and he clearly states, let me go to it, I wasn't aware who got into what seat that day, but from me watching what's going on, yeah, I know now, yeah. Mr. Howard then clarified that. Watching what's going on, do you mean the trial proceedings? He said, correct. Looking at this rule of sequestration, and we know it here as the rule dates back to biblical times. And going back into them, it's been well established that we need these protections of this rule of sequestration to prevent witnesses tailoring their testimony to match the testimony of the previous witnesses. And that's exactly what we have here. 2023, in the Bible they didn't have a TV live streaming into the courtroom. So most of our rules, when we were dealing with it, are saying, you cannot sit in this gallery and then come up on this stand and testify. But if he's sitting there watching from that TV, from the comfort of his home, there is no difference from him sitting here in this gallery and then getting up there and testifying. That is the crux of this rule, and that is exactly what it is meant to prevent. Sequestration of witnesses is one of the oldest and most time-honored rules in the court system. It's to ensure that we have effective truth-seeking. And we won't have effective truth-seeking if he's allowed to sit here, watch everybody testify, and get up there and then tailor his testimony to the last 3 weeks of evidence and other witnesses who have testified. I've provided the case law. I think the law is clear. Reading into that case law, because this rule of sequestration, we do have a sister rule in the federal court system, 615. And they've actually gone on a little bit further with their cases to give us examples of out-of-courtroom communications that are not allowed. And they give us examples of witnesses sitting outside of the courtroom talking about what they testified with another witness who's going to testify. They talk about giving witnesses the transcripts of other witnesses and preventing them from testifying. In this case, again, he watched the entire trial. We don't even have to guess about this because he tells us in his own deposition that he's been watching this trial, that he's heard his name in this trial, and that's why he's decided after 4 years to come and testify. He must be excluded to guarantee my client a right to fair trial.
Thank you. What's this state?
And judges, exclusion of the witness is the harshest sanction that this court can impose. The state acknowledges there was a violation of the rule of sequestration. The witness indicated so in deposition. However, counsel's representation that he watched the entire trial is wholly inaccurate. That's not what his testimony was. So the court must determine whether or not it was an intentional violation, whether it was inadvertent, or whether it was any bad faith on part of the witness or the state here in particular. The state would proffer that it was an inadvertent violation. It was unintentional on part of the state. As your honor is well aware, it's been documented that Mr. Glass has not been cooperative with the state. We tried to subpoena him pre-trial. In fact, the first time the state spoke with Mr. Glass was after his current arrest, which I believe was in June of 2023. The state contacted the witness for the first time and was able to speak with him after we had already began trial testimony. The witness indicated to me that he would not be here, he would not come, and he would not cooperate with the state subpoena. He did corroborate that in his deposition, that he did in fact inform me of that information. And therefore the state operated as he was not going to testify. It was not until the defense subpoenaed the witness that he became compliant and came in on Friday. I think the first time he came to Broward County and the state met with him was on Thursday of last week, which I believe was July 6th. So the first time the state would actually had an opportunity to even speak with the witness in person and inform him of the repercussions of the rule of sequestration was well after testimony had begun already. And the prejudice that the defense has cited in their motion is essentially that he's watched the video surveillance, which is currently in evidence at stage 7, and has changed his testimony based on his review of the video surveillance. So two things. He did give a statement to Detective Moretti back on February 26th of 2019, and he indicated that he got into the back seat of the red Mitsubishi. He's now been refreshed, and his memory is now refreshed that he did in fact get into the front seat and not the back passenger seat of that red Mitsubishi. The state would proffer that that prejudice is minimal, and the reason is because we have video surveillance. And so Mr. Glass, in and of himself, can be impeached based on his prior testimony saying he got into the back seat versus the front seat. And that's the only prejudice that the defense has outlined in his deposition testimony that has been colored by his view of any of the trial testimony. And so based on that information, one moment, Judge. The state would say that rule of sequestration for this court to exclude him completely as a witness would not serve its purpose. It's not a per se rule to exclude. The trial court has discretion, and I would ask you to exercise your discretion because there's less intrusive means, being one of him being impeached based on the inconsistency itself.
You have the transcript of this witness?
I ordered a copy and we did not receive one.
I do have the transcript, Judge.
If counsel can be so kind as to also provide us with a copy, we haven't received our copy.
Any problem with that?
No, I can email it right now.
All right, so could you give a copy of that to Travis?
Yes.
And what I'll do is I'll make it, I don't know if I'm allowed to make copies.
I can email to Ingrid, and then I can email to them. They have their copy machine right there. I do have one quick follow-up, Judge, if I may.
Sure.
So there is a line of cases, and counsel is arguing from the line of cases where the defense has violated the rule of sequestration. So when it's a defendant violating the rule of sequestration, you do have to go into a Sixth Amendment analysis because it's his constitutional rights that the court still has to protect. And that's why you have that stringent standard. However, when you're dealing with the prosecution violating the rule of sequestration, then it becomes the question of my client's rights to a fair trial. And that's how the analysis should go. And you're looking at those line of questions when you go to 96.16. There is another section that comes down that gives exceptions to the rule of sequestration, which we see. We have the witness's family in here. Why are they allowed in here? Because of 96.16 gives that exception. But there's case law that says when that family gets up there to testify, Mr. Demons' client rights to a fair trial will trump the other people's rights in this case. In this matter, Mr. Glass doesn't have any rights to be in this courtroom. He has no right to be watching this from TV. His testimony to the evidence. I would ask that we look at this in the light most favorable to Mr. Demons and his constitutional right to a fair trial. And that's what we want today. And it's not going to happen with a witness who's been watching this proceeding from the comfort of his home.
But the defense isn't suggesting that this was all some type of connivance with the state, that they planned this or executed in some fashion to get around the rule of sequestration. You're not suggesting that. You're suggesting that you shouldn't be allowed to testify because it's a violation of the rule, which the state's agreeing it's a violation because the rule of sequestration was invoked. But you're not alleging or suggesting the state had anything to do with it, are you?
So, Judge, and I did ponder this last night, and for the sake of being a professional, I did not come with a motion for prosecutorial misconduct. But as we've heard Ms. Smith admit herself that she sat in that deposition with us, and they too realized that he had been watching the trial from his own testimony. The simple fact that the state now wants to even put him on the stand is knowingly, Judge. They knew in the deposition, 1. 2, they knew when I put him on notice with my motion. So they had the opportunity after the deposition, 2, after my motion pointing out we violated the rule of sequestration, just not to call them. They, however, are going to continue to proceed knowing he has violated the rule and put him on the stand. So, yes, when we look at it that way, the state may be acting inappropriately.
Thank you. And counsel, from your perspective, as far as the state's concerned, once you found out this witness was going to, his location was found, and you gave his address over, and I know you said he wasn't going to cooperate. I think you made that representation in open court a week or so ago as well. I don't know the exact date, but you made a representation to that effect. When was the first time that you advised the witness that the rule of sequestration was invoked?
Judge, last Thursday, because prior to that, I had only spoken to him on the phone, and he had told me we essentially had abandoned almost calling him as a witness absent a decision to do a rule to show cause, which we had not decided at that point. So when he told me he wasn't coming in, I had no further conversation with him until he contacted our office, and that was in response to the deposition. And counsel's essentially...
What date was that?
I can have counsel look up the exact date to let you know, because we have an email when he contacted our office.
That's the time that you told him the rule was invoked?
No. He called our office indicating that he had gotten a subpoena and whether or not he needed to appear, which we indicated, yes, he did need to comply with the subpoena. We tried to make arrangements for him to come. I believe his deposition was scheduled on a Tuesday, if I'm not mistaken.
No, that was the deposition that was set, if you recall, without any discussion or scheduling with the state for that Friday.
So it was set on a particular day, and he failed to appear that day. And then I called him when he failed to appear while defense was still in state attorney's office in the lobby. I said, "Are you in Broward County right now?" He said, "No, I'm not. I don't have a ride." I said, "Okay, if transportation is arranged, can you make yourself available?" He said he would. He called us. He told us he would be in Broward County, I think, Thursday afternoon. He called us on Thursday, said he was in Broward County, and that was the first time we met with him in person. And I would say, Judge, the defense is asking you to essentially apply a per se rule. The case law says there's no per se exclusion for the rule of sequestration. The only thing she's saying that's been affected is his seat position in the Mitsubishi car. That seat position is on video. It's in state 7. And so that's something that the state can even show the witness in preparation for his testimony. It's something we would publish during his testimony. So that contradiction between where he sat in the car is not of the sort that should exclude his entire testimony and would color his testimony.
Thank you. My question, though, as to when you first advised the witness?
Thursday, Judge, when we met with him in person.
Last Thursday?
Yes, Judge, when we met with him in person for the first time.
Thank you. All right, can you defer ruling on it? I'd like to read the transcript.
Your Honor, I think the case law is also clear that you need to read his initial statement to see if there's been any change in his statement from the initial statement to the deposition.
And I'm going to provide, if I can approach, Your Honor.
Where's the case law? I thought you were handing me case law.
I'm providing the statement, so I can provide it to the judge.
I have the statement. I want to see the case law you're quoting to, because we're talking about excluding him. I didn't see any case law. It says
I don't think they
substantial.
cited any case law, counsel, they just cited the rule. But let's do this, though. I'm not done with this yet. I want to read what he said, as well as a statement. I want to take a look at those things.
May I approach, Your Honor?
Sure.
And so the
Who's your
case,
next witness, by the way?
it's Danny Benitez. He's a records custodian, so we anticipate it's going to take about 5 minutes, which is why we need it.
Where's your next witness after that?
Mr. Glass.
Where's this Detective Moretti?
He's also going to be this afternoon. And Judge, I'm going to print out the copy of the case law that the state is saying to, which I'll print out a copy for counsel and for Your Honor.
She's got her notes on it. I don't want that, because you have your notes on there. So I'm not.
So I'll take the, it's just the last.
Sorry, can you just email it?
I'll do it right now, Judge.
Thank you. She'll print it out. I would like to read it. And we'll just have it marked as a court exhibit for the purpose of this. So.
State's otherwise ready, Your Honor, to proceed with the first one.
Who is the first one?
Dan Benitez, Director of Custodians and Montessori School. And Judge, we do need to do one quick order to keep State 64 under seal for the purposes of the clerk. There is sexually explicit photos of minors and videos on there, so that has to be, the clerk needs to be made aware of that on the 9804. That's the 9807. Mr. Demons, Mr. Demons.
Any objection?
No objections.
All right, go ahead and sign. I'll sign it. Thank you. All right, we all set, ready to proceed?
Yes, Your Honor.
Defense?
Yes, sir.
All right, let's bring the jury. Jury entering. Ladies and gentlemen, thank you. Please be seated and let the record once again reflect the presence of the defendant, Mr. Demons, his counsel, the assistant state attorneys, both ladies and gentlemen, jury. Hope you had a good week last week. In any event, we're back on, so I think the state is still on its case in chief. Can we call your next witness, please?
Yes, Your Honor. The state calls Danny Benitez.
Danny Benitez?
Yes, I am, sir.
Well, this is our witness stand. Can you come up here, please? When you get there, remain standing for a bit. Raise your right hand and be sworn.
Do you solemnly swear or affirm the testimony you should give in this case shall be the truth, the whole truth, and nothing but the truth? I do. Please state your full legal name for the record. Daniel Benitez. Please spell your first and last name for the book.
Daniel Benitez.
Thank you, sir.
Please, have a seat.
Thank you.
Benitez, that microphone in front of you will adjust up or down, but doesn't move back and forth, all right?
Okay,
Ready to go?
I'm ready to go.
Perfect. Counsel, you may proceed.
Thank you, Your Honor. Good morning, Mr. Benitez.
Good morning.
Can you tell the members of the jury where you're currently employed?
Sure. I'm employed at Montessori Academy in Broward in Pembroke Pines, Florida.
And have you been employed with the Montessori School in one capacity or another since October of 2018?
My wife and I started the school in 2002, and up until today, we're still involved in the school as director of the school. I'm the operations director of the school.
And back on October 26th of 2018, were you you and your wife the owner and operators of that school?
Yes, we were.
Okay. And the Montessori School, where's the specific address?
The address is 19200 Pines Boulevard, Pembroke Pines.
Okay. And you mentioned that's in the city of Miramar, correct?
Yes, I have.
So at some point in time, you provided video surveillance from your school to law enforcement, either 2018 or early 2019.
Yes, I have.
And how long is the system, how long does the video maintain until the system overrides naturally?
The system actually maintains a backup for 90 days and then overrides itself with the oldest of the events being erased.
Okay. So in order to preserve video surveillance, you would have had to capture it and preserve it within that 90-day window, correct?
Correct.
All right. And you've had an opportunity to review the video surveillance that was provided to law enforcement and then placed on a USB?
Correct.
All right. Your Honor, at this time, we're showing the counsel with pre-marked as states quadruple H, so HH. May I approach the witness?
You may.
It says, is this the USB you were able to review?
Yes, it is.
And how are you able to recognize this particular USB?
Well, it has my initials on the back.
Okay, and did you sign in and initial it after reviewing the video surveillance?
Yes, I have.
Is that video surveillance a fair and accurate representation of the video surveillance that was captured back on October 26th of 2018 from the Montessori School's video surveillance system?
Yes, it is.
And that video surveillance was maintained and kept by Montessori School until it was turned over to law enforcement?
Correct.
And it's routine for you to maintain that system? In fact, you still have a system to this day?
Correct.
Your Honor, at this time, the state would move into evidence what was pre-marked as state's quadruple H. Is the next number in exhibit, I believe, 82?
And we're going to object, Your Honor. We're double checking, although they
Objections?
Excuse me. Just come sideways. Tell me what it is. Gentlemen, in a few minutes, the lawyers do not discuss the case, don't form any opinion about the case, or allow anyone to discuss the case in the presence. There will be no research. Thank you. you. Let the record reflect that the jury stepped down. Counsel remain along with the defendant. You want to play the video now? Show counsel the video. I don't know how long is it. How long is it?
3:40 to approximately 5 a.m. We wouldn't be intending on publishing the entire thing for the jury. But just so it's clear, this was previously provided from the record to defense counsel. We just now at Sidebar learned that they had not been able to watch it and the file was corrupted. They had not told us or asked for an additional copy in any way, shape, or form.
Didn't we just take care of that Sidebar? Didn't I ask them that?
Yes, Judge, but I'm making sure the record is clear on the state part on that. In addition, for the other images and things that she discussed in videos, those were from the phone, and those were available for defense. They were in my office on Friday afternoon. As to the things I said I would email, that was the PDF of all the photos that were published in open court on Thursday afternoon. Just so it's very clear, because I know Ms. Liberty was a little bit confused on some of those issues. I'm not confused on anything.
Thank you. So when is, I guess, my understanding is Detective Moretti your last witness?
Yes, sir.
All right, so what happens if I wasn't going to allow Mr. Glass to testify? What were we going to do for the next 2 hours, 3 hours?
State would be ready to go, Your Honor.
So Mr. Moretti is here.
Judge, with regards to the state would be ready with witnesses, yes, or videos to play.
Thank you. We're in recess. Thanks.
In and of himself can be impeached based on his prior testimony saying he got into the back seat versus the front seat. And that's the only prejudice that the defense has outlined in his deposition testimony that has been colored by his view of any of the trial testimony. And so based on that information, one moment, Judge. The state would say that rule of sequestration for this court to exclude him completely as a witness would not serve its purpose. It's not a per se rule to exclude. The trial court has discretion, and I would ask you to exercise your discretion, because there's less intrusive means, being one of him being impeached based on the inconsistency itself.
So again, more controversy surrounding a witness. The prosecution is not foreign to that. We saw some issues there earlier on in the case, but this concerns Travion Glass. This is, as we said, somebody who has left the recording studio at the same time as the other people in this case, and it becomes a question of what he saw or heard before giving his testimony. We're going to take a quick break. When we come back, our plan is to jump into court and see the continuation of the state's case. Stay with us. We'll be back. And welcome to our second hour of live analysis here on Law and Crime, everybody. I'm Jesse Weber, and thanks for joining us. We're following day 12 of the YNW Melly double murder trial out of Broward County, Florida. The courtroom was dark last week, but the trial for the Murder on My Mind rapper finally back in session. We believe the state is wrapping up their case in which they allege 24-year-old Jamell Demons shot and killed his two friends from inside of a vehicle back in October of 2018. Demons and his co-defendant Cortlen Henry say that they were actually victims of a hit and run, and fellow rappers Anthony Sakchaser Williams and Christopher Juvy Thomas Jr. lost their lives that day. It's going to be up to a jury to determine what exactly happened inside that car. But right now, we are listening to arguments happening outside the presence of that jury. So let's get back to it and hear what they have to say.
You have the transcript of this witness?
I ordered a copy and we did not receive one.
You have the transcript, Judge.
If counsel can be so kind as to also provide us with a copy, we haven't received our copy.
Any problem with that?
No, I can email it right now.
All right, so could you give a copy of that to Travis?
Yes.
And what I'll do is I'll make it, I don't know if I'm allowed to make copies.
I can email to Ingrid, and then I can email to them. They have their copy machine right there. I do have one quick follow-up, Judge, if I may.
Sure.
So there is a line of cases, and counsel is arguing from the line of cases where the defense has violated the rule of sequestration. So when it's a defendant violating the rule of sequestration, you do have to go into a Sixth Amendment analysis because it's his constitutional rights that the court still has to protect. And that's why you have that stringent standard. However, when you're dealing with the prosecution violating the rule of sequestration, then it becomes the question of my client's rights to a fair trial. And that's how the analysis should go. And you're looking at those line of questions when you go to 96.16. There is another section that comes down that gives exceptions to the rule of sequestration, which we see. We have the witness's family in here. Why are they allowed in here? Because of 96.16 gives that exception. But there's case law that says when that family gets up there to testify, Mr. Demons' client rights to a fair trial will trump the other people's rights in this case. In this matter, Mr. Glass doesn't have any rights to be in this courtroom. He has no right to be watching this from TV or his testimony to the evidence. I would ask him to look at this in the light most favorable to Mr. Demons and his constitutional right to a fair trial. And that's what we want today. And it's not going to happen with a witness who's been watching this proceeding from the comfort of his home.
But the defense isn't suggesting that this was all some type of connivance with the state, that they planned this or executed in some fashion to get around the rule of sequestration. You're not suggesting that. You're suggesting that you shouldn't be allowed to testify because it's a violation of the rule, which the state's agreeing it's a violation because the rule of sequestration was invoked. But you're not alleging or suggesting the state had anything to do with it, are you?
So, Judge, and I did ponder this last night, and for the sake of being a professional, I did not come with a motion for prosecutorial misconduct. But as we've heard Ms. Smith admit herself that she sat in that deposition with us, and they too realized that he had been watching the trial from his own testimony. The simple fact that the state now wants to even put him on the stand is knowingly, Judge. They knew in the deposition, 1. 2, they knew when I put him on notice with my motion. So they had the opportunity after the deposition, 2, after my motion pointing out we violated the rule of sequestration, just not to call them. They, however, are going to continue to proceed knowing he has violated the rule and put him on the stand. So, yes, when we look at it that way, the state may be acting inappropriately.
Thank you. And counsel, from your perspective, as far as the state's concerned, once you found out this witness was going to, his location was found, and you gave his address over, and I know you said he wasn't going to cooperate. I think you made that representation in open court a week or so ago as well. I don't know the exact date, but you made a representation to that effect. When was the first time that you advised the witness that the rule of sequestration was invoked?
Judge, last Thursday, because prior to that, I had only spoken to him on the phone, and he had told me we essentially had abandoned almost calling him as a witness absent a decision to do a rule to show cause, which we had not decided at that point. So when he told me he wasn't coming in, I had no further conversation with him until he contacted our office, and that was in response to the deposition. And counsel's essentially...
What date was that?
I can have counsel look up the exact date to let you know, because we have an email when he contacted our office.
That's the time that you told him the rule was invoked?
No. He called our office indicating that he had gotten a subpoena and whether or not he needed to appear, which we indicated, yes, he did need to comply with the subpoena. We tried to make arrangements for him to come. I believe his deposition was scheduled on a Tuesday, if I'm not mistaken.
No, that was the deposition that was set, Your Honor, if you recall, without any discussion or scheduling with the state for that Friday.
So it was set on a particular date, and he failed to appear that day. And then I called him when he failed to appear while defense was still in state attorney's office in the lobby. I said, "Are you in Broward County right now?" He said, "No, I'm not. I don't have a ride." I said, "Okay, if transportation is arranged, can you make yourself available?" He said he would. He called us. He told us he would be in Broward County, I think, Thursday afternoon. He called us on Thursday, said he was in Broward County, and that was the first time we met with him in person. And I would say, Judge, the defense is asking you to essentially apply a per se rule. The case law says there's no per se exclusion for the rule of sequestration. The only thing she's saying that's been affected is his seat position in the Mitsubishi car. That seat position is on video. It's in state 7. And so that's something that the state can even show the witness in preparation for his testimony. It's something we would publish during his testimony. So that contradiction between where he sat in the car is not of the sort that should exclude his entire testimony and would color his testimony.
Thank you. My question, though, as to when you first advised the witness?
Thursday, Judge, when we met with him in person.
Last Thursday?
Yes, Judge, when we met with him in person for the first time.
Thank you. All right, I'm going to defer ruling on it. Just, I'd like to read the transcript.
Your Honor, I think the case law is also clear that you need to read his initial statement to see if there's been any change in his statement from the initial statement to the deposition.
And I'm going to provide, if I can approach, Your Honor.
Where's the case law? I thought you were handing me case law.
I'm providing the statement so I can provide it to the judge.
I have the statement. I want to see the case law you're quoting to, because we're talking about excluding him. I didn't see any case law. It says substantial.
I just cited any case law, counsel. They just cited the rule. But let's do this, though. I'm not done with this yet. I want to read what he said as well as the statement. I want to take a look at those things.
May I approach, Your Honor?
Sure.
So
Who's your next witness, by the way?
It's Danny Benitez. He's a records custodian, so we anticipate it's going to take about 5 minutes, which is why we need it.
So who's your next witness after that?
Mr. Glass.
Where's this Detective Moretti?
He's also going to be in this afternoon.
And Judge, I'm going to print out the copy of the case law that the state is citing to, which I'll print out a copy for counsel and for Your Honor.
She's got her notes on it. I don't want that, because you have your notes on there. So I'm not.
So I'll take this. It's just the last.
That's all right. Can you just email it?
I'll do it right now, Judge.
Thank you. She'll print it out. I would like to read it. And we'll just have it marked as a court exhibit for the purpose of this. So.
State's otherwise ready, Your Honor, to proceed with the first one.
Who is the first one?
Dan Benitez, records custodian for Montessori School.
And Judge, we do need to one quick order to keep State 64 under seal for the purposes of the clerk. There is sexually explicit photos of minors and videos on there, so that has been, the clerk needs to be made aware of that on the 9807. That's the 9807. Mr. Demons, Mr. Demons.
Any objection?
No objections.
All right, go ahead and sign. I'll sign it. Thank you. All right, you're all set, ready to proceed?
Yes, Your Honor.
Defense?
Yes, sir.
All right, let's bring the jury.
Okay, so that was actually from a few minutes ago. We're a little bit behind. That's why I want to bring in right now Terry Austin, who's jumped out of that courthouse to explain to us what's been happening this morning. So, Terry, good to see you again. Walk us through what exactly that argument was about regarding Travion Glass's testimony and how Judge Murphy ultimately ruled on his testimony.
Well, Jesse, this is extremely exciting. Trevion Glass is one of the individuals, one of the 4 individuals who was in that red Mitsubishi, which was next to the subject vehicle. He is being deposed or was deposed last week. And what the judge is trying to determine right now is whether or not he's going to be on that stand. At first, he was limiting the examination, and now he's trying to determine whether he's going to get up at all. Initially, the state was arguing we don't want drug use, we don't want other bad acts, we don't want certain information, and the judge made those determinations. But now the defense has actually objected and said he shouldn't get in at all. And here's why. The defense is saying Melly's right to a fair trial is being violated because the witness, Trevion Glass, has watched, and he said this during the deposition, he has watched the trial while it's being live streamed. And so for that reason, he has not been sequestered. The judge was really trying to determine when did the state advise Trevion Glass that he should not be watching the trial. And he was literally just advised last week, certainly when he contacted the state, that he was going to respond to that subpoena. So it would be very interesting. It's the first time I think we've had someone who is actually at the scene of the crime. And so if he is allowed in, it should shed some light on what's been going on.
Now, I said we kind of jumped out of that because we are planning to jump back, but how did it all wrestle in the end? How did the arguments end before the jury was brought in?
Yeah, the judge has not determined that. He's determining 2 things right now. Whether Trevion Glass is going to get on that stand, and he's also determining whether Daniel Benitez, who was here, he's the custodian of record for the Montessori school, which had some surveillance of what happened that night. He's determining whether or not the jury can watch that video. Apparently, the defense has not seen that video, so the judge decided to take a break. He wants to very seriously consider both of these issues. Is Trevion Glass going to get on that stand, and whether or not this video is going to be shown to the jury? I might also add, Jesse, that he wants to see what else the state has for the day. And we do know that lead detective Moretti is going to be called and will be ready once these issues have been determined.
Yeah, so again, we were a little bit behind, but there was a witness who took the stand, and my understanding it was about providing surveillance video to law enforcement. What do we know about that testimony? And I also understand it ended early.
Right. Well, that was Daniel Benitez, and he was on the stand maybe 5 minutes, Jesse, and he stated that he owned and operated that Montessori school, which was nearby, and he had surveillance. Now, he didn't testify yet as to what surveillance he had, and the judge wants to watch that video before the judge determines whether the jury can watch it. And the defense objected, and so that's why the judge wants to take a look at that. And I believe the defense is taking a look at it, too. I think that was one of the reasons. They had a sidebar, so we could not hear that part, but it does seem as though one of the reasons the defense has objected is because they have not seen that video yet either. So, Jesse, that jury could very well see some video of what was going on that evening, and they may very well hear what exactly Trevion Glass has to say.
You mentioned Detective Moretti. I might be mispronouncing his name. What do we anticipate his testimony is going to be?
That's Detective Moretti. And yes, I think it's going to be very interesting. He is the lead detective here. And remember, he is the detective that they have accused, the defense has accused of not doing a good job in terms of investigating this case. He is also the detective who reordered, I believe, the DNA analysis of the DNA on the back door of the subject vehicle on the left-hand side. And there was also some discussion of a Celebrate report that the judge said cannot get in because the state did not produce that to the defense. So I think the judge really wants this detective to come on and to clarify some issues, and he wants the state to proceed with their case. He's asking them, who do you have? Are they ready? Can you proceed? What if I decide Trevion Glass cannot come on? Are you ready to go? And the state said, yes, we will be ready. The judge said, is your witness here? Is Moretti here? And she said he will be here. So he's ready to get the case rolling and to have them close on their case at this point.
And remind us, there was that issue about the DNA because the first test that they did didn't come back positive for the defendant's DNA. It was only a subsequent test that came back and they found something, which goes to the idea of how thorough the law enforcement techniques were and how, I think the defense has been very keen at suggesting it was a sloppy investigation. Not saying it was, but I think that's what they were trying to suggest.
That's exactly what they're trying to suggest. They're saying that it was a botched, they used the word botched investigation, and that this case has been going on since 2018, and it was only in June of 2023, this year, that Moretti decided, look, let me go back and see if I can get a second look at that DNA, and that evidence came back. And so at first, no DNA from YNW Melly was on that car. And then when they went back for a second time, apparently there was some DNA on that back door and the driver's side. So I think Moretti is an important witness, and I think to hear what he has to say about multiple issues is going to be important for that jury to hear.
By the way, who's in the courtroom today? Anything different? What's the vibe like right now? I mean, again, we've been off for a week, so I'm curious to see as we come to the conclusion of the prosecution's case, if you've seen anybody, noteworthy, anybody attending for either side.
That's a great question. I do see a packed courtroom this morning. Both sides are filled. I do see Christopher Thomas's mom in there. I see Melly's grandmom. His mom's not here yet, but she's on her way apparently. And the jury is there all ready to go. They have their jackets because it's normally quite cold in the courtroom, although I will say today the temperature is a little bit more comfortable. I think everyone is ready to start the defense case. Everyone is on their tippy toes as they're arguing these motions, and they're very solid arguments, and I think they are ready to have this trial come to some sort of conclusion. But everybody's on their P's and Q's this morning.
All right, Terry's going to jump back into that courtroom. We'll have her on later on in the program. We're going to take another quick break. When we come back, we'll see if this testimony can jump live. Stay with us. Ago, witness Daniel Benitez took the stand to testify about surveillance video that he provided to law enforcement for the case. He wasn't on the stand for very long, but I do want to watch how that questioning unfolded now. Let's take a look.
Counsel, you may proceed.
Thank you, Your Honor. Good morning, Mr. Benitez.
Good morning.
Can you tell the members of the jury where you're currently employed?
Sure. I'm employed at Montessori Academy in Broward in Pembroke Pines, Florida.
And have you been employed with the Montessori School in one capacity or another since October of 26, 2018?
My wife and I started the school in 2002, and up until today, we're still involved in the school as director of the school. I'm the operations director of the school.
And back on October 26th of 2018, were you you and your wife the owner and operators of that school?
Yes, we were.
Okay. And the Montessori School, where's the specific address?
The address is 19200 Pines Boulevard, Pembroke Pines.
Okay. And you mentioned that's in the city of Miramar, correct?
Yes, I have.
So at some point in time, you provided video surveillance from your school to law enforcement, either 2018 or early 2019.
Yes, I have.
And how long is the system, how long does the video maintain until the system overrides naturally?
The system actually maintains a backup for 90 days and then overrides itself with the oldest of the events being erased.
Okay. So in order to preserve video surveillance, you would have had to capture it and preserve it within that 90-day window, correct?
Correct.
All right. And you've had an opportunity to review the video surveillance that was provided to law enforcement and then placed on a USB?
Correct.
All right. Your Honor, at this time, we're showing your counsel with pre-marked as states quadruple H, so HH. May I approach the witness?
You may.
It says, is this the USB you were able to review?
Yes, it is.
And how are you able to recognize this particular USB?
Well, it has my initials on the back.
Okay, and did you sign in and initial it after reviewing the video surveillance?
Yes, I have.
Is that video surveillance a fair and accurate representation of the video surveillance that was captured back on October 26th of 2018 from the Montessori School's video surveillance system?
Yes, it is.
And that video surveillance was maintained and kept by Montessori School until it was turned over to law enforcement?
Correct.
And it's routine for you to maintain that system? In fact, you still have a system to this day?
Correct.
Your Honor, at this time, the state would move into evidence what was pre-marked as state's quadruple H is the next number they exhibit, I believe, 82.
And we're going to object, Your Honor. We're double checking, although the sentence.
Excuse me, just come side. Reflecting the jury stepped out, counsel ran along with the defendant. You want to play the video now? Show counsel the video. I don't know how long is it. How long is it?
3:40 to approximately 5 a.m. We wouldn't be intending on publishing the entire thing for the jury. But just so it's clear, this was previously provided from the record to defense counsel. We just now at Sidebar learned that they had not been able to watch it and the file was corrupted. They had not told us or asked for an additional copy in any way, shape, or form.
Didn't we just take care of that Sidebar? Didn't I ask them that?
Yes, sir, but I'm making sure the record is clear on the state part on that. In addition, for the other images and things that she discussed in videos, those were from the phone, and those were available for defense. They were in my office on Friday afternoon. As to the things I said I would email, that was the PDF of all the photos that were published in open court on Thursday afternoon. Just so it's very clear.
Okay, I'm back here right now with trial attorney Janine Atamian and federal law attorney Gwen Marie Davis Hicks. Gwen Marie, I'll start with you. What an interesting morning, right? So we start off with all these arguments back and forth between the attorneys and the judge regarding Mr. Travion Glass. Then this witness comes on the stand for like 30 seconds and they have to go back and see what this video looks like. What do you think about what's happening?
It's a really important point in the trial right now. Before the state or prosecution rushes this case, they're trying to get everything in as much as possible. What I'll say is that from hearing the arguments back and forth, this is a really crucial ruling, however the judge decides on whether or not the witness should be able to testify. One of the things I thought was really interesting was that the state said that they couldn't find him. We didn't know where he was. We weren't even going to call him. The timing of it is that the defense actually subpoenaed him to come. And that's when, during deposition testimony, they found out that he's been listening to the trial. So he should have been sequestered. So the timing of it is interesting. And also what the state is saying is that, hey, the part that we're showing is that we have video anyway showing where he's sitting. So I'd be really interested to see how the judge rules on this. On this issue right here.
What should the judge do, Janine? Because it does become a question of whether or not this witness's testimony is going to change.
So I think that the judge should rule with the defense. You know, the defendant's rights trump this situation. We know that he's been watching it. I don't care if he can be impeached. I think that the most important thing, especially because this is a death penalty case, is that the defendant's rights are protected. I also want to say that the judge is visibly frustrated with the state. The state is very, very, very disorganized. And I think that that's, you know, going to kind of play into his rulings because everything is very last minute with them and they're very unprepared.
And this is not the first time this has happened, right? I mean, Gwen Marie, he took issue with the state a couple weeks ago with the discovery violation. And so that's problematic. On top of the fact, you know, the defense has really accused the prosecution of wrongdoing at other points. So what do you think about that?
Yeah, I mean, this is more of the same. It's true. This happened a couple of weeks ago, another issue, and the state is having wrongdoings. But maybe what the judge might rule is make it limited, the scope of the defense, of the witness's testimony, just limited to what happened with the vehicle and having the surveillance. That's their point. And that's an option. The judge might just limit testimony to that. So that's something that the judge may do. I'm curious to see, though, you know, what he does. But again, I would agree. They have been last minute on a lot of things, the state, and it is a death penalty case. So it's really important what happens here.
Stakes don't get higher than that. Let's take a break. When we come back, we'll see if we can jump live. Stay with us.
Jury's in adjournment. Ms. Liberty, did you get an opportunity to take a look at the
Yes, Your Honor, thank you.
video or review? All right, so is there any objection?
No objection, Your Honor.
All right, so we'll do this again in front of the jury. So bring the jury in, please.
Referencing is on the bench. I've already provided a copy to defense counsel. That's the Williams and the Locke cases. Right? Sorry. Right. WRIGHT.
Thank you. Jury entering. Thank you. Let the record once again reflect the presence. Please be seated. Let the record reflect the presence of the defendant, this counsel, this state attorney, ladies and gentlemen, jury, all members. Mr. Benitez remains on the stand. Counsel, you want to proceed?
The state will move into evidence what was pre-marked as HHHH is 82.
Is there any objection?
No objection, Your Honor.
It'll be admitted.
Nothing further.
Is there any cross-examination of this witness?
None.
Is he excused? Thank you, sir. You may step down. You're excused. Thank you. You going to publish a video? No? You going to call your next witness then? Who's your next witness?
Trevion Glass.
Why don't you come sidebar, please? Your next witness, please.
Trevion Glass.
Yes, good morning. Are you Mr. Glass? Are you Mr. Glass?
Sir.
Welcome. This is our witness stand over here. Why don't you come to the witness stand? What I'd like you to do is remain standing. Raise your right hand and be sworn.
Do you solemnly swear or affirm the testimony you should give in this case should be the truth, the whole truth, and nothing but the truth? Please state your full legal name for the record. Please spell your first and last name for the court reporter.
TREVEDON.
Thank you.
Please have a seat. Mr. Glass, that microphone in front of you will only adjust up or down. It doesn't move back and forth. All right, so if you could scoot up close to the microphone. All right, you ready to proceed, sir? Counsel, you may.
Thank you, Your Honor. Good morning, Mr. Glass.
Good morning.
And I know you're quite soft-spoken, so I'm going to need you to speak out a little louder, okay? And remember, you have to make oral responses, okay?
Yes.
How old are you?
23.
And where are you currently living? What city?
Real Beach.
And have you lived there all your life?
Majority of it.
Okay. You completed high school, or what was the last grade you completed?
11.
Right. You're not married, correct?
Excuse me?
You're not married?
No.
Okay. So I'm going to talk about some prior stuff before we get into why you're here today. Have you previously been convicted of a felony? Yes or no?
Yeah.
And how many times?
To my best of knowledge, once.
Okay. If I were to show you something, would that refresh your recollection?
Yeah.
A prior judgment? Your Honor, permission to approach the witness?
Show counsel first, please.
Yes. I'm going to ask you to just look at the document, don't say anything. Okay? Have you had an opportunity to review the document? You have to answer.
Yes.
Right? Is your memory fresh as to how many convictions you have?
2. Or was that 1? The other one? I'm not sure. Let's see, 2 charges.
All right. Now, you currently have some pending charges in Indian River County, correct?
Yeah.
And those are 2 charges?
Yeah.
Misdemeanor resisting without violence?
Yeah.
And in obstruction of service or execution of a search warrant?
Yeah.
Are those misdemeanors or felonies?
I'm not sure.
Okay. Do you know what the penalty you're facing on those charges?
No.
Okay. Have you been offered probation in that case?
Yeah.
And have you been made any promises in exchange for your testimony here today?
No.
Right. So let's go back to October 26th of 2018. What were you doing like for work?
I wasn't working at all.
All right. Were you involved in the music business at all?
Kind of, sort of.
And how so?
Making beats.
All right. And when you were making beats, were you working with a specific group or music group or people?
One person to be particular, but yeah, supposed to be in a group.
All right. Let's start by saying this. What group was it?
YNW.
All right. And when you said one person specifically, who was that person?
Julie.
Okay. And can you tell the members of Judy's real name?
Christopher Thomas.
And how long had you known Christopher Thomas, who you refer to as Judy?
Over a decade.
Okay. And this is back in October. And did you know somebody by the name of Anthony Williams who went by Sakchaser?
Yeah.
And how long had you known Sakchaser?
A couple years.
All right. Your Honor, permission to approach the witness with state 73.
It's in evidence, yes?
Yes.
You may proceed.
Again, I'm going to ask you to take a look at state's photograph number 4 and state 73. Do you recognize that person in the state's photograph with the label marking 18-3118?
I do.
And who is that?
Anthony Williams.
So, back on October 26, 2018, do you recall being at the New Era studio?
Yeah.
Who were you there with?
Few other people.
Okay. Was Juvy and Sack there?
Correct.
All right. And do you recall around what time you guys got to the studio?
I'm not sure when we arrived.
Okay.
I don't.
Was it light or dark outside?
I believe it was dark. I'm not sure.
All right. And what was the intention going to the studio?
I believe we were supposed to have a 12-hour session.
All right. And that's a 12-hour recording session, right?
Yeah.
And who was the artist that was recording that night?
Really, everybody was artists. And
All right. Did you guys end up staying for 12 hours?
nah,
Okay. What changed and why didn't you end up staying?
to the best of my knowledge, people were sleeping, so we ended up going home because, sleep in the studio.
All right. And part of that is because studio time is obviously, it's costly, right?
Objection to leave.
Stay.
Okay. You just said it was paid for. What was paid for?
Studio time.
All right. So you guys had prepaid for 12 hours.
Correct.
And obviously not utilizing that 12 hours, is that a waste?
Objection, Your Honor.
Stay.
Deleting.
I'll move on. How long, well, you said that people were sleeping. Who was sleeping?
Everybody but me, Anthony, and Chris.
All right. So who was upset that people were sleeping?
Objection, leading.
Who was upset overall?
There was no testimony that anybody was upset.
Okay, rephrase your question.
Was someone upset that people were sleeping?
I guess you could say that, yeah.
And who was that person?
Sad.
Okay. And how did SAC respond? How did SAC respond to people sleeping?
You woke them up and let them know it's time to go.
All right. And how did you do that?
Yeah, you went and woke them up, you shook them up.
All right. Was there an occasion where he threw water on some people to wake them up?
Objection, Your Honor.
Stay.
Your Honor, this is deliberate. Can we go
Excuse me.
sidebar, please?
Counsel, if you make an objection, make an objection. Don't be arguing in front of the jury. I told you that before.
I
all
understand.
right?
Can we go sidebar?
No speaking objections.
Can we
Come
go
sidebar. Sure.
Thank you.
Okay. So at some point, you just mentioned that you guys were getting ready to leave the studio.
Yeah.
Publishing states 72. I published image number 1 in state 72. Mr. Glass, can you see that photo on the screen in front of you?
Yes.
Okay. And who's that person?
The best of my knowledge, Moretti.
Okay. And the person I'm referring to, what is he wearing?
A jacket.
All right. Do you recognize the person on the other side of the photograph wearing what appears to be a black shirt?
I'm sort of.
If you do.
No, I don't.
Okay. Publishing image number 2. Do you recognize the individuals in that photograph?
2 of them, or 3 of them, yeah.
Okay, so what you can do is identify them by the clothing that they're wearing.
Juvy, black jacket in the left, sack in the middle, jean jacket, Tay, black jacket.
And Sack is he standing or sitting?
Sitting.
And Tay, is he standing or sitting?
Sitting.
And you said Cortlen was wearing the black jacket. Is he standing or sitting?
Who?
Oh, how did you refer to him? My apologies.
Tay.
No.
Or Juvy?
The person wearing the black jacket, who did you identify that as?
Juvy wearing black jacket. Also, is Tay wearing black jacket?
The person wearing the black jacket who's standing up, do you recognize that individual?
Chris.
Okay. Do you recognize the people in photograph image 3?
Same one you just showed. Same person.
And who's that person?
Yeah.
The 3 images that were just shown from State 72, do you recall when those photographs were taken?
Same night.
Would that be, what date would that be?
10/26.
Of 2018?
Yeah.
What location were those photographs taken in?
New Era Promotions studio.
Was that the studio we just discussed that you guys were hanging out at?
Yeah.
I'm now publishing State 7. Publishing 10/26/2018, beginning at timestamp 2/17/42. Mr. Glass, do you recognize the 2 individuals in this screen pause at 2/17/47?
Do I recognize the back of the head?
Yes, do you recognize them?
I just see it back of the head.
Okay, I'm going to continue to play. Do you recognize anyone at timestamp 2/17/52?
Still back of the head.
Do you see an individual standing next to a red vehicle?
Yeah, that's cool.
Okay, you just said that's who?
Cool.
All right. And what is Kobe's real name?
That's what I know him by. Cool.
All right. Would anything refresh your recollection as to his legal name?
I don't know.
If I were to show you your prior statement, would that refresh your recollection?
Could.
Permission to approach the witness?
Right.
Mr. Glass, if you could take a moment and look at this page, read it to yourself, do not read aloud, and look up when you're done. your memory been refreshed as to the legal name of Kobe?
Yes.
And what is Kobe's legal name?
Objection.
What's the objection?
Sorry, Your Honor, I was wrong.
Jacoby Mills.
Okay.
I'm sorry. Jacoby
And if you could repeat the last name for the court provisional.
Mills.
All right, I'm going to continue to publish date 7. There is a second individual at the red Mitsubishi vehicle. Do you recognize that second individual?
Not really, no.
Okay. How about the individual that is standing at the gray Jeep?
That's sad.
Okay. I'm going to continue to publish. I'm pausing at timestamp 2:18:21. Do you see that individual who's walking away from the Mitsubishi Jeep?
I see him, yeah.
Do you recognize him?
That's AD.
Okay. And again, I'm going to ask you for AD's legal name.
I know his last name, Davis.
Okay. Would looking at your statement refresh your recollection as to his legal name?
I guess so.
Honor, permission to approach.
Same statement?
Yes, Judge. Approaching the witness. Mr. Glass, same procedure. If you could take a look at that and look up.
We already know the name, Judge won't be the same.
No. Without speaking, has your memory been refreshed as to AD's legal name?
Yes.
Okay. What is AD's legal name?
Adrian Davis.
Continuing to publish, date 7. Mr. Glass, let me know if I need to rewind the video, but you had a chance to look at the face of the individual wearing what appears to be a white shirt and blue shorts?
It's me.
Okay. Continuing to publish. I'm pausing the video at 2:18:41. Do you see that individual carrying something across his shoulder, wearing what appears to be a blue jacket?
Say it again?
Do you see that person on the video?
I see the back of his head.
Do you see the back of the head of the person wearing the jeans jacket?
Correct.
Was that person the same person that you previously identified in state?
Sustain, rephrase it.
Okay. We previously looked in state 72 at an individual you identified as Melly.
Objection, Your
Sustain.
Honor.
One moment. Publishing state 72.
Asked and answered, Your Honor.
There's no question pending.
What's your question? Do you see the jacket in States 72, image number 3? The front of that jacket?
Yeah.
You see that jacket in States image 1 of State 72?
I see the same thing y'all see.
We spoke about this, Mr. Glass.
I'm standing that way.
You ask questions, right?
I'm asking questions, Mr. Glass, and I'm just asking you to respond if you have knowledge. Is that jacket that was in image number 1 and image number 3 the jacket that Melly was wearing on October 26th of 2018?
To the best of my knowledge.
To the best of your knowledge, yes or no?
Yes.
Publishing State 7. And then go. Oh. 17. Okay. Back to State 7, timestamp 2/18/41. The individual that's on screen wearing a jacket and it appears to be something across his back. Who is that individual?
Objection, ask and answer.
Overruled.
Mr. Glass, you can respond.
I see the same person as last time.
Okay, and can you tell us who that same person is?
No.
Continuing to publish.
Ask the questions y'all know the answers to.
Mr. Glass, you can't speak when there's not a question. Mr. Glass, do you see that individual carrying something in their left hand? I'm asking if you see them, just if you see them.
Yes.
Do you recognize that person?
Of course.
Okay, and who is that person?
Chris Thomas.
Mr. Glass, can you identify for the record, and I know there's a video, but can you identify which vehicle you got into?
Red Mitsubishi.
And can you tell us who was in that car with you?
Kobe, Tay, and 80.
So 80, Tay, and Cody. Is that a yes?
Yes.
So that is a total of 4 people?
Correct.
And in the vehicle to the left of the screen, the Jeep, who entered that vehicle to your knowledge?
Everybody else that was there. Zach, Melly, Juvy, Cortlen.
Okay. And by my count, is that also 4 people?
Correct.
Right? And when those, okay. Continuing to publish at 2/19/36. I'm going to stop at 2/19/46. At the time you left the seat in that red Mitsubishi, where were you headed?
Supposed to be home.
Okay, and who's home?
It's Melly house.
Okay, and was everybody in that red car headed to Melly's house?
To the best of my knowledge.
Okay, and What about the Jeep? Where was your understanding that that Jeep was headed? The gray Jeep?
Same spot.
So both cars left the studio with the intention of heading to what you identify as Melly's house.
Correct.
Can you tell us, I guess, what was the mood or the vibe at the studio while you guys were there?
5 years ago. Can't tell you nothing right now.
Okay, if you don't recall, that's fine. Was there any physical confrontation that you observed at the studio?
It was like a regular day. Just studio, smoke and drink.
Right. And you just mentioned smoking. What were you smoking, specifically you?
Weed.
Okay. All right. And now the vehicles, we saw that the gray vehicle on the video pulled off first. Can you tell us where you guys, the route you guys took to the best of your knowledge?
I can't tell you because I don't know.
Okay. Do you recall getting on a highway at all?
I recall being in the car while I was driving. I don't know where. I don't know. I don't.
Okay. Were you awake the entire time you were in that vehicle?
I wasn't.
Okay. Do you know at what point you fell asleep?
I don't.
All right. And when you left the studio, you were awake. Is that a fair statement?
I was.
And at what point do you recall waking up, or what time do you recall the next thing you saw?
Once we came to a stop.
All right. And where did you come to a stop?
At the house gate.
And the house gate for Melly's house?
Yeah.
When you got to the house gate at Melly's house, who was inside your vehicle, the red Mitsubishi?
Same people you've seen get in the car.
All right. So by your testimony, Kobe, AD, Tay, and yourself.
Yes.
Okay. So still 4 people.
Still 4 people.
Do you recall how you guys entered the gate?
The gate was open for us.
And publishing states 47. I'm going to pause it at timestamp 3:49, it looks like 58. Do you recognize that red Jeep? Mitsubishi?
I do.
Is that the vehicle that you left the studio in?
Yes.
And is this the guard gate you just testified to at Melly's house?
Yes.
Okay. And do you see that screenshot at timestamp 3:51:31?
Mm-hmm.
Is that a yes?
Yes.
Okay. Do you see yourself inside that red Mitsubishi vehicle?
Yes.
And where are you located? Okay. And do you recall going through the gate, going through the procedure of going through the gate?
Mm-hmm. Yes.
So you get through the gate, where do you go next?
To the house.
All right. And can you tell us, you pull into the house, is there a driveway in the house, in front of the house?
Yeah.
Okay. Are there any other cars parked in that driveway when you get to the house?
No.
All right. Do you see the gray Jeep that you left the studio with at the house?
No.
right? So what do you do when you get out of the vehicle?
From what I remember, I went upstairs and went to sleep.
Okay, and you said upstairs. So the house is how many stories?
Couple.
Okay, so you went upstairs to where specifically to sleep?
In Juvy's room?
Right. Was Juvy in his room?
Nah.
Okay. Do you recall where Melly's room was in the house?
Not upstairs.
Okay. Do you recall where it was if it was not upstairs?
I think it was like first rooms when you come in the house.
Okay. Was Melly at the house when you got there, from what you can recall?
No.
Did you see Melly at any time in the house?
No.
Right. So you go upstairs in Juvy's room, and what do you do?
Crash.
All right. Crash meaning?
Go to sleep.
Okay. At some point, do you wake up?
Yeah.
And why?
Phone calls.
Okay. Safe to say that your phone was getting a lot of phone calls, blowing up.
Yeah.
All right. And at some point, you answer the phone, correct?
Yeah.
Okay. What do you do in response to the phone calls?
I answered the one that kept ringing, and yeah.
All right. And so what do you do in response to getting that phone call?
I ended up at the hospital.
All right. Do you recall which hospital that was?
No, I don't.
Do you recall what city you were in at this point?
I was in Broward.
All right. What city? Not the county.
Miramar.
Okay. Do you know if you went to Miramar Hospital?
I don't know what hospital it was.
Okay. So you get to the hospital. What do you find out when you get to the hospital?
That Anthony and Christopher was deceased.
Okay. And obviously at that, well, let me not say obviously, but at that point in time, what do you do? Or how do you react to that news?
Grieving.
Okay. Do you stay at the hospital?
Not long.
Right. Where do you go after the hospital?
I ended up somewhere. Somebody's house.
All right. Do you recall whose house that was?
I don't know whose house it was, but I ended up there.
All right. Let's start with the city. Do you recall what city that house was in?
Miramar.
All right. Do you recall if it was in the same or different area than where Melly's house was?
It looked similar.
Okay. And just to clarify, was it the same or different house than Melly's house?
Different.
Okay. Where did you go when you went to that house?
What you mean?
Like, where in the house did you go? So you go to the house. Where do you go?
I went inside the house. I was in the back.
Okay. And would your statement refresh your recollection as to whose house you were at?
Maybe.
Your Honor, permission to approach. I'm going to show defense counsel the same statement. Page 4.
Same procedure, Mr. Glass. If you could just review page 4.
See nothing about the house.
If you could just read the entire page, and when you're done, let me know.
finished reading that page?
Yeah.
Is your memory good fresh as to whose house you were at?
Still don't see nothing about no house in there.
Okay. I'm going to now show you what's in evidence in state 62. Do you recognize the individuals in state 62?
Yeah, I do.
Okay. Who are those individuals?
Melly and another dude, Fredo.
Okay. You said Melly and another dude, Frito?
Yeah.
Do you know Frito's name and or any nicknames?
That's all I know about him.
Frito?
Do you recall ever going to Frito's house?
Just that time.
And just that time being what time?
After I left the hospital.
Okay. So this. And for the record, what is Frito wearing in the photograph?
A shirt. White shirt.
Okay. So after the hospital, you went to Frito's house.
To the best of my knowledge.
Okay. And what were you doing at the house?
Still grieving.
Okay. Who took you to the hospital?
The cameraman.
Okay, do you recall his name?
Drew.
Right. And do you recall who took you from the hospital to Frito's house?
Same person.
All right. And before you left for the hospital, or actually, who went to the hospital with you and Drew?
Just Drew.
Okay. Who was at the house, Melly's house, before you left for the hospital?
Same people that was there when we got there.
Okay. And same people being the 4 people that entered the Mitsubishi?
Yes.
Okay. So you're at Frito's house. You mentioned, and I forgot exactly where you were in the house. Did you say where you were?
Drew was wrong.
Oh, no, not Melly's house. Frito's house. Where were you in Frito's house?
Outside.
Okay. And who was at Frito's house when you first got there?
Everybody that was in the house.
Okay. And it's because I don't know who everybody was or is. Can you please specify?
Kobe, Melly. I'm on people I can remember.
Okay. Was that the first time you saw Melly after you guys left the studio?
Yeah.
Was Melly wearing the same clothes or different clothes than when you saw him at the studio?
It was a new day. Nah, he wasn't.
Nah, he wasn't. You guys
He wasn't wearing the same clothes.
Okay. Do you recall what he was wearing?
Just had on some shorts.
And how long did you stay at Frito Bain's house?
I don't know.
Right. Minutes, hours, days?
Could be minutes, could be hours.
Okay. So not days?
Not even a day.
Okay. And so when you got to Frito's house, was it light or dark outside?
It's light.
And you previously said yourself and Melly and someone else was at Frito's house. Was Frito there as well?
I think I did see him. I don't remember.
Okay. What happens while you're there? Like you're there, you're outside, what happens?
Grieving.
Okay. And you're grieving, are you grieving alone?
Yes.
Are you at the house at any point in time? Do more people come to the house or do people leave the house?
If they did come, I don't know. I was in the back.
Okay.
I was back there breathing.
At any point in time, did Melly leave Frito's house?
It came to the point when I was there by myself.
All right. So you were there by yourself. So the people that you previously said were there were no longer there, correct?
Right.
And so do you know where they went during that time?
I don't.
All right. And we're still talking about October 26th of 2018, correct?
Yes.
And this would be shortly after the hospital?
Yes.
All right. At some point, does Melly come back to Frito's house?
Around this time, I'm still grieving and getting a little, I don't know, yeah, I guess.
Yeah, I guess Melly comes back.
Yeah, I guess they did come back.
Right?
I don't know. I'm not sure.
Okay. And at some point, does Melly leave again? A second time?
I don't remember anything farther after that.
All right.
Me grieving. That was the last thing I remember was me grieving. Not even in Gifford.
All right. So before you end up in Griffin, if I were to show you a statement, would that refresh your recollection as to Melly leaving and coming back a second time?
I suppose so.
Under permission to show him his statement again?
Yes, Counsel.
Mr. Glass, I'm going to give you page 5 and page 6. If you can take a look, you can start in the middle and review those pages and look up when you're done.
Are you done? Is that a yes?
Yes.
Did that refresh your recollection?
Somewhat.
Okay, so tell us what you somewhat remember.
I just did.
If you recall, you said you weren't sure, you went to Gifford, and then I asked you if your statement would refresh your recollection. Does your statement refresh your recollection as to whether Melly left again?
I'm not sure if they left. I was grieving.
Okay.
I'm not sure what nobody did. I was grieving.
All right. You mentioned, well, not you mentioned, let's see. I pointed out to you someone was, the person that was wearing the jacket that you identified as Melly was carrying something across his side or his back on the video. Do you recall seeing that?
Yes.
Okay. Do you recall what that's referred to?
Possession.
Okay. Can it also be commonly referred to?
Objection.
Sustained.
Are you familiar with the term man?
Objection.
Watch from sidebar.
Did you see that satchel again after you left the studio? Do you know what was in that satchel?
I don't.
Okay. Do you recall seeing anyone else with a satchel that night at the studio?
It was 5 years ago. I don't recall.
Okay. Is there anything that can refresh your recollection as to whether or not anybody else was wearing a satchel?
I suppose so.
If I were to show you the video again, would that refresh your recollection?
I suppose so.
Publishing Suite 7. I'm going to start publishing state 7 at 2:19:01. And I'm going to pause at 2:19:13. Does the video refresh your recollection as to anyone else that was carrying a satchel?
Yes.
Who, if anyone, was carrying a satchel?
I see Chris for one.
And that's Christopher Thomas.
Yes.
Did you ever have any business relationship with the person I refer to as Track?
No.
Okay. Do you know who Track is?
Not really.
Not really, or
I don't know who he is at all.
do you know of him?
Yeah.
Okay. Did you see Track on October 26, 2018 at any point?
No.
Do you recall giving a statement, specifically the statement that I've previously provided you with here today, to the detectives in this case? You have to answer out loud.
Yes.
That was a statement that you gave to Detective Moretti and another detective, I believe from Indian River. Is that correct?
Could be.
Do you recall in that statement giving a different response when asked?
Stay.
Would showing you that statement refresh your recollection as to anything regarding your interactions with Track on October 26, 2018?
I don't know Track.
No. My question was, would showing you the statement refresh your recollection as to any time you saw Track on October 26 of 2018?
No.
Okay. One moment. You said you ended up back in Gifford at some point in time on October 26th of 2018?
Yes.
And do you recall where Melly was at the time you went to Gifford?
I don't remember.
Was at some point at Frito's house, do you guys all leave, meaning you, yourself, everyone that you previously identified was there?
Objection, I don't recall.
You don't recall leaving?
I don't recall leaving with anyone. I don't know when I left. I don't know how I left.
Okay. Just to clarify my question, so you mentioned you left. When you left for Gifford, was anyone else at Frito's house?
I don't know.
Do you recall Melly making any statements in your presence while you were at Frito's house?
No recall.
Would showing you your statement refresh your recollection as to anything Melly told you while you were there?
No recall being told anything, so no.
Okay. You mentioned when they left the first time, you recall them at least leaving one time. Did you recall if when they came back there were any statements regarding where they went?
Sustained.
No,
Sustained objection.
don't answer that. So you remember them leaving the house at least once, correct?
Yes.
All right. Now, when they came back, do you recall any conversations that Melly had in your presence that first time, after the first time?
I don't recall.
Would show you your statement, refresh your recollection as to those statements.
No, really.
All right. Did you have a Facebook page back in October 26th of 2018?
I believe so.
On approaching counsel, what's been pre-marked is states quadruple I. Previously shown. Wish to write the witness?
You may.
Mr. Glass, do you recognize these two pages that I'm showing to you?
Yes, sir.
And is this a Facebook, these statements reflect a Facebook conversation?
They do.
Is this a fair and accurate representation of that conversation that you had on Facebook?
It is.
Right. Your Honor, at this time, the state would move to introduce what's been pre-marked to state quadruple I as the next numbered exhibit.
No objection.
I'm sorry?
No objection, Your Honor.
It will be admitted.
States quadruple I will be marked states 83.
Permission to publish?
You may.
Mr. Glass, can you see that document in front of you?
Yes.
All right. Where it says author, can you read that for the members of the jury?
You want me to read it?
If you can read that, what does it say next to author?
Fargo.
What does it say before Fargo?
Fetty Fargo.
Okay, do you see where it says Fetty Fargo?
Let's see.
Okay, and who's Fetty Fargo?
It was me.
Okay, so was that your was that a, how you identified yourself on Facebook?
Kind of, sort of.
And who were you having this conversation with?
Right now, I look like I'm talking to myself. I
Okay.
look like I'm texting myself. I don't know who I sent it to.
Do you see where it says participants?
Okay. So, Chasing Melly.
Okay. And that was page 1. I'm going to now publish page 2. I'll publish it in part since it's a little small. Can you see that in front of you?
Mm-hmm. Yes.
Great. I'm going to scroll up. What was the purpose of you having this conversation with Melly, Jamell Demons?
I don't know. Just everything was questioned.
When you got to Gifford, were you looking for answers?
Not just me.
Okay. Were people kind of pressing you for answers?
Correct.
And did that have any impact in whether or not you reached out to Melly?
know what you mean by that.
So, and again, you said that people are looking for answers. So did you reach out to Melly looking for answers?
I did.
Is that the gist of that conversation on Facebook?
Is that just the
The
conversation?
gist of the conversation, was that the purpose behind the conversation and the general conversation that you had with him?
Yes.
Random moments to confer. Do you know who Jamie King is?
I don't know who she is. I know of.
Okay, you know of Jamie King. Do you know how she's related to Jamell Demons?
Objection leading.
Sustained.
Do you know her relationship?
Mom. It's supposed to be his mom.
Okay. Do you know if Jamie King and Anthony Williams had any?
Objection leading.
I wouldn't know none of that.
Rephrase your question.
Do you know the relationship between Jamie King and Anthony Williams?
I don't.
If I were to show you a copy of your statement, would that refresh your recollection?
Nope.
And one moment to confirm. Nothing further at this time.
Counsel, thank you. Is there any cross-examination this week?
Yes, sir. Morning, ladies and gentlemen. Good morning. Good morning, Mr. Glass. Your Honor, would you mind if we move the monitor from in front of the witness's face?
I don't mind. I mean, I mind.
Would you mind, Your Honor?
I don't mind. Is there a specific issue that you have, Mr.
I do. I do.
Judge, can
So,
we approach sidebar?
sure. Ladies and gentlemen, why don't you step out for a second? Don't discuss the case. Don't form any opinion about the case. Don't allow anyone to discuss the case for your present certain no research. Counsel Mann, along with the defendant, and the assistant state attorneys. So, Mr. Glass, I don't understand. What's the issue?
On this side of my face and show whenever the scene. Because I'm blind in my left eye, I'm trying not to.
So you don't see out of your left side?
Correct.
Left eye?
Correct.
So my thought is, let's try this. Can we, Gary, can you do me a favor? Just move the monitor for a second.
Just move it out of the way.
Can you do that?
I could do that too. But if I, as far as this goes,
No, I'm not asking you to detach it. How much do you put it down?
that's just here.
All right. So, Mr. Glass, is that all right?
Just your courthouse.
Okay. So we can proceed like that. I think that works for everybody. So they show you pictures and things like that. You have to be able to see the monitor too. You understand, Mr. Glass? All right. We ready to proceed?
Yes.
All right. Bring the jury back in. See if they're ready. in recess. Mr. Demons, you need a rest for break? No? We're in recess.
And do you recall who took you from the hospital to Frito's house?
Same person.
All right. And before you left for the hospital, or actually, who went to the hospital with you?
Just true.
Okay. Who was at the house, Melly's house, before you left for the hospital?
Same people that was there when we got there.
Okay. And same people being the 4 people that entered the Mitsubishi?
Yes.
Okay. So you're at Frito's house. You mentioned, and I forgot exactly where you were in the house. Did you say where you were?
Juvy's room.
Oh, no, not Melly's house. Frito's house. Where were you in Frito's house?
Outside.
Okay. And who was at Frito's house when you first got there?
Everybody that was in the house.
Okay, and it's because I don't know who everybody was or is, can you please specify?
Kobe, Melly. I'm on people I can remember.
Okay. Was that the first time you saw Melly after you guys left the studio?
Yeah.
Was Melly wearing the same clothes or different clothes than when you saw him at the studio?
It was a new day. Nah, he wasn't.
Nah, he wasn't. You guys
He wasn't wearing the same clothes.
Okay. Do you recall what he was wearing?
Just had on some shorts.
Okay. And how long did you stay at Frito Bain's house?
I don't know.
All right. Minutes, hours, days?
Could be minutes, could be hours.
Okay. So not days?
Not even a day.
Okay. And so when you got to Frito's house, was it light or dark outside?
It's light.
And you previously said yourself and Melly and someone else was at Frito's house. Was Frito there as well?
I think I did see him. I don't remember.
Okay. What happens while you're there? Like you're there, you're outside, what happens?
Grieving.
Okay. And you're grieving, are you grieving alone?
Yes.
Are you at the house, at any point in time, do more people come to the house or do people leave the house?
If they did come, I don't know. I was in the back.
Okay.
I was back there grieving.
At any point in time, did Melly leave Frito's house?
It came.
Okay, so Janine, now you're hearing how he found out that they were both killed. He was grieving, talking about where he was at. What are you taking away from this?
And he's also talking about how Melly wasn't wearing the same clothes, which kind of seems odd to me because, I think that once you hear that your friend's been shot, he goes over to the hospital with, I forget what guy took him, and you would think that Melly would not be changing his clothes and stuff, but I thought that was interesting. I think it's a really cumbersome testimony, though. He really is uncooperative, and he really kind of gives these really one-word answers. He's annoyed, and I really think that it's hard testimony to get through.
Well, let's actually take a break, and I'm curious to see if he says he had any other interactions with YNW Melly or Cortlen Henry after this took place. So stay with us, and we'll see more of his testimony on the other side.
So the record is clear. It appears that Mr. Glass was reading something from his phone and as Your Honor walked in, talking to someone on the phone. So I would ask the court to inquire as to what he's reading and who he's speaking to while he's on the witness stand.
Judge, I think the only individual who would not be allowed to speak with would be myself and Ms. Smith. So I think that should be the extent of the inquiry.
Thank you.
Mr. Glass? All right, you're looking at me now. All right, thank you. I wasn't here. I left the office, left the bench, we're in recess, came back in, and counsel suggested to me that you're on the phone and you read something and you're discussing something on the phone. Is that true?
It's true.
Yes, so did it have anything to do with this case?
Not at all.
So was it some other business or?
Supposed to be texting. So.
You were texting? Yeah. Were you texting about the case?
About it.
What were you texting?
Texting saying that this wild, shit wild. That's all I said.
I didn't hear you.
I said things are wild. That's all I said.
Things are wild.
It's wild.
Anything else?
That's it.
And did you have a conversation with someone?
My brother called me and he was concerned, that's all.
Concerned? Yeah. Concerned about what? Did he say?
Concerned about who I'm here with and how I got here.
Okay. And anything about the case, facts of the case, your testimony, anything like that?
No.
Thank you. All right, so are you ready to proceed?
Yes, Your Honor.
Stay ready to proceed?
Yes, sir.
All right, can we proceed? The jury's ready?
Yes, sir.
I'm trying to rush you. I'm just trying to get an idea. I know you haven't started. Jury entry?
Thank you.
That's all I'm asking.
Thank you very much.
Ladies and gentlemen, thank you. Please be seated. Let the record once again reflect the presence of the defendant, Mr. Demons, his counsel, and assistant attorneys. Ladies and gentlemen, the jury, and all witness, Mr. Glass remains on the stand. Counsel, this is your opportunity for cross-examination. If you're ready, you may proceed.
Thank you, Your Honor. Morning, Mr. Glass. Morning, sir. I wanted to show you what the state admitted as States 83. You just took a peek at this and identified the participants as being you. You thought it looked like you were talking to yourself because you were the only one typing. There were no responses, at least on the first page, correct?
Objection to counsel testimony.
Sustained.
There are no responses to this, to your text on this first page.
No.
On the second page, the state was discussing that essentially you were inquiring of Mr. Demons Melly what had gone on because you were trying to get information, right?
Yeah.
And you see a conversation here where you get a response. want to direct your attention to that statement. It says, I show them niggas more love than their parents. Right? You see that?
I see it, bro.
Okay. Thank you. And the next statement by the next message in sequence is again from Melly, and it says TF. What does that mean?
You tell me.
Okay. What does that mean?
I don't know.
Okay. So you were having a conversation and you didn't understand the response?
I don't know what TF means.
Okay. You didn't understand that response. Correct?
Just said it.
Okay. And then there's another one that says, man, tell them fuck that. If they think I did some shit like that, we can go to war. Nigga, you know I would never do nothing like that. See that?
I see it.
Okay. So, statement mentioned that you got arrested recently and charged criminally. Correct?
Correct.
And on May 30th, not too long ago, of this year.
Yeah.
And one of the charges that was made against you was obstruction of the service of the execution of a search warrant. You're aware of that?
I am now.
Pardon me?
I am now.
Okay. So you got charged and you had no idea what you were charged with?
Correct.
Okay. And you are now out on pretrial release?
I bonded out, sir.
Okay. And while you were on bond, you are of the opinion that if you don't come here,
I'll be in jail.
Objection, Your Honor, apology.
That's the only reason I am.
Excuse me. What happens is when they make an objection, just wait before you answer. Objection, no, it's overruled. Proceed.
That's
you're of the impression that if you don't come here and sit in that chair and testify, you're going to go to jail.
correct.
Okay. There are several instances in which Ms. Smith, prosecutor, that questioned you, showed you a statement that you previously gave. Remember that?
Yes.
And you told us you remember seeing me in a deposition not too long ago.
I said what?
You remember seeing me last week on Friday?
Yeah, I remember.
Okay. And you recalled at the time that your statement to the detectives was a few days after the incident.
You say, do I recall?
That's what your recollection was at the time?
Yes.
A couple of days after?
A couple of days after.
And now after seeing the statement, you realize that it was 4 months later, right?
You say what?
The statement you gave to police. That you're
telling me it was 4 months?
It was 4 months ago. Pardon me?
You telling me or asking me?
I'm asking.
That don't make sense. For you to ask me if I'm told you it was 3 to 4 days after they died, why are you asking me if it was 4 months if I just told you?
Okay. So, in the statement that you gave to police back then, you claimed that you had gotten into the red vehicle in the rear seat, right?
It's 5 years ago. To the best of my knowledge, yeah, that's what I said.
You're saying the statement was a few days after, right?
What did you tell?
The statement that you gave to the police was a few days after the incident?
Yes.
And you said then that you had gotten into the rear of the red vehicle?
To the best of my knowledge, yes.
Okay. And then you watched this trial unfold on TV over the last couple of weeks, right? You didn't watch any of this
I
trial?
watched it, but I didn't watch it unfold or whatever you're trying to say.
Okay. You watched this on TV, this trial?
On my phone.
Okay. And you saw a video of yourself get into the red vehicle, right?
Correct.
And you learned that the statement that you gave a few days after the incident was wrong.
Because I said I was in the back and I was in the front.
Yes, exactly that.
That piece.
Yes, that piece.
Yeah, okay, yeah.
Okay, so your recollection had begun to fail you only a few days after the incident,
Objection.
as regards that issue, at least.
Objection to counsel testifying, Audrey.
You forgot where you sat in the vehicle a few days after.
Objection to counsel testifying.
Overruled.
We can answer
Answer what?
that question. Is that correct,
Did
sir?
I forget?
Did you
Or
forget?
did I have made a mistake and say I was in the back and remember that I was in the front?
So when you told the law enforcement officers that you had gotten into the back of the vehicle a few days after the incident,
That's what I thought, to the best of my knowledge.
that's what you thought? Okay. And when you got to Melly's house that morning, you had a key?
Did you have a key?
No, I didn't. Did you?
No, I didn't.
Who had a key?
I don't know.
You know of anybody having a key to Melly's house?
I don't know.
Okay. But you did gain entrance to that house that morning when you were leaving after you left the studio.
Yeah.
Okay. And then you said you just went and crashed and went to sleep in Juvy's room. Right?
Factual.
Okay. And you were awakened by your friend Drew.
I did not say that.
Were you awakened by your friend Drew?
I said I was waiting by phone calls.
Okay. On February 26th of 2019, when you actually gave your statement to law enforcement, do you recall this question and this answer?
Objection to improper impeachment.
Sustained.
On that day, you told the police that Drew woke you up.
Objection to improper impeachment.
Sustained.
I don't recall.
Excuse me, I sustain the objection.
Okay. On your Honor, may we approach?
Sure.
Did you ever make a statement differently where you claimed that you were awakened by Drew.
Objection, counsel testifying to proper impeachment.
Overruled. Do you understand the question, sir?
I don't even remember getting asked a question.
All right, restate your question.
Did you ever make a statement to the police?
I don't recall.
Okay. Do you recall now being asked this question and giving this answer?
Objection to improper impeachment.
Overruled.
Question by the detective then. And so when you first saw Drew, when did you see him? Where did you see him at? Your house or Fredo's house? Answer, at the house in Miramar. At Melly's house. Okay. He woke me up. It was like, come to the hospital. You said that.
I don't recall.
Don't recall. Okay. When we spoke to you last week, you said you were awakened by phone calls from Christopher Thomas's mom, right?
Plenty of phone calls.
And, pardon me?
Different people.
Different people. And the one that you answered was Ricky? So you were awakened by a phone call from Ricky?
To the best of my knowledge.
Okay. So as you recall it today, Ricky is the one that woke you up with phone calls, not Drew that woke you up in person.
Correct.
Okay. So you smoke a lot of marijuana, right?
Possibly.
Well, you smoke it anytime you get a chance, I think is how you phrase it.
It's your answer, yeah.
That was your answer.
I smoke when I smoke.
You smoke when you smoke?
Yeah.
And when's that?
When I smoke.
And when would that be?
When I smoke.
How many times a day?
Objection to asked and answered.
Overruled.
Twice, 3 times, maybe.
Okay. And on the night before you got to the studio, on the day in question, you had smoked at least 2 joints, right?
I sure guess.
That's what you said, right?
I don't recall.
Okay. And when you got to the studio, you were smoking, correct?
Possibly.
Were you or weren't you?
It was 5 years ago.
You forget?
I don't recall.
Okay. And you were drinking Hennessy, I believe? Or do you not recall that either?
It's possible.
Possible. But you don't recall?
I don't.
Okay. So you don't recall much from that night, then, do you? Right? Fair?
Right.
Okay. And when you got in the red vehicle and left, you went to sleep in the vehicle when you left the studio. Right?
Yeah.
And you didn't wake up until you got to the guard gate.
I woke up when we came to a stop.
You did not wake up until you got to the guard gate. Am I right or wrong?
I woke up when we came to a stop.
Okay,
Which was at the guard gate, yes.
Okay. One moment. With respect to your daily, right? You've never seen Melly with a gun.
Objection, Your Honor.
Sustained.
Move to strike.
Here's this your last question.
Have you ever seen Melly with a gun?
Objection, Your
I
Honor.
sustain the objection.
Have you ever seen him track with a gun?
Possibly. Yes. Maybe. Maybe so.
Okay. You don't know of any friction between Melly and Anthony Davis at any time, Anthony Williams at any time?
Not that I know of.
And you don't know of any friction between Melly and Christopher Thomas at any time?
Not that I know of.
And you don't know of any friction that occurred at the studio that night that would cause anybody to get murdered?
Objection, Your Honor. Call for speculation.
You didn't see any friction at the studio that night of any magnitude?
I didn't.
You did?
I didn't.
Okay, you did. With respect to your daily marijuana regimen, did you smoke before you came here today?
I did not.
Okay. I have nothing. Thank you.
I should have.
Counsel, is there any rebuttal?
One moment, Your Honor.
Thanks, Dan.
Mr. Glass, did you live in Broward County back in October of 2018?
I did not live here.
Okay. When did you come in relation to this incident to Broward County?
I was picked up probably, I don't know, I was picked up on the weekend or something like that.
So how would you, I guess, date how long you were here prior to the incident? Time frame.
3 days, 2 days?
Okay. So you were not a full-time resident of Melly's residence?
I was not.
Okay. Nothing further.
Is this witness excused?
Yes, Your Honor.
Thank you, sir. You may step down. You are excused. Mr. Box, ladies and gentlemen, why don't we take our lunch and recess now? It looks like it's over after 12. Remember the admonition, do not discuss the case, don't form any opinion about the case, don't allow anyone to discuss the case in your presence. And certainly no research. We'll see everybody back at, let's say, 1:30. All right? Thank you, ladies and gentlemen. Keep your heads on the chairs. Thank you. Let the record reflect the jury stepped down. Counsel remain along with the defendant. Anything to discuss, counsel? Thank you. We're on
Do you see where it says participants?
Okay. So, checks and Melly.
Okay. And that was page 1. I'm going to now publish page 2. I'll publish it in part since it's a little small. Can you see that in front of you?
Mm-hmm. Yes.
Great. I'm going to scroll up. What was the purpose of you having this conversation with Melly, Jamell Demons?
I don't know. Just everything was questionable.
When you got to Gifford, were you looking for answers?
Not just me.
Okay. Were people kind of pressing you for answers?
Correct.
And did that have any impact in whether or not you reached out to Melly?
I don't know what you mean by that.
So And again, you said that people are looking for answers. So did you reach out to Melly looking for answers?
I did.
Is that the gist of that conversation on Facebook?
Is that just the
The
conversation?
gist of the conversation, was that the purpose behind the conversation and the general conversation that you had with him?
Yes.
Random moments to confer. Do you know who Jamie King is?
I don't know who she is. I know both.
Okay, you know of Jamie King. Do you know how she's related to Jamell Demons?
Objection leading.
Sustained.
Do you know her relationship?
Mom. It's supposed to be his mom.
Okay. Do you know if Jamie King and Anthony Williams had any?
Objection leading.
I wouldn't know none of that.
Rephrase your question.
Do you know the relationship between Jamie King and Anthony Williams?
I don't.
If I were to show you a copy of your statement, would that refresh your recollection?
Nope.
And one moment, sir.
Well, no, that was not a Dell computer screen that was testifying. That was a very important witness, Travion Glass. He left with everyone that night from the recording studio. He was in the red Mitsubishi. He's a very smart witness. The prosecution, as you can tell, is having a lot of problems. When he was asked whether or not he remembered anything, he said he didn't. When he was asked whether or not his statement would refresh his recollection, he said it won't, which means the prosecutor couldn't present it to him. So on the other side of here, though, we are going to have some much more important discussion of this with our own Anjanette Levy, who will be hosting an hour question and answer, if not more, while the jury is at lunch. Stay tuned. All your questions, submit them to Law&Crime, and we'll be back after this break.
Good afternoon and happy Monday. Thanks for joining us here on Law and Crime. I'm Anjanette Levy, and I'm going to be with you for the next hour as we take your questions during the double murder trial of YNW Melly. The Broward County Courthouse, of course, was dark last week, but the trial for the Murder on My Mind rapper is back in full swing, and we believe the state is wrapping up its case in which they claim 24-year-old Jamell Demons, who we all know as Melly, shot and killed his two friends from inside a vehicle back in October of 2018. Demons and his co-defendant, Cortlen Henry, have a different story, saying that they were the victims of a hit and run. Fellow rappers Anthony Sakchaser Williams and Christopher Juvy Thomas lost their lives that day, and soon it will be up to the jury to decide how that happened. But for now, I'm here with a great panel. Terry Austin is down there in Broward County at the courthouse covering the trial. Law&Crime's Linda Kenny-Bodden is here with me as well. She's also a criminal defense attorney, a famed criminal defense attorney. And with me is civil rights attorney Tyler Bailey in South Carolina. So thanks everybody for being here. Terry, let's start with you. I want you to tell us what's been going on in the courtroom today, as we've heard from Travion Glass, who's really a very important witness because he's one of the only witnesses, really the only witness we've heard from who was there that night.
That's right, Anjanette. He's critical because he was there at the scene, and he is the first witness to testify about what he saw that night. Now, there was a deposition that he did just last week. He's back here on the stand, and we've already had his direct and his cross-examination. It's very interesting. He did say he did not want to be here. The only reason he is here is because he is afraid he is going to get arrested and charged if he did not appear, because he has some other outstanding charges pending, and so he had to appear. And he also has a bit of an attitude, I must say, with all parties, both the prosecution and the state and even the judge. So ultimately he got up on that stand and he did testify. He said, and he confirmed who was in each of those cars. You know, obviously there's the gray car, the gray Jeep, and then there's a red Mitsubishi, and he confirmed the 4 individuals in each of those cars. So we knew that from looking at the video. He looked at the video, the still shots, and he confirmed the individuals who were in all of those cars.
And he also talked about how it sounded like the plan was that night for everybody to go back to the apartment complex where they all lived. It sounds like he and his friends in the red Mitsubishi did that, but the Jeep didn't.
That's right. He said he went back and he went to Melly's place and he fell asleep. He was exhausted. That's why they left the studio, because they were sleeping and you have to pay for studio time. Sack wanted everybody to get up and get out because they were actually not doing any work, and it was, you know, senseless to be there without paying. So they all left. And he did say that he went back to Melly's house, he fell asleep, and then ultimately he did get this phone call that said, you know, something had happened, and he confirmed that, you know, Sack and Juvy had deceased, that had been killed. And so he went to the hospital, then he, you know, later, you know, left the hospital. So he's definitely confirming everything that happened that night. He also said he went to, I think it's Fredo Bang's house, and a bunch of people came into that house as well. So there was a lot of chaos and confusion. He didn't know exactly when Melly came and left. One thing he did say, I will say, is that when Melly came back at one point, he had different clothing on. So I think that was a critical piece of information as well.
Yeah, I'm sure that's something that the prosecution will hone in on, because they're going to say, why were you changing your clothes in the middle of the night after your two friends were murdered? So it'll be interesting to see how they wrap this up, again, with the lead detective, Moretti, who's supposed to be taking the stand later today. Well, we're going to be taking your questions, as I mentioned at the top of the show, for the next hour. So submit those to us on YouTube, Twitter, Facebook, Instagram, Threads. Get on Threads if you're not on there already, and TikTok. So let's get right to the questions. Linda, I'll throw this one to you. At Nate Dog from YouTube asks, do you think Melly will testify?
Wow, that is always the most interesting question. I don't think he is going to testify. However, having said that, we have seen a rash of defendants get on the stand. The problem with that is that if he testifies, the trial will come down to just what he says. Now, the defense may think he has to refute why he changed his clothes, but maybe there's somebody else that they'll put on to talk about why he changed his clothes, because to me, that may be a single most important fact in this case for the prosecution.
A change of clothes around the time of a homicide is always a big red flag. It's something that raises a lot of suspicion because it just seems kind of too coincidental. You know, there aren't many coincidences in life. The Z Sisters from YouTube asks, do you feel as if YNW Melly has a chance of being found not guilty as of right now? So Tyler, I'll throw that one to you.
You know, this is a tough case where he's being charged with these murders basically based on mainly circumstantial evidence. I do think there's some reasonable doubt, but what I think is reasonable doubt versus what jurors believe is reasonable doubt is a real question. As of right now, I don't see him being found not guilty. We still have to see the defense's case. Maybe they'll bring up a lot that's going to strengthen their case. They've been bringing up a lot of good points here, but as of right now, I don't see Melly walking away from this case.
Our next question, Menace JPN from YouTube, Terry asks, is this witness, Travion Glass, beneficial to Melly? What do you think?
Well, I think he has benefits for both sides. I mean, he isn't really saying anything that's going to help the prosecution or the defense. I mean, I mentioned the clothing because I do think that was one piece of information that could be helpful as far as the prosecution is concerned. But here's what's clear, Anjanette. He does not want to be here. He does not want to be questioned by either the state or the defense, and he's showing that he is impatient. He does have a little bit of a sense of humor. He did say when he was asked about his smoking and his marijuana, he did say, I should have had some before I came here, and the courtroom sort of all laughed at that, including the jury. But I don't think he's just given any information that's really going to do anything for either side at this point. He was very hesitant to say very much.
And I can understand that. You know, there's this whole thing about snitching and being perceived as being a snitch, and he's probably fearful and doesn't want to be there. I mean, we're talking about a case that involves allegations of gang membership and things like that. So I don't blame him for not wanting to be there. At @GotMorals_1106 from Twitter, Linda, how long is this going to be? The judge even looks tired with the defense's horrible evidence.
Well, the defense really hasn't put in any evidence yet. It's always the prosecution who goes first. As a matter of fact, the defense has no burden to put in any evidence at all. But I do think they will have their own medical examiner. I think they'll have their own crime scene reconstructionist. That could take some time. Now, of course, that's a couple days. Now, if Melly testifies, then all bets are off, obviously, because then that case, as I said, becomes around him, and it will take a lot longer. But I don't see the defense going that long on the evidence that they may have. I think they're going to be pointing towards, if he does get a conviction, as you know, in any death penalty case, you start by doing your mitigation first, even if you don't have a verdict, to make sure that if you do get a verdict against you, that you can try to avoid the death penalty through your mitigation investigation.
You know, you mentioned the possibility of Melly testifying. A lot of people think he won't. But, you know, Linda, this is really a decision that he makes. Right. I mean, Melly, that's really one of the only decisions he gets to make in the case, is whether or not he gets up there.
Right. He gets to make several decisions. He gets to make a decision whether he pleads guilty or not guilty. He gets to make a decision whether he waives a jury or not. And the third decision that is only his is whether he testifies or not. His attorneys can say no, and he may say yes, knowing that he has that 10 million followers out there on Spotify, and say, hey, I'm going to tell my truth, and my truth is the truth they want to hear. So, yes, you're absolutely right, Anjanette. One of the three decisions a defendant gets to make himself without his attorneys.
Tyler, this next one's for you. At Teresa855-24156 from Twitter asks, if the defendant is found guilty, how likely will an appeal be approved because the judge allowed this witness, Travion Glass, to testify after he had been watching live streaming of the case before he got on the stand?
Well, appeal being...
Oh, that one's for Tyler. Sorry, Terry.
I was saying whether the appeal be improved or if the defense will file one, I think is the question. The defense will all but certainly file an appeal if Melly is convicted. I think there's a lot of issues for appeal. This is a death penalty case. The stakes are very high. Some of the evidence that was entered into the case, there's a lot of objections to. So I believe all, but certainly they will file appeal if Melly's convicted.
All right, Terry, this one's for you. Malcolm Chandler from YouTube asks, why didn't the defense, and we're back to the close now, why didn't the defense question the witness on Melly changing clothes? Are they conceding this as fact?
I don't think they're conceding anything at this point. I think they did not want to redress that issue again. It's already been stated on the direct examination. I think they focused, like surgery, on the points they wanted to make. One of the points was that Facebook messaging back and forth between Melly and between Trevion Glass. And the one point I do think that the defense made was, look, they were having a discussion about what happened. Apparently, Glass was concerned. People were asking him. But I think defense made it very clear that Melly basically didn't respond for at least the first page. And then later he said, I'd never do, quote, nothing like that. So I think he made it clear on the cross-examination that Melly, at least at that point on Facebook, was denying that anything had happened. I think, defense decided I'm not going to ask about the clothing because, that is, I think, a very difficult issue to address.
Yeah, and they may think it's more beneficial to them to just gloss over it and move on and not make a big deal out of it. All right, we're going to take a quick break, but when we come back, we'll take more of your questions. So keep them coming to us on YouTube, Twitter, Facebook, Instagram, Threads, and TikTok, and we'll get to as many of them as we can. I'm Anjanette Levy, and you are watching Law and Crime. Welcome back. I'm Anjanette Levy, and you are watching Law and Crime, and we're taking your questions about the YNW Melly double murder trial. The court is back in session this week after being dark last week for the holiday and for some other issues. Submit your questions to us on YouTube, Twitter, Facebook, Instagram, Threads, and TikTok, and we'll get to as many of them as we can. Our next question, Linda Kenny-Bodden, comes from Daniel Baker. He says, do you think this case is winnable even with all the circumstantial evidence? And I think he might be referring to, is it winnable for the defense?
Yeah. Yes, I absolutely do think it is winnable for the defense, because remember, the question is, even if Melly was in the car, was he in the same place that he was seated earlier, or did the shots come from somebody else who may have changed places with him? And the prosecution has to prove that beyond a reasonable doubt. And we know that Cortlen Henry, that he has that co-defendant who is having a separate trial later on, because the prosecution has charged him also here for the accomplice to the homicide. So the defense could easily win that case, where somebody could get hung up and say, well, he could have been the shooter, but so could have been the other guy who didn't get on the stand here for the state and testify.
Mm-hmm. Tyler, Michael Jorgensen has a question on YouTube. Do you think the prosecution team choosing to put on a witness that seemed hostile and unwilling to cooperate makes them look desperate to jurors?
That's a good question. I'm not sure if it makes them look desperate. I think the prosecution team obviously felt this witness had really something to bring. I think this witness does not want to testify. He does not want to be perceived as a snitch. And his statements must have something very helpful in him, in those statements. That's why they keep trying to refresh his memory. This witness is pretty savvy, saying that the statements are not going to help him recall. So that information is not getting in. I think the prosecution is being optimistic, hoping they could get this evidence in, but they're not looking like they really can't. They're using him for what they can, but he's not bringing what they want him to bring, clearly.
Mm-hmm. Terry, our next question is from @Robin_Deshant, I think, from Twitter. One simple question. Why does he, and I think she means Melly, she just says he, seem so happy to be there?
Well, I don't think he's very happy to be here. I think it's an opportunity for him to be out of prison. Remember, he has been in jail since the very beginning. He is not on house arrest. And so I definitely think it gives him an opportunity to see his family, to be outside of the prison that he's or the jail that he's in. And so, you know, he might be laughing at times and he might be smiling at times, but I don't take it as he's happy to be here. This is a death penalty case. I am certain that the severity of this crime is weighing on his mind, and the results of the case is a very serious, situation. And I'm certain, and I've seen him be very pensive as well. So if you see him smiling, it's just because, he's talking to his attorneys. That's my impression in any event. I think his demeanor now is not as jovial as it might have been in the beginning. Some of that might have been nerves, but I think at this point he's sort of settled down and he understands how serious the case is, but you can still see him smile from time to time.
Our next question, Linda, comes from Threads, EST_4_18_1981. I'm assuming that's somebody's birthday. Can the judge subpoena Mr. Glass's cell phone records regarding him talking/texting while on the stand, even if they were in recess? Wow. Well, I don't know if I've seen people talk or text on the phone during recess on the stand.
Well, interesting, because I've had cases where the other side has asked whether or not you talk to anybody on the phone in between a recess and who. The judge cannot subpoena anything unless there's a request from the prosecution, and the prosecution has good cause to believe that some type of order may have been violated. And what could be that order? That could be that the order could be, well, were you talking to another witness about your testimony and influence another witness? But since everyone basically in the case has testified, that's really not going to go anywhere. So the prosecution could try to do that. But, this is a really smart witness. And I want to repeat again what Tyler said and what we talked about at the beginning of the hour. He knows enough to know that when he's asked whether a statement will refresh his recollection, to say no, because you can't use the statement to refresh a recollection if the witness says no. Most people say, sure, let me look at it, right? Maybe it'll help. So he's very smart. and I don't think that he's going to make any mistakes that's going to put him in the, shall we say, as a target of being a snitch at this point in the trial.
Junina43 from Instagram asks Tyler, question, was this witness scared of anyone in the room? Why was he constantly trying to hide his face with his hair?
I can't say if he was scared of anybody in the room. I think that, nobody is used to testifying on the stand, especially in a case of this nature. It's a death penalty case against a former associate of his who he probably has known for years. He has his own legal problems that he's testified about. He does not want to be there. Now, is he scared of anybody in the courtroom? I'm not sure. He probably knows this case is streaming to millions of people across the world, and he does not want to proceed as a snitch, especially in his community. He's testifying in his county, and he's also an artist as well. So he doesn't want that to probably mess with his career.
And, there's a lot of, pressure for people to not snitch, depending. This is the kind of case where people would be freaking out about being perceived as a snitch. It's just the way it is. TikTok, this question comes from TikTok, Terry. MD Axeman 3 asks, is there a picture of Melly with different clothes? Can it be proven?
Well, there's certainly still shots of him at the studio, and he's wearing this blue jean type looking jacket, and he was on a photo having that on. I have not seen any photos of him with the shorts on or any still videos of him with these shorts on. He's only had that one outfit where he had pants and this jacket on in the studio and getting into the car, and that's what Trevion Glass actually testified about. Yes, that's Melly right there. You just saw his picture. I just told you that was him. Yeah, he's wearing the same thing. And so there's no picture of him that I am aware of any different clothing. Just so far, Glass's testimony that he came back to the house with different clothing on. And I think he was talking about Fredo Bang's house and not Melly's house, because he came back and forth to Fredo Bang's house.
And Fredo Bangs is the one who picked Melly up that night. We know that from texts and stuff like that. Facebook question, Linda. Catherine Vargas from Facebook asks, how many more witnesses does the prosecution have?
Well, it appears they may have this witness and then a follow-up witness, because we know that they're planning to probably end their case soon. I think they had hoped to get a viewing of the car and then maybe have had another witness to talk about the car viewing. But the judge denied that earlier, as we know. So I think the prosecution is going to close out probably today, at the latest tomorrow.
Mm-hmm. Okay, Michael Jorgensen from YouTube asks, does the fact that the defense was able to get the witness to admit that he remembered little about that night affect his credibility with the jury? Would it render what he said useless?
I don't think it would render what he said useless. I think it does help out the defense that he doesn't remember much or everything that he said that night. It's something that the defense likely would try to bring up in their closing or use it throughout their case when they present it in different forms of fashion if they can. I think this witness will probably be perceived as credible given he does not want to be there. Anything that he's forced to say is likely, if I was on that jury, I would take it more so of being a fact, because he does not want to testify. He's not saying that he doesn't want to say, he's actually being forced to testify and forced to either confirm or deny things.
Terry, that best dad ever from YouTube asked, do you think the witness drinking and smoking that night affected his memory?
I don't think it affected his memory, and here's why. He said he smokes all the time, and I guess long term, I'm sure medical, evidence has shown in the past that it probably does affect your memory, but he didn't seem as though he couldn't remember anything. It did seem to me, and probably to that jury as well, that he had this selective memory. He remembered some things, but not other things. Some of his memory was refreshed. I agree both with Tyler and Linda. He is a savvy witness. If he doesn't want to remember something, he says, nothing you can do will refresh my recollection, and the prosecution had to move on several times. So I think the jury is looking at him as a smart witness, somewhat funny witness, definitely someone who is not as respectful as we've seen witnesses be in that courtroom. But as far as his memory is concerned, it's selective and he remembers what he wants to.
Linda, that doesn't necessarily benefit the defense, though, does it? I mean, you could look at this witness and have different viewpoints. You could think maybe he said something differently back then because he felt pressured, or maybe he's saying things differently now because he doesn't want to be looked at as a snitch. So it could go either way.
Right, absolutely, Anjanette. It could go either way. The jury could say, well, wait a second, your deposition was taken on, what, Friday? And you can't remember between then and now what you said, and nothing will refresh your recollection. So you must have said something helpful to the prosecution that you're not going to say now. But the problem is the jury doesn't know what it is. So that's why I think his issue of remembering the clothes could be important. But then again, you know, a lot of the rappers wear the basketball shorts under their sweats and just take off their sweats. So he's wearing shorts to somebody's house. It's different than he was in. That may not mean very much. So very, very interesting witness. Yes, he doesn't want to be there. Yes, he is hiding his face a little bit. Yes, he's in public view. But I think the jury understands that this case is this case, and you're going to see that.
It'll be interesting to see how it all turns out. We're going to take a quick break. Keep the questions coming on YouTube, Instagram, Twitter, TikTok, Threads, and Facebook, and we'll get to as many of them as we can. I'm Anjanette Levy. You're watching Law and Crime. We'll be right back. Welcome back. I'm Anjanette Levy, and we're taking your questions about the YNW Melly double murder trial. So keep them coming to us on YouTube, Twitter, Facebook, Threads, Instagram, TikTok. We'll get to as many of them as we can. We had a really interesting question our last segment. Terry Austin, I'm going to bring you in because you said during the break you had some information about this. It was about Travion Glass up there on the witness stand texting and talking on his phone during a sidebar or a brief recess or something like that. So tell us what happened with that.
And Jeanette, I've got to say, I have never seen anything like it before. I'm sure it's happened. But while we were on a very short break, he got a call. He picked up his phone. He started talking, and he was also texting. So ultimately, the defense told the judge, look, he was on the phone. He was texting. That can't happen. He's a witness. He's on the stand. He hasn't finished his testimony. So the judge did question him, and the judge said, okay, so you were on the phone. Did you talk about the trial? And he said, no. And then he said, well, did you say anything that, was around the trial, surrounding the trial? And he said, no. He said, I was talking to my brother, and I simply told him that, things are wild. And that was it. So the judge asked him a couple of more questions, but all basically, you haven't said anything about the case. And ultimately the judge said, okay, let's go. You're back on. But I thought it was very interesting. Most of the courtroom was looking and saying to themselves, oh, wow, you were on the phone. It's, something that I haven't seen, and I think something that surprised the courtroom. The jury, by the way, was not in the room at that time.
Mm-hmm. Yeah, that's really what matters, is whether or not the jury saw the whole thing. But yeah, that's a new one for me. Witnesses. Linda said she's seen it happen before. I've never seen it.
You know why? You know why both of you? You know why? But because you're, as a witness, the only people you can't talk to are somebody who's going to testify. You can get on the phone. Let's say you wanted to call his mother. Hi mom, how you doing? Can I pick anything up from the store for you? Because there's no restriction of being on the phone or texting for a witness unless it has to do with the trial.
All right. Well, Linda, this one's coming to you. Minx TV from YouTube asks, why didn't they question Travion Glass about Bortlen, since he also changed clothes and he was at the hospital? From the studio to changing clothes and arriving at the hospital, something is missing.
Well, that's really interesting. I don't know why they didn't question him. Do we have any evidence in the trial that Bortlen did change clothes also to arrive at the hospital? I don't remember that testimony. Maybe Terry does, but it depends on who you're asking. If the prosecution doesn't want to do it, if obviously, because that wouldn't help him, the defense may have another witness that they're going to put on the stand that they can put it in through their case. So, we really don't know the strategy here, but they have to be very careful when it comes to Cortlen Henry, because he is a co-defendant.
Dior_me Tyler from Instagram asks, will they ask Melly, and obviously Melly would have to testify for this to happen, will they ask Melly where the clothing is that he changed out of during the murders?
Well, if he gets on the stand, I'm pretty sure they will. The chance of him getting on the stand in this case, I think, is unlikely. It's definitely a case. I generally recommend, when the stakes are high enough that the defendant tell their story. This is one of the cases where I probably would not want to put Melly on the stand. So if he gets on the stand, I'm pretty sure the prosecution would ask him that question. The likelihood of Melly getting on the stand, I believe, is low.
Terry from Instagram as well. DJ Louie Lou asks, is the prosecutor's office still looking for Melly's girlfriend? That's Mariah Hamilton.
I don't think at this point the prosecution is looking for anyone. They know they have to wrap up their case. They had her mother on the stand, if you recall, and that testimony I don't think went very well for the prosecution. She made it clear when she got on the stand that she was afraid and she was feeling intimidated by the prosecutor herself, Ms. Bradley. So I think as far as the daughter's concerned, we're not going to see her called by either the state or the defense for that matter. And frankly, I don't know how much more she has to offer. She took the phone call from Melly when he was telling her that they were in a drive-by shooting. And frankly, I don't think that's very helpful for the prosecution. So I think we'll see the last witness, who is the detective, the lead detective, Moretti. And, he's expected to testify later after Travion Glass, and he's off the stand now. So we'll see him soon.
Linda Demon KG from YouTube asks, do you think if Melly is found guilty, it will affect Bortlen in a positive or negative way?
Oh, that's a really interesting question, isn't it? Because when Bortlen goes to trial, he's going to say, hey, wait a second, the shooter is Melly. You can't talk about the verdict so much, but the shooter is Melly. By the same token, if he's an accomplice to the shooting, then it also has a reverse effect, doesn't it? But I just think that's an interesting question, one I can't answer right now. We'll have to see what the verdict is and what happens when you get to his trial.
Tyler Two Particles in a podcast from YouTube asks, question, don't you think the jury might notice every time the prosecution wants to bring in any evidence, the defense objects? I would be wondering what they're hiding if I was a juror.
Well, yeah, I mean, a lot of times jurors, it can get annoying if there's constant objections and what they're trying to hide. But in a case like this, I would think that the jurors would understand eventually the stakes are so high that the defense is going to object. Melly's life is on the line here. At the bare minimum, life in prison if he's convicted. If he still can face a death penalty as well. So the defense objecting to evidence getting in is what they should be doing on a case like this. They got to dot their I's, they have to cross all their T's.
Remixes from YouTube, Terry asks, and we have less than a minute left. If Bortlen had gunpowder on his hands, not Melly, and Bortlen had a change of clothes on before the hospital, why is Melly being accused on the death penalty and not Bortlen?
Probably the best question we've gotten all day. I think that those, gunpowder residue is very important. We have Melly on the stand just because he was sitting in that position, and the medical examiner said that that's where the bullet came from. So that's how the prosecution decided, as between Henry and Melly, which one is getting charged for the death penalty.
So there you have it. They don't believe Bortlen was the shooter. That's why, basically. All right, keep the questions coming to us on YouTube, Twitter, Instagram, Threads, TikTok. We'll get to as many of them as we can. We have to take this quick break. You're watching Law and Crime. Welcome to Law and Crime. I'm Anjanette Levy. Thanks for joining us as we take your questions about the YNW Melly double murder trial. We're in the lunch break right now. We've got just a little bit of time left in that lunch break. So keep your questions coming to us on Facebook, Twitter, YouTube, Instagram, Threads, and TikTok. We'll get to as many of them as we can. YNW Melly, of course, is known, his legal name is Jamell Demons, and he's on trial accused of killing his two friends, Chris Juvy Thomas and Anthony Sakchaser Williams, back on the early morning hours of October 26, 2018. The prosecution claims Melly fired the shots from the backside of the vehicle or the back seat of the vehicle, while Melly and Bortlen claim, his co-defendant YNW Bortlen claimed that this was a drive-by shooting. YNW Bortlen, his legal name is Cortlen Henry, and his trial will start in October of this year, and I'm sure we'll have that covered for you. As I mentioned, we've got your questions coming in, and we're going to take more of them. Terry Austin from Law and Crime is at the Broward County Courthouse. Linda Kenny Bodden of Law and Crime is here, as well as is Tyler Bailey, a civil rights attorney from South Carolina. Our next question comes from Andrew Carson from YouTube. Terry, after a rocky start, do you think the prosecution is feeling better about its case?
Well, I think they felt better when they had the medical examiners on, and also when they had the reconstructionists on, because those two pieces of information said that that shot was taken from the backseat. Those two shots that killed, the kill shots essentially, that killed, both Christopher Thomas and Anthony Williams. So I think they felt the best when they had that testimony on. Right now, I don't think that they are at a high spot because they're winding down their testimony. They're ending on a note, I think, that didn't really help their case so much with Trevion Glass. He just basically was saying he didn't remember much. He did add this bit about the clothing, but all in all, they're ending their case. They still, honestly, Anjanette, and we've said this from the beginning, they still have not put that gun in Melly's hand at the time the incident occurred. So I think there's still some doubt in the case, and I think the jury is probably going to go into the defense's case with a little bit of doubt on their mind.
Chevelle Leathers from YouTube asks Linda, how will the jury, knowing that Jamie King, who's Melly's mom, and Trevion Glass were threatened by the prosecution, affect the trial?
Because, you go with your life experiences, and, they did hear from the mother of the girlfriend of Melly that she felt threatened by the prosecution. And if your life experiences show that you do not believe the police, that you do feel that the state always comes down on people, especially people of color or people who are poor, that could absolutely affect the trial, indicating that the state just went after a celebrity, right? They went after Melly, the celebrity in the car, before they really knew it was him, and they had to make a decision between his co-defendant and him for the death penalty. And who did they go after? The famous rapper. So I think it can affect the jury. You just need one.
Darius Sanchez-Smith from Facebook asks Tyler, will the death penalty changes affect how the jury decides on the verdict? And I believe they're referring to the changes in the Florida law that allow for an 8-4 verdict on the death penalty, for the death penalty to be rendered as a punishment rather than the unanimous 12-0.
Yeah, it will change, as you said, Anjanette, the number of jurors that have to vote for a death penalty here. Just 8 jurors have to decide that they agree with the death penalty versus 12 unanimous verdict for death penalty. This is a new law that Governor DeSantis put in place. It's different in a lot of jurisdictions throughout this country, given that 8 jurors could vote to have somebody's life, the supreme penalty, on the line, and 4 could be against it. It's typically a unanimous verdict for the death penalty. So the jurors will have a lower threshold if that's the route they want to go. I do think it could backfire, though, because I think jurors with the death penalty being on the line may be thinking or magnifying the doubt that the defense is poking in the state's case. And if you're going to vote to put somebody's life on the line, I think you're going to focus on any issue where there's reasonable doubt or it's not making sense, the state's case.
Terry, J. Red's Jowry on Threads asks, do you think Melly needs more psychological help rather than prison time?
Well, I haven't seen any evidence to say that he needs psychological help. I think all of the evidence so far has him as, a rapper, someone who was climbing to fame, someone who is very popular. I haven't seen any evidence to say that, he has any medical issues as far as, mental instability is concerned. Off the record, I mean, we have heard that he may have some issues, but I'm not going to comment on that because it's nothing that we've seen that has been introduced into evidence. I haven't seen any behavior that indicates he may have, ADD or something to that effect, which millions of people do have. So I don't think that his medical or mental health has much to do with this trial at all. And certainly this jury has not seen any evidence to that effect.
Michael Jorgensen, Linda from YouTube asks, at this point, do you think the defense needs to attempt to provide an alternate version of the crime, or do they just poke holes in what's been presented so far?
That is a great question because we as defense lawyers always talk about that. I am a very big one in the defense case when I have a team to have an alternate version of who the killer is. I think that gives the jurors that have that doubt more to talk about than just poking holes in the crime, in the prosecution case. And also the defense can go after a motive, okay? One of the things, the prosecution doesn't have to prove, but why on that night at that time would Melly decide to kill some of it has been described as his best friend. So I think that the defense should rely on that, have their own crime scene reconstructionist, and have a version that puts the gun in another person's hands.
Paul Hannigan from YouTube, Tyler Bailey asks, and he's from Ireland, so thanks for watching from Ireland. Has there already been enough reasonable doubt raised that the jury should acquit, and will the defense ask for a JOA, judgment of acquittal?
Great questions. Early on in this case, before the reconstructionist testified and medical examiner, I would say there seemed to be a stronger case for the defense. I do think those state's witnesses have helped their case greatly, showing that the kill shots came from the back seat, and also showing the trajectory of the shots and that they were dead at the time they were shot from outside the vehicle. The defense probably would move for that motion. I do not believe the judge would grant it in any situation. There's reasonable doubt. Is it enough to have Melly acquitted is the question. We still got to see the defense's case. And I think if there is an alternative theory of the shooter, maybe somebody else did a drive-by shooting, who that could have been, or their enemies, there's a lot that could come out that can help the defense's case.
Terry, Wilson from YouTube asks, have any other cars been spotted on CCTV in the area that could have committed the drive-by?
Not to my knowledge. I mean, we've had these videos that were introduced and played by the prosecution of cars going on a highway, but they weren't identified as anybody's car in particular. We know about the two primary cars, the gray Jeep and also the red Mitsubishi, but those are the only two cars that have been identified in the crime scenes. And the crime scenes include, obviously, the studio, and also we saw one of the cars coming into the housing complex, the Jeep, I believe. But we haven't had any other cars identified. So there may be other cars that are driving that at some point will be identified, but the prosecution is the one who introduced those videos. She had someone come in, lay the foundation, she played those videos, but she didn't describe them or other cars. So for now, we just have those two primary cars.
Linda, Russell Thomas from YouTube asks about Travion Glass. Did the last witness commit perjury, saying he didn't talk to authorities, then presented with the statement that he made?
Well, I don't know if you can call it perjury here, Russell, but it is a good question and something the jurors may think about. I mean, no, he talked to authorities and he talked to the prosecution and he had his deposition taken. So everyone knows that he talked, but the question is does he remember what's in the statement? And it's very hard to prove that, even though we think that he is just a savvy witness who would say, I don't recall and nothing will help me recall, you really can't prove that's perjury. I mean, there was a famous case years ago, probably before before you were born. Oliver North, in a federal case, he was a general accused of perjury, but he really couldn't have been because his answer was, I don't recall, I don't recall, I don't recall. So savvy witnesses know that I don't recall means no perjury.
Did you say Oliver North was before I was born?
Yeah.
Bless you, Linda. Not true. I remember it well, but I love that. I'll take it. Okay, Jacob Sanders from YouTube asks Tyler, did the witness move the needle? Seems to lack credibility.
I don't think this witness moved the needle. I don't. I think that the prosecution was optimistic, thinking or knowing what was in the deposition and his statements would have been good facts for the jury to hear. But as Linda has mentioned, as we all have mentioned, he says he does not recall, and these statements will not help him recall. So I don't think he's really moving the needle for the prosecution. I believe that whatever was in those statements would have really moved the needle. That's why they called this witness, and that's why they called him so late in the case, in their case, because they believe this would be a crucial witness for the jury to hear. But his testimony hasn't moved the needle, in my opinion.
Big Head, Terry from YouTube asks, and this is kind of similar to a question we had earlier, will the death penalty changes affect how the jury decides on the verdict? I think it possibly could, even though they are not supposed to be biased.
Well, they're not supposed to be biased, but they were told during the voir dire, the jury selection, could they listen to a death penalty case, so they know that this is a death penalty case. They said they could be fair, but subconsciously, I do think when a jury is trying to decide the guilt phase, they are thinking about what the potential punishment could be. And if that punishment is death, I think they will think twice about implementing that sort of punishment. So I do think the prosecution should have thought very carefully about that, making sure that their evidence was way beyond a reasonable doubt. There is some doubt in this case, at least based on the evidence I've seen thus far. And so I think a jury might be looking at that death penalty and thinking, I'm not going to vote on guilt. I don't think there's enough to put this individual to death.
Linda, this next one comes from Marie underscore from YouTube. And a lot of people have been asking about Bortlen, Cortlen Henry. He was in court last week for a pretrial hearing. His trial is set for October. He wanted the terms of his, well, it was a week and a half ago he was in court, but he wants the terms of his bail to be modified so he can go to church and travel. Judge said no. Will Bortlen testify? Do you see that happening since we're at the end of the state's case?
No, I don't see it happening. To have him testify, the state is going to have to give him immunity. And that's not the kind of immunity as a prosecutor you want to the other shooter. I've been in cases with that. We had that issue in the Aaron Hernandez case, if you recall. And we were successfully able to argue, I think, to the jury that there was reasonable doubt because the other shooter is the one who didn't have any charges against him. So I don't think the state is going to go there, certainly not at this late date.
Yeah, that would be a shocker, I think. All right, everybody, thanks so much for joining us. Unfortunately, our time is up, but Linda Kenny Bodden's going to take over everything after this break. Tyler Bailey, thanks for being with us. Terry, we'll let you go back into court. And everybody have a great day and keep watching. I'm Anjanette Levy, and you're watching Law and Crime.
afternoon and welcome back again to the Law and Crime Network. As you know, I'm Linda Kenny Bodden. Well, we're going to continue our coverage in Broward County, Florida for the YNW Melly double murder trial. This South Florida rapper, whose real name is Jamell Demons, is accused of the 2018 shooting deaths of Christopher Thomas Jr., also known as YNW Juvy, and Anthony Williams, also known as YNW Sakchaser. All were part of the YNW collaborative, along with the co-defendant Cortlen Henry, who will be tried separately later on after this trial. It's day 12 now of this trial, and today we heard the testimony from Trevion Glass, an associate of the defendant who was in the recording studio with the defendant, co-defendant, and the victims on the night of the murders. While the court is still on their lunch recess, let's recap key moments of his direct examination. Let's go right into court now.
So let's go back to October 26th of 2018. What were you doing for work?
I wasn't working at all.
All right. Were you involved in the music business at all?
Kind of, sort of.
And how so?
Making beats.
All right. And when you were making beats, were you working with a specific group or music group or people?
One person to be particular, but yeah, supposed to be in the group.
All right. Let's start by saying this. What group was it?
YNW.
All right. And when you said one person specifically, who was that person?
Julie.
Okay. And can you tell the members of Judy's real name?
Christopher Thomas.
And how long had you known Christopher Thomas, who you refer to as Judy?
Over a decade.
Okay. And this is back in October. And did you know somebody by the name of Anthony Williams who went by Sakchaser?
Yeah.
And how long had you known Sakchaser?
A couple years.
And who's that person?
The best of my knowledge, Moretti.
Okay. And the person I'm referring to, what is he wearing?
A jacket.
All right. Do you recognize the person on the other side of the photograph wearing what appears to be a black shirt?
Kind of, sort of.
If you do.
No, I don't.
Okay. Mr. Glass, let me know if I need to rewind the video, but you had a chance to look at the face of the individual wearing what appears to be a white shirt and blue shorts?
It's me.
Okay. Continuing to publish. I'm pausing the video at 2:18:41. Do you see that individual carrying something across his shoulder, wearing what appears to be a blue jacket?
Say it again?
Do you see that person on the video?
I see the back of his head.
Do you see the back of the head of the person wearing the jeans jacket?
Correct.
Was that person the same person that you previously identified in states?
Sustain, rephrase it.
Okay. We previously looked in state 72 at an individual you identified as Melly.
Objection.
Do you see the jacket in states 72, image number 3? The front of that jacket?
Yeah.
You see that jacket in states image 1 of state 72?
I see the same thing y'all see.
We spoke about this, Mr. Glass.
I'm saying that. You ask questions, right?
I'm asking questions, Mr. Glass, and I'm just asking you to respond if you have knowledge. Is that jacket that was in image number 1 and image number 3 the jacket that Melly was wearing on October 26th of 2018?
To the best of my knowledge.
To the best of your knowledge, yes or no?
Yes.
Publishing state 7. And then go. I'm back to state 7, timestamp 2/18/41. The individual that's on screen wearing a jacket and it appears to be something across his back. Who is that individual?
Objection, asked and answered.
Overruled.
Mr. Glass, you can respond.
I see the same person as last time.
Okay, and can you tell us who that same person is?
Melly.
Was Melly at the house when you got there, from what you can recall?
No.
Did you see Melly at any time in the house?
No.
Right, so you go upstairs in Juvy's room, and what do?
Crash.
All right, crash meaning?
Go to sleep.
Okay. At some point, do you wake up?
Yeah.
And why? Or how?
Phone calls.
Okay. Safe to say that your phone was getting a lot of phone calls, blowing up.
Yeah.
All right. And at some point you answer the phone, correct?
Yeah.
Okay. What do you do in response to the phone calls?
I answered the one that kept ringing, and yeah.
All right. And so what do you do in response to getting that phone call?
I ended up at the hospital.
All right. Do you recall which hospital that was?
No, I don't.
Do you recall what city you were in at this point?
I was in Broward.
All right. What city? Not the county.
Miramar.
Okay. Do you know if you went to Miramar Hospital?
I don't know what hospital it was.
Okay. So you get to the hospital. What do you find out when you get to the hospital?
That Anthony and Christopher was deceased.
Obviously, at that, well, let me not say obviously, but at that point in time, what do you do? Or how do you react to that news?
Grieving.
Okay. Do you stay at the hospital?
Not long.
Right. Where do you go after the hospital?
I ended up somewhere, somebody's house.
All right. Do you recall whose house that was?
I don't know whose house it was, but I ended up there.
Okay. And what were you doing at the house?
Still grieving.
Okay. Who took you to the hospital?
The cameraman.
Okay. Do you recall his name?
Drew.
Right. And do you recall who took you from the hospital to Freedom's house?
Same person.
All right. And before you left for the hospital, or actually, who went to the hospital with you?
Just Drew.
Okay. Who was at the house, Melly's house, before you left for the hospital?
Same people that was there when we got there.
Okay. And same people being the 4 people that entered the Mitsubishi?
Yes.
Okay. So you're at Frito's house. You mentioned, and I forgot exactly where you were in the house. Did you say where you were?
Juvy's room.
Oh, no, not Melly's house. Frito's house. Where were you in Frito's house?
Outside.
Okay. And who was at Frito's house when you first got there?
Everybody that was in the house.
Okay. And it's because I don't know who everybody was or is, can you please specify?
Kobe, Melly. I'm on people I can remember.
Okay. Was that the first time you saw Melly after you guys left the studio?
Yeah.
Was Melly wearing the same clothes or different clothes than when you saw him at the studio?
It was a new day. Nah, he wasn't.
Nah, he wasn't. You guys
He wasn't wearing the same clothes.
Okay. Do you recall what he was wearing?
Just had on some shorts.
Okay, let's bring my guest in to discuss his testimony. Obviously, Bob Motta, host of Criminal Defense Diaries. It is a podcast. He is a criminal defense attorney. And my dear friend also, Krista Ramey, a trial attorney. Krista, I want to start with you. Trials come down sometimes to 1 or 2 things. Could that 1 or 2 things here be that Melly had either changed his clothes or was just wearing shorts on?
Yes, because why? It's a kind of weird fact in this case, right? But there's a lot of 1 or 2 things here that things can come down to. One of the things that I've noticed during this trial is just his deportment and decorum in the courtroom, constantly trying to cover his hair, trying to obscure himself. You know, a jury wants to believe someone that they like, not someone that seems like they're hiding something. And changing clothes seems like they're hiding something. And hiding behind a computer and your hair covering your face, likewise, it looks like you're hiding something. So I think that piece of evidence can be pretty powerful ultimately in the end.
Well, let me just tell you, there was Terry Austin's been in the courtroom. She said that he apparently cannot see out of one eye, so the court, or has trouble seeing out of one eye, so the court moved the screen so he could see, and then it wasn't moved back until somebody later said, oh, can we now move the screen back and see his face? So that's what happened. That's why we were watching a Dell computer testify, it seemed. Okay, Bob Motta. One of the things that happened this morning was that the prosecution also tried to get a view for the jury of the car, and the defense objected. They said they hadn't even seen the car, and the judge said, no, I can't understand the defense who would not go see a piece of evidence. I mean, usually, and I've said this before, when I'm in a case, we go see evidence so much that there's motion to the prosecution that says no, even though the evidence should belong to all of us. In the Hernandez case, for instance, we couldn't see the car that the victims were shot in because it had been sold to the state of, it went to somebody in the state of Georgia, not Georgia in the United States, but Georgia and Russia. But I don't understand that, because sometimes you can find evidence. Bob, your thoughts?
Yeah, as far as why the defense objected, the only thing that I can think of is in terms of the kind of the damning evidence that they had put on last week with respect to the two forensic officers who had been out there. It was pretty damaging, you know, in terms of the bullet holes and where they were and see.
Bob, you're breaking up, so let me just go to Krista on this. Krista, let me cut Bob off for a second. Bob, you're broken up. Let me go to Krista. Krista, let's talk about this for a second. But you can find evidence. You can find evidence if you're a defense attorney. You can go with your experts and look at stuff. I don't understand that maybe they felt that they shouldn't look at it. I just don't get it. I don't get it. And I think that if he gets convicted, that could be one thing, an issue on appeal. Your thoughts?
I cannot understand not only the defense team not wanting to look at it, but as you said, taking your experts there, because I might see something as an attorney that clicks to something that might lend itself to credibility of a witness, or what someone is trying to say. On the other side, my expert might find all sorts of pieces of evidence or things that I wouldn't even think of looking for or at. And so, yes, it's bizarre, and it's not only bizarre, it's borders on malpractice to not have already seen that car. I mean, much less, for the jury view, not to have seen the car, I think is what he said. So I am pretty stunned by that.
Yeah, as a matter of fact, let me just tell you a story before we go to break. Again, in the Hernandez case, we went to see the evidence, and I found an exit wound that had not been marked on the shirt of one of the decedents, an exit wound from a bullet that changed where the trajectory was, that had not been noted on any of the prosecution discovery. Me, an attorney. So anyhow, I think that you always have to go see the evidence in the case, no matter what side you're on, but we'll see if it has an effect here. And we're going to take a break. When we come back, we'll go right back into that courtroom and bring you more of this stunning testimony we're hearing this morning. Stay with us.
underage child that has to be kept under seal for that in the phone. But the state has selected 20 videos. I think we're down to, 25 videos. We're down to 24, to showing who is using the phone and operation on the phone.
I don't know the relevancy of that, and it's repetitious to the 525 photos that we went through in about 3 hours the other day, coming from purportedly his phone. I don't know why we have to go through all of this again. And there's also a short video of a little baby on there also. I don't know what the relevancy of any of this is. And if it is relevant, if she can't get it through the 525 pictures that we have to sift through, where she manually counted each one, I don't know what we're doing, Judge, quite honestly. So I would object on relevancy. Cumulative. These are fancy words for me.
Yes, Your Honor, the state has to prove that the defendant was the one using the 772-713-9807 phone number. This is a short selection that is representative of the number of videos that are on there that show the defendant being the person using the phone. The defense has argued that it is not his phone in any way, shape, or form. So this is showing that there is no one else on there, and that even with photos and videos that show other people, for example, have the defendant using the cell phone to FaceTime and videotape a FaceTime of another individual. And they're constantly showing the phone in the defendant's hand, sometimes reflected in some sunglasses or eyeglasses on screen.
I know counsel objected to on relevance grounds. I already breached that, and we crossed that bridge a while ago. I overruled that objection. But now there's another objection to cumulative. Haven't we seen these videos and pictures?
We have not. These are different ones from different time frames, showing that the defendant had exclusive control of this phone for all times relevant to this case.
There's one where there's a child on it, and I think it violates the children's, what is it?
Online Privacy Protection Act, which says children under the age of 13 cannot be filmed or published without the parents' consent. One of those videos is a video of
a little kid. Child.
What's that video about?
It shows the defendant's voice in the video. It then has him filming a FaceTime of another individual. Your Honor, the state didn't create these videos, the defendant did, so if anything, he's the one who would be in violation of that particular act.
I disagree with that.
I don't know what the act says, but what does this statute say?
I'm not familiar with the first time that has been brought to my attention.
Code imposes certain requirements on operators of websites or online services directed to children under 13. Long and short of it is basically you cannot record or publish children under the age of 13 without their parents' permission.
What's the statute number?
It would be 16 CFR Part 312, Children's Online Privacy Protection Act.
16 CFR 12?
Part 312, Judge.
312. So how many of these videos do you have?
There are 24 now, Your Honor, out of 1,000.
All right, and you want to show this one that with the child as well?
Yes, Your Honor, it shows the defendant holding the phone and videoing.
You can show some of these other videos first. Is that right?
Yes, Your Honor. Do you want to see the one in question?
No, I want to see what this statute says, 16 CFR 312.
Your Honor, there's an additional individual. First of all, I just wanted to crystallize our position that if they're putting in 530 photos to establish that it's his phone, adding another 20-something videos doesn't move the ball any. It's cumulative and should be excluded. We object on those grounds. There is also video number 1, 2, 3, 4. And in that video, Mr. Demons uses a pejorative term that I don't want, that I think will be inflammatory, and on 403 grounds we would object. It refers to Caucasians as crackers, and I don't want any of the jurors who might be of that race to form a negative impression and be prejudiced in their assessment for the sake of proving that Mr. Demons owns a phone that they've already seen 530 photos from.
Judge, with regards to that last video that counsel is taking issue with, this is the absolute last video or audio file that is on this phone before the defendant turns himself in, and he does use that term. However, I think in the totality of the circumstances, it is more probative than prejudicial.
We would stipulate that he used the phone on that day.
My name is Melly, and I'm going to turn myself in, but I'm in a suitcase because these private are harassing me, and I have to get on a private jet, and I don't want them to see me.
So in terms of, it shows the defendant just prior to his arrest and booking, and showing that he was turning himself in, which has already been testimony about, that was brought in from the defense with regards to Deputy Maycock, who did the booking prints on this case.
We'll stipulate that he used the phone on that day to avoid the potential prejudice of him offending jurors on the racial pejorative.
Play it again.
Sure.
Hello, so everybody. This is real French. My name is Melvin, and I'm gonna turn myself in, but I'm in a suitcase because these privates are harassing me, and I have to get on a private jet, and I don't want them to see me.
And so, just to be clear, there has been numerous other inflammatory, racially motivated terminology and language that has been used, and there's been no objection on that ground.
We all done anything else?
Nothing else.
All right, so regarding the one with the presumably under 13-year-old child on the video, just hold that until I can see what the CFR say. The jury regarding the last video where the pejorative terms used, crackers, just go ahead and delete it, all right?
So with your permission, I can take out just that term?
Yep.
Okay.
That's what was
I'll need a couple minutes to do that.
I hope that's enough.
Who's next witness?
Mr. Cardi, Your Honor.
You're not ready?
We're using a small check.
We're in recess.
Welcome back to the Law and Crime Network. I'm Linda Kenny Bond.
I have to get on a private jet. I don't want them to see me.
Ready to go?
Yes, Your Honor.
All right, let's get back on the record. The State of Florida versus Demons. President is the defendant, his counsel, the assistant state attorneys, juries in the jury room. Regarding the objection was posted about the child on the CFR, that objection noted. I've looked at the CFR question. I don't think it's applicable. The objection notes over here. All right, and he took out the word majority term cracker.
I did, Your Honor, and I played it for Mr. Howard twice, so he can verify that it is silent during that portion.
Thank you. Spring jury.
We can have Detective Moretti take the stand.
Sure. Ladies and gentlemen, thank you. Please be seated. Let the record once again reflect the presence of our jury, as well as the defendant, Mr. Demons, his counsel, the assistant state attorneys. And Ms. Bradley, this is your next witness.
Yes, Detective Mark Moretti.
Mr. Moretti, can you raise your right hand for us?
Do you solemnly swear or affirm the testimony you give in this case shall be the truth, the whole truth, and nothing but the truth?
I do.
Please state your full legal name for the record.
Mark Moretti.
Spell your first and last name for the court report.
M-A-R-K-M-O-R-E-T-T.
Thank you.
Please have a seat. That microphone in front of you only goes up or down. It doesn't move back and forth, all right?
Yes, Your Honor.
You ready to proceed?
Yes, Your Honor.
Counsel, you may.
Thank you. Good afternoon, Detective. How are you today?
Well, ma'am, thank you.
Where do you work?
City of Miramar,
How long have you worked for the City of Miramar?
20 years.
And what is your current assignment with the City of Miramar?
Homicide unit.
How long have you been in the homicide unit?
Since 2000, I started working in the homicide cases in about 2016.
Prior to becoming a homicide detective for the City of Miramar, what other hats did you wear?
I also worked in economic crimes for a couple of years. Before economic crimes, I worked in street crimes, which is street level narcotics, gangs, robbery, violent offenders. Before that, I worked in traffic unit as well as traffic homicide. And then before that, I was in road patrol.
Prior to your time in the Miramar Police Department, did you work for any other law enforcement agency?
Yes, I worked for Pinehurst Police Department in Miami from 1998 to 2003.
And don't make me do math, 2003 to the current, you've been with Miramar?
Yes, ma'am.
Prior to Pinecrest, did you serve in the military or any of the armed forces?
Yes, ma'am. I did a total of 20 years in the military. I did 7 years active in the Air Force, got out shortly after 9/11, went into the Coast Guard Reserve, did another 13 for a total of 20 years. I served in enlisted as well as in the officer corps for the Coast Guard.
So in terms of your training and experience as a police officer and a detective, did you attend a police academy?
Yes, in 1997, while still on active duty in the military, I went to St. Petersburg Criminal Justice Center.
And approximately how long was that police academy training?
A couple months.
After you became an officer with Pinecrest, did you have on-the-job training?
Yes, ma'am.
And at Pinecrest PD, did you hold any special titles or roles?
I was a drug recognition expert for field sobriety, impaired drivers. Also maintain the maintenance on the intoxilizer for courtroom purposes.
In terms of homicide specifically, do you have training in just that area?
In Pinecrest?
And all your time in law enforcement?
I've had about 240 hours in homicide investigations. The first class was death investigations here in Broward County. The second one was the Miami-Dade Police Department's Homicide School. And then the third one is through IPTM, which is the Institute of Police Technology and Management, which is another 40 hours of formalized training in the area of homicide investigations. And I attended 3 conferences, which each one is 40 hours long, and specifically 2 homicide investigations for about 240 hours, just a specialized training.
In terms of on-the-job training, do you have practical experience handling homicide cases?
Yes, I started slowly working homicide cases in 2015, just as training. I was basically writing warrants for the unit. I was doing fraud, and so when they were on scene, they'd be at the station, and I would get a phone call to start authoring warrants to be prepared for the judge.
Okay. In terms of the number of homicide cases you've handled since you said 2016 was when you went to that
Yes,
unit?
ma'am.
How many homicide cases, or death investigations, I should say, have you handled since then?
Homicide cases I've been involved in about 40 up to this point. As the lead, maybe 12, 15. Total death investigations, probably another 20 or 30.
So I want to talk about cell phones. Is that another area you have training and experience in?
Yes, ma'am.
What classes have you taken in from Celebrate?
I've been through the basic Celebrate examiner's course to conduct a digital forensic examination of the cell phone, and then interpreting the data from the cell phone as well.
Okay, and in terms of the number of cases that you've worked, could you give an approximate number that involves the data from a cell phone itself?
I've probably handled, over the years, probably 75 to 100 cases, specifically just with cell phones.
What about cell phone company data? The true call, the per call measurement, all of that?
I've been dealing with that since I came into the Detective Bureau. So that would be in 2013. I've had a bunch of specialized training in regards to cell sites. I've been to a forensic mapping course. I've been through with the platform what we use to analyze the cell site data, which is called CellHawk. It's just a different platform. Then I've been through the FBI's course, which is the CAST. And I still use CAST, the CAST platform, but for different aspects of cell site analysis. And I've been through an actual specific course for cell phone investigation, just using the phone in your investigations.
Can you explain to ladies and gentlemen what is CellHawk? That's the first time they've heard this term.
CellHawk is the same. It's very similar to what the FBI uses. FBI uses what's called CASVIZ. CellHawk is just a mapping program working off of Google Maps, to which we plot the data for the cell phone. It takes a lot of the work out. In the past, when we first started to analyzing cell data, we would have to actually plot the towers ourselves, determine what sector, draw the azimuth. Nowadays, we can just take the cell records and put it into the CellHawk. We still have to authenticate it, make sure that the data is being read properly, and then we're able to make our determination or apply the data to our case.
So you mentioned plotting and things like that. Do you use mapping software in your day-to-day work as a detective?
Of course. I mean, we just regular Google Maps, Google Earth. It's also a method of open source investigations is using the mapping.
So I'm going to go to October 26th of 2018. Did you have an occasion to become involved in a Miramar Police Department investigation under Miramar case number 18-10-06269?
Yes, ma'am.
What was your role?
I was called out around about 6 o'clock in the morning. Detective Bertrand called me. I was off, was not working. Hector was in his final year and a half of employment, and he didn't want to take on any new cases. He asked me, he said, I have him at the hospital, I have 2 dead bodies, would you mind coming out? Of course, they said to me, that's fine.
So when you got to the hospital, what did you see?
When I first got on scene, I made contact with the on-scene supervisor, which was Sergeant Bermudez, and he walked me through the scene, which was, at that point, it was just a 2018 Jeep Compass that was parked in the emergency unloading zone. It had many bullet holes on it.
Time out for just a second. Can you explain to the ladies and gentlemen of the jury how the emergency room unloading zone is separate and different from other areas of the hospital?
It's a pull-up where it has the electric sliding doors that it allows you straight access into the emergency room, which all hospitals are relatively standard in that sense that there's going to be a quick immediate access for the hospital personnel to provide immediate care in triage type situations.
Is the emergency room the only entrance into that hospital?
No, you can come, there's an entrance off of Pembroke Road, and there's an entrance off of 172.
And when you came to the scene, do you remember which side you went to first?
No, ma'am.
The time when you get to the hospital, you talked about speaking with Sergeant Bermudez. Who else did you see on scene?
A couple of the detectives were already there. Detective Bertrand, Detective Toyota was there. And then also a couple of the other sergeants, because we had 2 young males that were deceased, so prompted a lot of people to be called out to the scene.
Okay. And in terms of civilians, were there any civilians on scene when you got there?
At that point, I wasn't made aware of all the civilians on scene until after we had spoken with Cortlen Henry.
Okay. So you mentioned Cortlen Henry. Who is that?
Cortlen Henry is the driver of the vehicle, and he is also the co-defendant in this case.
And when you made contact with Mr. Henry, where was that?
They had him separate from everyone else. He was in a visiting a room, a treatment room. It was an actual hospital room with a door, not just a sliding shade. It actually was door, window, bed.
When you made contact with Mr. Henry, did you have any knowledge of the surveillance footage from the New Era studio that's been entered into evidence of State 7?
No, ma'am. At that point, I came into it blindly.
So how did you treat Mr. Henry?
He was a victim of a crime.
So the ladies and gentlemen of the jury have already heard the statement that you took. During the course of that statement, what things in that Mr. Henry said started setting off a little bit of alarm bells for you?
The biggest thing is where the crime allegedly had occurred. We were being told it was on Miramar Parkway, and we just west of Southwest 160th, closer to 172, in that area there. But when we had the area walked out, we didn't find any shell casings, didn't find any shards of glass, and you're in a residential. Yes, there is businesses there, but on the south side is residential. As many bullet holes there was in that car. Initially, I think I saw at least 10, and we didn't get a single phone call.
Okay. So when you were there on scene, did you look at the car that was out there? You said you saw at least 10 bullet holes?
Yes, ma'am.
Did you notice any damage to the rims or the tires of the vehicle?
No, ma'am.
Did Mr. Henry tell you about a side swiping of a curb?
He said that when a vehicle pulled up next to him and started shooting, he lowered his position in the vehicle for his safety, and he hit the curb. But there was some front end damage, but you could tell it was older front end damage.
Was that explained during the course of his statement? That's from a prior accident?
Yes, ma'am, I believe so.
In terms of the way you treated him, what were you taking into account?
He's a victim of a crime. And sometimes when you experience very traumatic situations, you're not going to remember everything. And it's understandable that you're going to be vague sometimes in your facts. And even if you're not from the area, you may be confused on the location. So our biggest thing was that we knew something happened. We knew it just didn't happen where they said it happened.
Why is it important for a law enforcement officer to know where something happened?
Well, we got an established venue, which has been for jurisdiction for us to investigate the crime.
Speaking of venue, in what city, county, and state is Memorial Miramar Hospital?
It's in the city of Miramar, county of Broward, state of Florida.
And at that point, when you're making contact with Cortlen Henry, does the name Jamell Demons come up in any way, shape, or form?
Yes, ma'am.
Is there any indication that he was in the car told to you at that point?
No, ma'am.
You mentioned at some point in the statement another shooting off of I-95.
Yes, ma'am.
What investigation did you do to see how that was potentially related to this case?
I was able to get a hold of the detective on scene, which is Detective Curcio from Broward Sheriff's Office, and I was able to compare notes and discuss and figure out that shooting was definitely not related to our shooting. They even had a weapon left on scene, which was, I believe, an assault-style rifle, and we was able to determine that was not related to us.
In terms of, were you able to determine if different caliber weapons were used in those two shootings?
To the best of my recollection, there was different calibers, and at the end of the day, I know they made an arrest on that, and their facts didn't even match up to our facts.
So going on to potential suspects that Mr. Henry gave you, does he mention anyone or point the finger at anybody at that point?
I think he mentioned one name. They may have had some beef up from Vero, from some guy named Bentley or something like that, but nothing that we could verify.
And in terms of the beef with Bentley, did he say if it was ended?
I believe his statement, he said it was taken care of, it was squashed.
With regards to an incident at Walmart, were you informed about a potential suspect there?
Yes, there was an incident a few months back at Walmart. I think during his statements, he said first the fight took place inside and it was outside, but I guess the necklace was stolen. It was posted online. But it didn't seem that anything really came of that either.
Okay, so Detective Moretti, based on your training and experience, have you had the opportunity to respond to various Walmarts across South Florida?
Yes.
Have you done criminal investigations regarding incidents or crimes that have occurred at those Walmarts?
Yes.
Based on that, do you know how long Walmart keeps video for?
Traditionally 30 days.
And in terms of the time period that was being described to you, was that within the 30 days?
It was way beyond 30 days.
So going back to that morning, did you go with Mr. Henry in the car with Detective Toyota to find out where this incident had happened?
No, Mr. Henry rode with Detective Toyota. It was just them two in the car.
And in terms of the evidence or anything that was reported back to you as the lead detective in this case that was recovered from the street surface of Miramar Parkway between I-75 and 184th?
There was no evidence recovered at all.
So, knowing that you had this location, are there businesses along Miramar Parkway that have surveillance footage?
Yes.
Were you able to go to some of those and retrieve some of that surveillance footage?
Yes.
So I'm going to start with what's been marked as the state's quadruple L, which is a composite of two photos. Counsel, you have a copy? Detective Moretti, I'm showing you a composite of two images which have been labeled as state triple L. Do you recognize those two photos?
Yes, ma'am.
How do you recognize those two photos?
These are snapshots of the video from the McDonald's, the corner of 172 and Miramar Parkway.
And how do you recognize those?
Well, I'm the one that retrieved the video myself personally. But you can see at 3:46 a.m. you see a red vehicle going by, a red SUV, and then at 3:46:57 you see a silver SUV going by, which was consistent with the two vehicles.
Well, before we get into that, do those photos fairly and accurately depict the video that you took from the McDonald's on October 26th of 2018 are those two screenshots from the video that cover the time frame of this incident?
Yes, ma'am.
Have they been altered or changed in any way?
No, ma'am.
All right, this time the state would request Ms. States Procedural L in as States 84.
Any objection?
No.
You're admitted.
States quadruple L will be marked States 84.
And permission to publish, Your Honor?
You may.
Starting at States 84, page 1, which is 10/26/2018, 34650.040. Detective Moretti, the screen in front of you is a touch screen, so I'm going to zoom in on the picture a little bit. And can you show the ladies and gentlemen of the jury what area of the screen you were talking about?
Right.
If you move, it should show the cursor a little bit better.
Okay.
And so what color did that vehicle appear to be?
Red.
And keeping it in the same location. Moving on to page 2, 34657.840. Is that same circle around the vehicle that was in question in this photograph?
Yes, ma'am.
And was that appear to be a darker colored vehicle?
Yes, ma'am.
At what point did you learn about New Era Studios?
When we spoke with Mr. Henry, he informed us that they just came from the recording studios in Fort Lauderdale. And so two of our detectives then responded there, Detective Bertrand and Detective Toyota, to retrieve the video, or just to go there to see what evidence they could recover.
Okay. Once the video was recovered, did you review it?
Yes, ma'am.
Okay. Approximately how far is it from the New Era 805 Northeast 4th Avenue in Fort Lauderdale to the Sunset Lakes 40th Street Guardhouse?
30 miles.
And have you had the opportunity to drive that distance or that route before?
Yes, ma'am.
With regards to the studio video, what's been admitted as State 7, did you review this before or after the search warrant was conducted on the Jeep?
This was before.
Okay. So going to channel 4, 2:17:42 starting time. Fast forwarding here till 2:18:40. Were any man purses, satchels found in that gray Jeep?
No, ma'am.
Specifically, the beige one that's pictured at 2:18:40.
No, ma'am, we did not recover that.
Continuing forward to 2:19:05. Was a black satchel recovered?
No, ma'am.
Specifically the one that is seen in the individual in the black and white jacket?
Correct.
Okay. Did Mr. Henry have possession of either of those satchels or man purses at the hospital?
No, ma'am.
So after you learn about the studio video, do you have an occasion to respond to a location that's identified as 18521 Southwest 44th Street?
Yes, we went to that before the video was recovered. That was the location where the defendant was residing at the time.
And who else did you know lived there at that time?
I believe the defendant, co-defendant, Mr. Henry, Mr. Mills, Mr. Davis, Mr. Glass. I believe they were all living there, as well as the victims.
And in terms of the location of that address, do you know the name of the subdivision it's in?
I believe that's Sunset Lakes.
And where is Sunset Lakes? What city?
City of Miramar.
When you went to that 18521 Southwest 44th address, did you go inside?
No, ma'am.
Can you tell the ladies and gentlemen of the jury what it was like when you first got to that location?
At that point, we had already cleared from the hospital. It was probably, the sun was already coming up, so, maybe 7, 8 o'clock in the morning, maybe even a little bit later. We went, there was no cars in the driveway. We went to the front door, knocked, looked in the windows. We didn't see anyone.
While you were on scene, did a vehicle pull up?
Yes.
What vehicle was that?
It's the red Mitsubishi.
And who was in that?
Driving it was Dontavius Withers and Adrian Davis.
Did you make contact with them?
Yes.
Without going into what they said, were you able to get a phone number from each of them?
Yes.
Did you see the defendant, Jamell Demons, there at that time?
No, ma'am.
Were you invited into the house?
No, ma'am.
Okay. In terms of the McDonald's video, when time and the continuity of when you did things, when did you go to McDonald's?
I believe that I went to McDonald's the week, this happened on a Friday or Saturday morning, and I was at McDonald's Monday morning.
Okay. So I'm going to go now to, on October 26th, did you do any additional evidence collection or interviewing of any individuals?
On the 26th?
Yes.
No, I just wrote the search warrant for the Jeep.
Okay. While you were at the hospital, you mentioned that you didn't see civilians when you first got there.
Correct.
Were there any civilians that you made contact with before you left?
Yes.
And who would those be?
There was some of the victim's family there, some of the Phillips family.
No, neither victim has the last name Phillips. You'll have to identify who those are.
The Phillips family was with Chris Thomas's family.
Okay.
There was also I didn't make contact with him. Detective Bertrand did. Trayvon Glass, an Andrew, I forget his last name. He was there. I made contact with the defendant's mother, Jamie King.
Okay. And after you left the hospital and made contact with those individuals, did you do anything else other than writing the warrant and executing the warrant on the gray Jeep?
No, ma'am.
Explain to the ladies and gentlemen of the jury what you have to do to write a search warrant.
The search warrant is based upon probable cause. There's an affidavit, like an application, and then there's the actual warrant. We write the warrant, the application, the affidavit, and then we send it to a state attorney. We find when the state attorney is on duty. Hopefully we get the way from up early in the morning because we're up. So we send the warrant to them, they review it, and then if they approve it, then it goes to the judge. The judge will then sign it. At this point, we're doing electronic warrant, so we could submit it electronically.
And in terms of the search of the Jeep, can you start searching it while you're waiting for the judge?
No.
Why not?
Because we don't have authorization to go into the Jeep. And we secure it, we can take it, we can hold it, but until that warrant is signed, we cannot touch that vehicle.
So after the warrant is signed, it's executed. Are you present for the execution of that search warrant?
Yes.
Why?
I actually have to read the warrant to the vehicle. I know that sounds very strange. It's one of those procedures that's been done for years. I can never explain it, but if it's a house, we have to read it to the house. If it's a vehicle, we read it to the vehicle.
Is that why we see you holding papers with all these warrants?
Yes.
So after you read the warrant aloud and tell the people that are assisting you what you're looking for, What is your role while the warrant's being executed?
I step back. I don't get involved in that process.
Do you collect evidence at that point?
No, ma'am.
Do you indicate which areas may be of interest for evidence collection?
I'll point out that this is who was sitting where. This is what we have, but that's their area of expertise.
After that warrant is executed on the gray Jeep, when are you made aware of the casing that's found in the back seat?
That night, when they collected it.
And going forward to October 27th of 2018, did you leave Broward County and travel to meet with other witnesses?
Yes, ma'am.
Where did you go?
We went up to Vero Beach, into Gifford, to make contact with some of the victims' family.
Okay. Did you have an opportunity to, without going into what was said, see Adrian Davis again?
I saw Adrian Davis again. We saw Dontavius Withers again. I believe we saw Chris Thomas Sr. And I think if I'm not mistaken, the girlfriend of Chris Thomas as well.
Was there an occasion in which the application Snapchat was brought up?
Yes.
As a result of learning about a Snapchat, did you author a warrant for Snapchat?
Yes, ma'am.
So when you authored the warrant for Snapchat, which has already been admitted into evidence in various states, what were you looking for?
I was looking for communications between Jamell Demons and Dontavius Withers.
And what were those communications supposedly going to show?
The communication was supposed to show that Jamell Demons sent a message.
Can we approach?
Ladies and gentlemen, I just want to clarify one thing. Prior to trial, I mispronounced the defendant's name. It's pronounced Demons, D-E-M-O-N-S. Lemons with a D is the way it was explained to me. And I know it's been pronounced different ways here, but it's pronounced Demons. All right? Detective, all right? Demons?
Yes, Your Honor.
Thank you. Proceed.
Okay, so going into what's been previously offered into evidence as State 61. The account information, if you could publish what this says, and I'm trying to make it as big as possible, as to who owned this particular Snapchat account.
Okay.
You could read?
Yes, this is the display name is Melly Montana. The email address associated with is mellymontana@icloud.com. The phone number is 772-713-9807. And I guess I think they call it the vanity name YNW Melly.
Okay. And is that display name as it's indicated here?
Yes.
And in terms of the IP history, did you do any additional investigation or research into the IPs that were provided?
No.
Going into the...
I'm sorry.
Is there objection?
There's no objection, but we need the rest of it.
All right. Ladies and gentlemen, I'm sorry. We'll take a short recess. Do not discuss the case. Don't form any opinion about the case. Don't allow anyone to discuss the case in the present. Certainly no research. Just leave your notepad on your chairs. Thank you. Thank you. Let the record reflect the jury stepped out. Counsel Mann along with the defendant. Do you need to write break? Can you arrange that?
Yes, sir.
Mr. Demons?
Yes.
Thank you.
And I apologize for interrupting.
Oh, no problem.
I'm going to show you how to clear this down.
We apologize for pronouncing his name wrong. Sidebar.
You make everywhere you look has to be predetermined to prove your case and your theme. So the theme here is what?
I think the theme is here that Melly killed two of his best friends growing up, and I think that the forensic evidence was pretty powerful, in terms of them putting the forensics on. It made it hard for me to believe that he wasn't somehow involved. I mean, I think at the end of the day, we know that he was sitting in the seat that we saw him get into on the video when they left the studio. And I thought that, the use of the dowel rods was pretty, that's old school. I think they're using lasers these days, but like the dowel rods, in terms of the angles, it was compelling evidence. I think that I probably would have ended on that with that type of stuff, because if this guy's the last witness, then we're not going to hear that statement that you were talking about from the snaps. And that is ultimately, you are definitely going to hear about that in the defense's case in chief, and you're certainly going to hear about it in the closings.
Yeah, but you know what, Bob, and you and I have been around the trial, so is Christy with the dowel rods. I've had a lot of cases with them. They're shooting in the back of the neck, but all somebody had to do was turn like this, and then the shot comes from someplace else, and if the bullet's not found. So I assume the defense is going to go there if they have an expert witness talking about it. But we'll see. We're going to take a break, and when we come back, we'll be back to the scintillating testimony in the courtroom as the prosecution seeks to end their case on a strong note. Welcome back to Law and Crime. I'm Linda Kenny Bodden. Well, we're in the case of Florida versus Jamell Demons. Who is he? YNW Melly, the rapper who has about 10 million view fans on Spotify. People watch him, listen to him, and looking at his trial where he is accused of the double homicide, shooting two of his friends in the YNW collaborative network. That's Juvy and Sakchaser. Well, the prosecution is seeking to close out their case soon by showing that YNW Melly was at the scene of the shooting at the time his friends died, by putting his cell phone there, by putting him as the owner of the cell phone and putting the cell phone in his possession. And to do so, they're about to present a number of 50 more photos, 24 videos through their lead detective, that's Mark Moretti. So let's go into court and listen how they do this.
Who is that?
Cortlen Henry is the driver of the vehicle, and he is also the co-defendant in this case.
And when you made contact with Mr. Henry, where was that?
They had him separate from everyone else. He was in a visiting a room, a treatment room. It was an actual hospital room with a door, not just a sliding shade. It actually was door, window, bed.
When you made contact with Mr. Henry, did you have any knowledge of the surveillance footage that's been in from the New Era studio that's been entered into evidence of State 7?
No, ma'am. At that point, I came into it blindly.
So how did you treat Mr. Henry?
He was a victim of a crime.
So the ladies and gentlemen of the jury have already heard the statement that you took. During the course of that statement, what things in that Mr. Henry said started setting off a little bit of alarm bells for you?
The biggest thing is where the crime allegedly had occurred. We were being told it was on Miramar Parkway, just west of Southwest 160th, closer to 172, in that area there. But when we had the area walked out, we didn't find any shell casings, didn't find any shards of glass, and you're in a residential. Yes, there's businesses there, but on the south side is residential. As many bullet holes there was in that car. Initially, I think I saw at least 10, and we didn't get a single phone call.
Okay. So when you were there on scene, did you look at the car that was out there? You said you saw at least 10 bullet holes?
Yes, ma'am.
Did you notice any damage to the rims or the tires of the vehicle?
No, ma'am.
Did Mr. Henry tell you about a side swiping of a curb?
He said that when a vehicle pulled up next to him and started shooting, he lowered his position in the vehicle for his safety, and he hit the curb. But there was some front end damage, but you could tell it was older front end damage.
Was that explained during the course of his statement? That's from a prior accident?
Yes, ma'am, I believe so.
In terms of the way you treated him, what were you taking into account?
He's a victim of a crime. And sometimes when you experience very traumatic situations, you're not going to remember everything. And it's understandable that you're going to be vague sometimes in your facts. And even if you're not from the area, you may be confused on the location. So our biggest thing was that we knew something happened. We knew it just didn't happen where they said it happened.
Why is it important for a law enforcement officer to know where something happened?
Well, we got an established venue, which is then for jurisdiction for us to investigate the crime.
Speaking of venue, in what city, county, and state is Memorial Miramar Hospital?
Jury entering.
Ladies and gentlemen, thank you. Please be seated. Let the record once again reflect the presence of our jury, the defendant, the judges, the counsel, the assistant state attorney, our witness protection, Mark Moretti, remain on the stand. Bradley, I think you're still on your direct examination. If you're ready, you may proceed.
Thank you, Your Honor. Okay, Detective Moretti, we had started talking about the Snapchat records. Before we go in and publish the rest of those, in your investigation, were you able to determine nicknames and legal names for various individuals that are involved in this case?
Yes, ma'am.
So starting with the defendant, did he have a nickname that he was commonly referred to as?
The, Melly.
Okay. Hold the microphone, it got pushed away. Thank you.
On Williams' phone, he was known as Smurf. I'm sorry, on Williams' phone, he was known as Slim.
Okay.
Some various other names.
So in terms of for Cortlen Henry, did he have a nickname you learned during the course of this case?
Yes, Cortlen Henry actually went by the name of Bortlen.
Okay. And for Mariah Hamilton, did she have a nickname?
The one most commonly used was Riri.
So in going through the messages, I'm going to zoom out just a little bit on this. Like for example, Friday, November 9th, 2032-05 UTC. What is the difference between UTC time and November of 2018 post time change?
It's UTC is Universal Time Code, which is 5 hours ahead of our current time zone.
And that's in November. What about in October? What was the difference before the time change?
It was 4 hours time difference. I think the time change, the actual date was November 4th.
Okay. So in terms of this message, there's a lot of kind of gibberish characters at the end after it says kill me. What are those gibberish characters?
Usually those are emojis that when it's printed, that's how it looks on paper.
Okay. And so I'm going to make sure we understand, and that it's clear to ladies and gentlemen of the jury, what these columns each stand for. So starting with the far left column, what is that column?
Is the ID column, I guess the two accounts that are speaking with each other.
Okay. The next column, what is it?
It's the from, that's to be the sender, and then the next column is to, which would be the receiver of the message.
Okay, and then under where it says body?
That is the actual message.
And over here on timestamp, what would that reflect in that last column?
That was in the actual time that the message was sent in UTC, and you would just subtract 5 hours off of that. That's okay.
Okay. I'm not going to make you do the math right now because that's we'll get to that in a second. So I want to go to October 26th of 2018. Were there any messages captured as part of the search warrant on October 26th, 2018?
No, ma'am.
In terms of the message here on Tuesday, October 23rd, who is identifying themselves as using this Snapchat account?
The name being used is Melly.
Okay. So were you able to determine who was Dat Baby 01?
Yes, that was Mariah Hamilton.
How could you tell that?
The context of the conversation between them two, as well as interviewing Miss Hamilton.
Were there pictures that were sent back and forth that also included her photograph in these?
Leading.
Overall.
Yes, there was photographs between it as well.
So going to this message here, which is Friday, November 9th, 2023, 12 UTC, 2018. Now I am going to ask you to do the subtract 5 math on that one.
What you see there is 2023 UTC, which would be 8:23 UTC PM time. However, but transferring it back to Eastern Standard Time, it would be 3:23 PM.
And what I'm going to do here, so it's clear on the columns again, go back to the first page of the chat. So this message is going to the defendant's account.
Correct.
Okay. What does Ms. Hamilton say to the defendant?
Objection. Document speaks for itself.
So he can read it and publish it?
Overruled.
Like I said before, your stupid ass blocked me. You move very effing funny. TF. We know what that means. BITCH. You know what that wasn't taped on that girl page, but your dumbass just lie about everything. I peep every effing thing, and I always watch how a MF move, and this is how you've gone move, bitch. I'm not going to come around no more, period. Don't post me on your damn Snapchat if you're scared to post me on your Instagram for your bitches, period. TF. And I won't go to another show neither. Be trying to have Bortlen go to the shows with you so you can bring bitches and shit back to the hotel. Everything is so cool. I peep everything. You're one sneaky lying bitch boy. F you. I'm standing on my shit this time. Bet you won't hear from me again after today. And then there's 3 emojis, which doesn't translate when you put it in.
May we approach?
Yes.
proceed, please?
Yes. Okay, so we were continuing on. We had just published November 23/12. So going to 20/24/17. We can just stay in UTC so you don't have to keep doing.
Thank you. I'm sorry, what's the date of that message?
November 9th.
Same objection.
Thank you. Objection notice overruled.
So with regards to, again, using the first page, so it's clear as to who is from and to, the author of this message on 20/24/17, who is that from?
It's from Melly, Montana to Dead Baby B01.
Okay. Then the next message from that Melly, Montana, and this is November 9th, 2018, 20:25:19 UTC for counsel.
Judges, may I have a continuing objection so I don't have to interrupt the state on this?
That's fine, guys.
Thank you. Continuing objection.
Thank you.
And so what does Melly.Montana say to that individual on November 9th of 2018? I'm going to try and make it big, sorry.
No, that's fine. I just want to read it quickly before I use caution. Bitch, I'm not fit to leave board with Tao after what you stuck on me being with, but you think that's all I think about. This N-word saved my life. He's coming with a K everywhere with me, cuz with a K. If them crackers come grab him, it's my fault. You forgot 3 question marks.
So then I'm going to go, so it's clear. The messages chronologically, how do they go in this exhibit?
They go by the time frame, but you can see it's a sequential argument between 2 individuals, the same individuals.
So let me ask you a better question. The message here below that says 2025-39 is the message that's above it at 2027-26 prior to or after?
It's after.
Okay. So in terms of reading the sequence, do you go from the bottom of the page up?
From the bottom up.
Okay. So going now to the next message, again, November 9th, 2025, 39 UTC from Melly.Montana to that baby message. What does it say?
Dumbass ho, you so selfish and young-minded. Don't even think about what I'm going through.
Okay, and then moving on to the message from this November 9th, 2027 UTC, 2018.
Fuck ass ho, you don't. FWN, which means fuck with me. Anyways, you just use me like the rest to keep all that shit ho on God, on my mama. He was on her shit.
Okay. So, continue on to the next message from Melly, Montana, and this one is at November 9th, 2027-26 UTC. And that message here from Melly, Montana again, what does this one say?
You know I don't want Bort Brown yay like that stupid asshole.
The next message, which is then 2027-23 UTC for the record, from, again, Melly, Montana.
Shit deeper than just bitches.
So continuing up, moving on to Friday, November 9th, 2029-20 UTC, 2018. Message from Melly, Montana to, again, that baby. What does that one say?
You don't fuck with me anyways. I peeped it. You can slide, but God knows I wasn't in her shit. N-word will end real dumb. Breaking Your shit, you spoiled everything was given to you, you bitch. You act like a N-word, oh some bitch slide. I keep Bortlen with cuz at the end of the day, he did one of the realest shit in my life.
Okay. So this argument continues on, so you described it. So the response to that from Dat82 Melly Montana, which is on 20/30/26, Friday, November 9th, 2018. What is her response?
Oh, I am. Stop messaging. There's nothing else to say. Still peep everything, hun, and I says it's fine.
The response from Melly Montana on Friday, November 9th, 2030.
I try to pre-read it to make sure,
yes.
Cautious what I say. I'm gonna keep him with me. He ain't never say half the shit you said. I put you way before him at one point. He never said, none, bitch, stay away. You don't love nobody. For real, you heartless. I see it, bitch. Stay away, ho. You just want to break a N-word.
So going up to Friday, November 9th, 2031, UTC. Again, the from column, Melly Montana. What does that message state?
I'll real deal.
And then the next one here.
But you dropped 5.
My apologies, sorry. At the top.
And the end, never mind.
Okay. So then the response from Dat Baby on Friday, November 9th at 2018, 2032-05 UTC.
She responded, kill me with a question mark with some emojis that were unreadable.
Okay. So after you reviewed these Snapchat records, and you weren't able to confirm or deny anything about a Snapchat communication on October 26th, 2018, what was the next step in your investigation on, let's see, so that was October 27th, we had talked about in Vero Beach. I want to go to October 29th of 2018. What did you do in terms of search warrants on cell phone data?
I authored 2 search warrants, one to Sprint, one to T-Mobile. The Sprint one was to Dontavius Withers' cell phone, as well as one of the victims, Chris Thomas's.
Okay.
And then the other search warrant was for the phone of the defendant.
Objection. What's the objection?
Cause for hearsay. And they have not established a predicate that it's, in fact, our client's cell phone.
Which comes sidebar.
Detective Moretti, you indicated that you had done a search warrant to T-Mobile. Is that for the 772-713-9807 phone number?
Yes, ma'am.
Was that also done for a 954-248-9801 number?
Yes, ma'am.
Was that the correct number on the 9801?
This is the second time, yes.
Okay. So explain to the ladies and gentlemen of the jury what it means when you transpose the digit.
When I originally authored the warrant, I on the cell phone number for Anthony Williams. I transposed the last two digits, so the data came back. It was wrong.
Okay. Were you able to catch that mistake and fix it?
Yes.
You make mistakes. You're a human being.
I make mistakes. I'll continue to make mistakes. Not perfect. Never said I was.
Okay. So once you, on October 29th, you analyze the you do the warrants for the cell phone data.
Yes.
You get it right away like that?
No.
Okay. Explain to the ladies and gentlemen of the jury about when you first got some of that data back.
We first, at the time, Sprint and T-Mobile were two separate entities. They have now since combined. We traditionally got Sprint back quicker. I think we got it back within a week. I think it took about 2 weeks for the other number, for the T-Mobile providers. So when we first got the Sprint records back, at the time, Sprint just wasn't as accurate as T-Mobile was.
Okay. In terms of, do you mean accurate or precise?
More precise. I mean, T-Mobile has the true timing of ants, which at the time Sprint was using per call measurement data, but we didn't have a lot of per call measurement data, which is distance and angle from the tower to the device, which is just estimated.
So when you get the Sprint data, do you have any idea of how far away a particular device may have been from the tower?
At that time, no.
In terms of what information were you able to glean from the Sprint data as to where you need to start looking for your next potential lead?
It took us out to US 27 because the cell phone for Chris Thomas hit on the tower out on US 27 near Holiday Park, and that's where we started our.
So tell the ladies and gentlemen of the jury, when you went out to US 27, when you first got the Sprint records, what did you do?
I plotted it, analyzed the data. It took us out to US 27. Detective Bertrand and I actually walked 2 miles of US 27 because we were on 27 looking for anything, shards of glass, spent casings. We weren't near the crime scene at that point. We tried to, we went into the mobile home park, come across some people, never heard gunfire that night, didn't see anyone out there, not the vehicles, nothing.
Okay. So in terms of about what date was this that you were out walking on US 27?
It was about the first week of November, about November 7th or 9th, something like that.
Okay. So once you obtain the T-Mobile records, how does that refocus your investigation?
It was able to dial it in a little more specific. It was able to direct us out to US 27 in Pembroke Road.
Okay. When you first get the T-Mobile records, do you go through and verify and see some of the known locations? For example, the studio.
Yes.
So in terms of the T-Mobile records, I want to draw your attention to, and if I could bother Ms. Smith, be so kind as to get the T-Mobile records, which are in evidence. State 63. So, Detective Moretti, when you're looking at the information in the T-Mobile records, and I'm going to start by pulling up the 772-7103 records.
So I'm going to publish part of States 63, which has been previously admitted into evidence. We're going to go to 205-8127 records, the timing advance LTE. So going...
This is for which phone number?
772-713-9807. That's right up there at the top in tiny print.
Oh, okay.
Okay. So I want to go down for times on this one to 3:18 a.m. At 3:18 a.m., there's a latitude and a longitude that is listed on that particular item.
Yes, ma'am.
Do you, at that point, verify the studio video versus where that latitude and longitude is showing the network thinks the phone is?
It was, yes, it was within a block of the studio.
And has that been reduced to a map?
Yes, ma'am.
Okay. Showing defense counsel what's been marked as state quadruple M, what's been previously shown to defense counsel, all of these maps before we came in. Okay, Detective Moretti, I'm showing you it's been labeled as state's quadruple M. Do you recognize this? It's just two-sided. I'm sure it's just, yeah.
Okay. Yes, ma'am.
And how do you recognize this?
That is the map, Google map of the area where the recording studio is at.
Does this Google map fairly and accurately depict the latitude and longitude coordinate here at 318? 26.313371.
Yes, ma'am.
And negative 80.138733.
Yes, ma'am.
Any alterations or deletions?
No, ma'am.
Your Honor, at this time the state was requesting the state's quadruple M in as state 85.
Can I bog iron, please?
Sure.
State indicated no objection. You're more than welcome.
Detective, this is dealing with cell phone analysis, correct?
Yes, sir.
And primarily, can you get up? Primarily Cellhawk and Cellbright.
Two different devices. Cellbright is for the digital forensics examination of the cell phone, and Cellhawk is the platform we use to plot the actual CDRs and timing advance records.
And how many hours have you taken in training in those two areas?
The cell phones and the
Cellhawk and the Cellbright.
Probably well over 100 hours.
Okay, and have you received any certifications?
Certification from Cellhawk as well as from CASFIZ, which is what the FBI uses.
And have you ever trained other officers or supervised other people in digital forensic analysis?
On digital forensic analysis, no. Cell sites, yes.
And is there a particular process you follow when you conduct a cellular forensic examination?
You mean when we take data from the cellular device?
Yeah.
The once you
Objection outside the scope, Your Honor. We're not talking about the device yet.
I'm sidebar, second. Quiet, please.
Detective, can I approach the book? I can't read this.
Yes, sir.
You're reading merely off this chart, the latitude and longitude. Is that correct?
Correct.
You don't know how this was printed. In other words, how they determined the latitude and longitude.
How T-Mobile determines?
Yes.
No, I do not know how they produce it.
I renew my objection.
Anything else?
No.
Thank you. Objection notes overruled. Proceed.
So, Detective Moretti at this point, Your Honor, the state offers states quadruple M as states 85.
Any additional objections, counsel?
No, sir.
Objection notes overruled.
States quadruple M will be more states 85.
Okay. Permission to publish?
You may.
And so, Detective Moretti, this is it. I have the back of it shows the latitude and longitude on here, but that covers up quite a bit of the map. So after you have an opportunity to publish this, I'm going to switch it to the other side, which then just has the indication of the marker.
Okay, it's fine now.
So, Detective Moretti, in terms of the address that's previously been testified as 805 Northeast 4th Avenue. Where was that determined to be on this map? And you can, okay, is it drawing on there?
I'll get it.
And so did you personally go out to that location at various times during the course of this investigation?
Yes, ma'am.
Okay. So I want to go forward now. After you looked at that particular coordinate, I want to go to 335. Which is on this particular CDR, again, states 63 previously in evidence, line 127 of the 772-713-9807.
Yes, ma'am.
It's been previously shown to defense counsel, marked as state quadruple N.
I'm going to ask one question. Okay. With the court's permission, can I ask one question?
Yes, sir. Go ahead.
You're merely reading off this bill or this chart, correct?
Correct, sir.
You don't know how it was derived?
No, sir.
Same objection.
So, Detective, I'm showing you what's been previously marked as states quadruple N for identification purposes only.
It recognizes.
And then going back to the states quadruple N fairly and accurately depicts the latitude of 26.116584 and the latitude of negative 80.3241128.
Yes, ma'am.
Your Honor, and does this fairly and accurately depict the location of that on this map?
Yes, ma'am.
Here at this time, the state would move states quadruple N as states 86.
Any objection?
Same objection.
Thank you. Objection notes overruled. It'll be admitted.
Thank you.
States quadruple N will be marked states 86.
Detective Moretti, again showing you first
the coordinate with the latitude and longitude. And once you're able to kind of familiarize yourself with that, I will flip it over to the other side.
You can flip it.
Okay. And here on States 86, can you show the ladies and gentlemen of the jury where the whole camera is in the express lanes in this photo approximately? Sorry. And Detective Moretti, did you obtain camera footage from the Department of Transportation to cover this time of 3:35 a.m.?
Yes, ma'am.
So I want to continue forward now in your investigation to 3:47 a.m. Line 136 on this particular CDR for 772-713-9807.
What line? 136, you said?
136. Detective, I'm showing you what's been previously marked and shown to defense counsel as states quadruple O for identification purposes only. Do you recognize states quadruple O?
Yes, ma'am.
Does states quadruple O fairly and accurately depict the latitude of 25.977994 and the longitude of negative 80.374577 as depicted on line 136?
Correct.
At this time, the state would request to move states quadruple O in and publish.
Any objection?
May I ask the same question?
Go ahead.
You're just reading from that document, correct?
Yes, sir.
That you did not create, correct?
Correct.
And you have no idea how it was created?
Correct.
Objection.
Objection noted, overruled.
Okay, so publishing what is now states 87. Travis? 87?
87. Quadruple O will be marked states 87.
So, Detective Moretti, in terms of the location of this particular pin or GPS marker, are you familiar with this city it's in?
This is in the city of Miramar. This is Miramar Parkway and 172 Avenue.
Okay, so I'm going to go ahead and turn it over on the other side. Is there a fast food establishment located at the corner of 172nd Avenue and Miramar Parkway?
Yes, ma'am.
Could you please point that out for the ladies and gentlemen of the jury by circling it? And in terms of the photos that were previously introduced as states 82, are those from that same account?
Yes, ma'am.
So, Detective Moretti, I want to go forward during your investigation and go to what time has been listed as 3:53 a.m. That is line 145 of the 772-713-9807 CDR for defense counsel. Showing what's been previously marked as states quadruple P and shown to defense counsel prior to this afternoon's court session. Detective Moretti, do you recognize states quadruple P?
Yes, it's Hines Boulevard.
And does the latitude and longitude of 26.007627
and negative 80.411552 fairly and accurately depict the latitude and longitude on line 145 of the CDR in front of you?
Yes, ma'am.
Here at this time, the state would request to move into evidence as states quadruple P, as states 88.
Any objection?
Same objection, and I would be asking the same questions, which we all know would be his answers.
Any objection? No, it's overruled. It'll be admitted.
Okay.
States quadruple P with mark states 88.
88. Thank you.
So publishing states 88. Detective Moretti, in terms of the location that we are looking at right here, where is this, once you have this GPS pin?
Yes.
Okay, I'm going to go ahead and flip over to the other side. Again, the same map, just without the details on it.
You want me to identify the monastery school or just identify the GPS coordinates?
You read my mind. The Montessori Academy, please. Did you obtain video from the Montessori Academy?
Yes, ma'am.
Okay. Your Honor, at this time, the state would request to publish what's been previously admitted into evidence as states 80. 82.
I'm sorry, which is the 80 or 82?
82. Ms. Smith has the other line.
Yes, you may. It's in evidence.
Go ahead and switch to the other computer. It tends to work a little bit better. Moretti, is this the footage you obtained from the Montessori Academy?
Yes, ma'am.
Okay, and so starting at 3:52, or 3:53, my apologies, I'm going to publish from 3:53 through 4:20. Try to speak in influence. Detective Moretti, based on your familiarity with this area and this location, the video that says U.S. Tower East View, what direction, cardinal direction does it face?
It's facing towards the east, capturing vehicles going westbound.
Okay. And the bottom, the U.S. West parking, what road is it facing in what direction?
It's still facing Hines Boulevard. It's facing west. And it would actually capture vehicles going east and west, but it's more focused on vehicles going eastbound.
Okay. And so when you say more focused on vehicles going eastbound, you mean closer to the camera would be that step?
Yes, closer to the camera.
Detective Moretti, in reviewing this footage at 406, was there a dark colored vehicle traveling westbound?
Yes, ma'am.
Was there a red vehicle traveling westbound in connection with
East or west, no red vehicle was driving.
that was at 353 as well?
353 as well as 406, there was just the one solo vehicle traveling by itself.
includes publishing through 4:20 a.m. So going back to our 772-713-9807 CDR. You had just talked about 3:53 a.m. in line 145. I want to skip ahead to 406, and we'll come back to 403 in just a minute. So 406 is here in line 156. That's been labeled as state's quadruple Q for identification purposes. It's previously shown to the defense counsel. Detective Moretti, I'm showing you it's been marked as state's triple Q for identification purposes only. Straight state's triple Q. What is that?
This is Pines Boulevard and 196th Avenue.
Okay. So is the latitude and longitude reflected on state's triple Q of 26.010021 and negative 80.408839?
Yes, ma'am.
Accurately reflect the line 156 of the CDR we've been looking at?
Yes, ma'am.
And does that point on the map accurately and fairly depict where that location is in the world?
Yes, ma'am.
Here at this time, the state would request to move state's quadruple Q in as state's 89.
Any objection?
I know it's shocking, but the same objection.
Noted, overruled. Will be admitted.
And permission to publish?
You may.
Okay, and Detective, this is a 4:06 a.m. If you would be so kind as to show the Montessori Academy again. So I want to go back now to 4:03 a.m., which is highlighted in line 154 of this CDR, or timing advance from T-Mobile for 772-713-9807. Do you know how the environment data is done on this CDR?
Are you asking how T-Mobile produces it?
Yes.
Basically, it's from what it's determining, or it's interpreting the location of the phone based upon its environment. And it either says mobile, outdoor stationary.
Objection. May we approach?
Yes. show, I need a few minutes with the attorneys. Don't discuss the case. Don't form any opinion about the case. Don't allow anyone to discuss the case. No research, no heads on your chair. Thank you. Sure, we're in recess for a minute. Mr. Demons, need a restroom break?
Yes, sir. Yes, sir.
Range up one. Thank you. We're in recess. This is the attorneys, the witnesses on the stand, and the jury's in the jury room. So, counsel, why don't you go step by step and just explain to me what we're doing?
Sure. What I have also is an additional item from State 63 on the screen, Your Honor. This is the definitions page provided by T-Mobile and was introduced as part of the records in this case, where it explains exactly what each column means. And then here, for example, column 5, environment, indicates whether the call was determined to be indoor, mobile, or outdoor stationary.
Okay. So, as to what the witness is going to say about the new coordinates here, I think you said it was at 4:03 a.m. on phone 9807, the last 4 digits.
Yes, sir.
And at that location, where is this going to be at?
That location is going to be at Pembroke Road in US 27.
And
approximately 100 meters, 100 feet.
The 9807 number was 400 feet from the crime scene, and Anthony Williams' phone was 100 meters from the scene.
And you're saying that, going back to the first exhibit you had on the location there, you are saying that on one of these lines it basically indicates
Yes, Your Honor.
Under environment, line 5.
154, which is the coordinates that I just showed you, what's been marked as states quadruple R for identification, the Pembroke Road in US 27. That is the outdoor stationary notification that the T-Mobile network is saying as to the location of the phone.
Thank you. And your objection is?
Our objection is that the FBI agent Brendan Collins testified that not only can he not give an accurate location, but cannot tell and does not use the environment as absolutely unreliable. And the reason they brought in the FBI agent, so the court knows later down the line, and listed him and brought him in late in the case, several years, I believe, later, is because they realized that the individual, specifically this detective, was not qualified to testify to the items that the court that the state is now inquiring. And that was the sole purpose of adding him late in the game and making us take his deposition rather late in the game. I mean, that's what the FBI agent testified to. The environment is absolutely unreliable. He doesn't even know how it works. And they never, ever use it in any jurisdiction that the FBI is working on. And the mere fact that that prints, whatever it prints, means nothing.
Judge, could I ask for 5 minutes just to find in the transcripts where he did it so I can direct the court directly to where the FBI agent testified, not only in trial?
Go right ahead.
Thank you.
Can we be in recess during that period of time?
Yeah, I'm just trying to think of, is there anything else you want to share with me, Ms. Bratton?
No, Your Honor, not at this point.
All right, so we'll be in recess. You show me what you're talking about in the transcript of the Brendan Collins.
Thank you, Judge.
I think so, but I think what Natalie said is true. I mean, I think there's shifting loyalties here. It's sort of we're dancing around something, but we don't exactly see what it is. And so because of that, there's still room to argue it both ways.
All right, it remains to be seen what happens next, but we're going to find out at the top of the hour. I do want to thank Dr. Bulber for joining us. Great analysis. And Natalie, you're going to stick around here with me. We're going to take a quick break here on Law and Crime, but much more ahead down in Florida as more of the YNW Melly trial continues. Stay with us.
Did you find it yet, Counsel?
Judge, not specifically on that point. I know I did ask if the court wants to see from the deposition transcript. That question was very clearly asked because when
I've got a note here that when Agent Brennan Collins from the FBI testified, he did indicate that he said he can testify as to records are consistent with time and date are critical. He goes on a host of things that he was discussing, but when it came to environmental issues, he said it can affect the calculation meters, not miles, a small deviation.
Your Honor, I think that was in regards to foliage, meteorological issues and things like that. That was the environment. In terms of this particular on the environment data or column, my recollection is that this was not asked on cross by Ms. Liberty, but that he said he does not rely upon this in doing his calculations. However, you could look at other collateral sources and corroborate whether this was or was not accurate.
Your Honor, may I? The mere fact that this is burden shifting. The burden is on the proponent of the evidence to establish its authenticity and that it is what it purports to be. The mere fact that the state is saying that the defense hasn't showed that it's not reliable is in fact an admission that the state has not shown that it is. And the only evidence that they're pointing to is a hearsay out-of-court statement by somebody at T-Mobile purporting to describe how it works and not even giving any indication as to the reliability of that that is pertinent to our objection here, which is how are you telling whether the person is inside or outside? I have one of these apps to track my daughter's movement. She's 2 blocks down the road at a friend. It's saying that she's at the house. So this whole notion, one, that it is precise, and two, that it can tell with specificity and reliability sufficient for a jury to rely upon it in a murder case, that you are inside or outside when they have no expert laying that predicate. And it is required of them to do so before attempting through this witness to muscling that information under the guise of it being accurate when it in fact is not. And if they had a witness who could establish that it was, one, they should find that witness, and two, they should present it before trying to present this information. They can't just say, well, the T-Mobile records say it, because one, it doesn't say it, and two, even if it did say it, it does not establish its reliability.
Hold on.
Yes, sir.
Anything else?
No, Your Honor.
All right. Counsel, respectfully, I overrule the objection. It appears to me that that's all filed for cross-examination. This is all part of the document that's in evidence. The document says what it says, and so objection notice overruled. Can we get the jury back in?
Jurors entering.
Ladies and gentlemen, thank you. Please be seated. The record once again reflects the presence of our jury, the defendant, Mr. Demons, his counsel, the state attorney, the witness remains on the stand. Counsel, if you would proceed, please.
Thank you. Okay. So, Detective Moretti, we're now going to line 154, and that is at 4:03 a.m., 10/26/2018. We were talking briefly about the environment column on line 154, the environment column under D. What does it say?
Outdoor stationery.
So I'm now approaching with what's been marked as state quadruple R for identification purposes and previously shown to defense. Do you recognize this?
Yes, ma'am.
Does state quadruple R fairly and accurately depict the latitude and longitude here on line 154 of 25.993063 and negative 80.428081?
Yes, ma'am.
And is that an accurate location as to where that GPS point is in the world?
Yes, ma'am.
Here at this time, the state would request to move into evidence state quadruple R as state 90.
Any objection not previously raised?
Not previously raised.
Thank you. Objection not overruled.
States
It'll be admitted.
quadruple R will be marked states 90.
So Detective Moretti, I want to go here to publishing states 90. Once you have your bearings on this, this point from the 9807 phone, I'm going to switch over to the other side, at 4:03 a.m. What area does this depict?
This is the actual crime scene on US 27 and Pembroke Road.
And approximately where along Pembroke Road on this map were those casings discovered?
It was on the south side of the road, about 820 meters from US 27. 820 feet from US 27, and approximately where the GPS coordinate is at.
Okay. So I want to talk a little bit about the next point in the map. I'm going to turn this to its home. So going forward now to 4:42 a.m. That is line 185 for defense counsel, showing what's been previously marked as state quadruple S and shown to defense counsel prior for identification purposes only. Showing you states quadruple S for identification. Detective Moretti, do you recognize that?
It is Pembroke Road and Southwest 178 Avenue, which is in our jurisdiction of Miramar.
Does the latitude of 25.989873 and longitude of negative 80.386462 fairly and accurately depict the latitude and longitude from line 185 of the 772-713-9007 cell phone records?
Yes, ma'am.
Here at this time, the state would request to move state quadruple S in and publish for the jury.
Any objection?
Same objection.
Overruled. It'll be admitted.
The states quadruple S will be marked states 91.
Okay. So Detective Moretti first showing with the information on the back. And then publishing on just the point. So Detective Moretti, can you describe to the ladies and gentlemen of the jury what is Southwest 178th Avenue south of Pembroke Road?
It's a subdevelopment. It's called Silver Lakes within the city of Miramar. The area we're looking at is south of Pembroke Road.
And you said it's a development. Is that commercial or residential?
Residential development.
And so this was 4:42 a.m. forward and showing what's been marked as state quadruple T. It's been previously shown to defense counsel on that for identification purposes only, as well as approaching with states 71. Let me show defense counsel on state 71.
State 71, page 20.
First, showing you as part of State 71, page 20. In blue, there is an address in that message. Can you read that address aloud?
3220 Southwest 192nd Avenue, Miramar, Florida 33029.
And in terms of showing you now what's been marked as state quadruple T for identification purposes only. I'll show you all of the exhibit first and then ask you a couple questions.
Okay.
So Detective Moretti, I'm going to go forward now to 8:46 a.m. which is reflected on line 315 of this CDR. It states what's been marked for identification as states quadruple T. Fairly and accurately identify the latitude and longitude of 25.977759 and negative 80.405479 on the blue dot.
Yes, ma'am.
Does states what's been marked as for identification as states quadruple T fairly and accurately identify the location of 3220 Southwest 192nd Avenue, Miramar, Florida, on that map?
Yes, ma'am.
And do those fairly and accurately depict those locations in Miramar, Florida?
Yes, ma'am.
Here at this time, the state would request to move in states quadruple T as states 92.
Same objection?
Same objection.
Overruled. It'll be admitted.
States quadruple T will be marked states 92.
So I'm going to take back states 71 again. And publishing for the ladies and gentlemen of the jury, the address that you just read aloud. And Detective Moretti, if you'd be so kind as to say the date and time that address and message were sent and read.
It was let's see, it was read sent on 4:45, 4:46 a.m. and actually. Okay, it was sent on 10/26/2018 at 4:45:46 a.m. and it was read on 4:45:50 a.m.
Okay. So now going to states 92. First showing that same address. And so it's clear for the record. The address on this map is indicated by what color pinpoint?
Green.
Okay. Going now to the latitude and longitude that we previously discussed.
And it is blue.
Okay. And so now to take them without the okay. Detective Moretti, in terms of the address that we just talked about, that 3220 address, what subdevelopment was that located in?
That was in Sunset Lakes.
Is that the same subdivision as that 18541 address we talked about earlier today?
It's the same development, but not the actual same sub-community.
Approximately how far apart are they?
They're about maybe less than a mile apart.
After you reviewed these coordinates and had some idea of a path of travel and location, did you go and try and locate any other surveillance footage that would be useful in the presentation of this case?
We got the video from the Turnpike, from 595.
Okay.
We got the video from the McDonald's. There was a video from the Monastery School. We were on US 27 looking for video, which we did not recover any.
Okay. In terms of the cameras on US 27, what did you learn about those?
It was much to our surprise that those cameras do not record.
And so the initial date of when you obtained the T-Mobile records, do you recall what date that was?
I believe it was, the initial records was the 9th of November.
Okay. So after November 9th, you obtained the Montessori School footage?
Yes, ma'am.
Prior to getting those T-Mobile records, did you have any indication that Pines Boulevard was an area where you should be looking for video surveillance?
Prior to the T-Mobile records?
Prior to the T-Mobile?
No, ma'am.
Okay. So after you got the T-Mobile, did you look for other video on Pines Boulevard or assign someone to do so on the east side of 172nd?
Yes, ma'am.
Were they successful in obtaining any footage?
No, ma'am.
Okay. Going forward on November 21st, did you have the opportunity to respond out to the location of Pembroke Road and US 27?
Yes, ma'am.
Can you describe to the ladies and gentlemen of the jury a little bit of the geography of that location?
It's an isolated road in the Everglades off of US 27. There's not a lot out there. There's a waste management dump. It's not well lit. And if you travel in the middle of the night, it's dark. The roads aren't identified. No street lamps. It's a very desolate place in the middle of the Everglades.
In terms of when you were getting there on the west side of US 27, what terrain features are there?
On the west side of US 27 is a canal that runs north and south, and that is marshy swamp areas.
Okay. To get on going now, describe to the ladies and gentlemen of the jury, 208th Avenue. Where does that road run?
It runs north and south. It connects Pembroke Road to Pines Boulevard. However, on each side, north and south, there is a gate that prohibits any travel.
Okay. Do you know what is located on that street as to why it is?
The Fire Training Academy is located up there.
Okay. And what jurisdiction is between Pines and Pembroke Road?
Their jurisdiction, Pembroke Pines jurisdiction starts in the middle of Pembroke Road. We have the south side of Pembroke Road. They have the north side of Pembroke Road, and the line in between, the yellow line in between divides our two cities.
Okay. So now you talked about, so on US 27 going now from west to east on Pembroke Road. What's on either side of the road?
On Pembroke Road, it's marshy swamp area. There's absolutely nothing there.
When you get to the far eastern edge of Pembroke Road, when you access it from US 27, is that open to the public?
No, it's a closed area because of the waste management dump out there, and it doesn't even connect all the way through. It goes maybe another quarter mile in, and then it's the entrance to the dump, and that's it.
Okay. Is there a gate at the entrance to the waste management facility?
Yes, ma'am.
Is there an additional gate at the far western end of Pembroke Road? I'm sorry, the eastern end of the western part.
Yes.
Would it be more helpful if I showed you a map to describe these?
Yes, ma'am.
Showing defense counsel what's been previously marked as states quadruple U. Detective Moretti, I'm showing you what's been previously marked as states quadruple U. So don't trust the jury just yet. Sorry. Do you recognize that map?
Yes, ma'am.
Does that map fairly and accurately depict the geographical location you just described?
Yes, ma'am.
Here at this time, the state would request to move state quadruple U in as states 93.
Any objection? No. It's admitted. What's the number, Travis?
93.
Thank you.
Okay, Detective Moretti, I'm going to put this up here to publish. And so we're going to start over here on US 27. Could you indicate on the map up ahead, and you can either use your finger or if you want to go really old school with a pointer. Take your pick.
I could probably use the pointer.
Could you indicate that canal that you indicated on the west side of US 27?
You're going north and south, running parallel with US 27 Canal Road.
Okay, so I'm going to move this over a little bit. I'm going now to show the 208th Avenue. Can you show the ladies and gentlemen of the jury where the gate is on the south end of 208th Avenue?
There's a gate right here.
Okay. And will you show the gate at the eastern edge of the western part of Pembroke Road as to where traffic is stopped?
Repeat that again?
Can you show the gate at the eastern edge of the western part of Pembroke Road?
Right about here.
And in terms of the waste management facility, is that indicated and shown on this map?
Yes, ma'am.
And where is that?
Right where it says waste management.
And in terms of the access to that, is there a gate for there as well? Sorry, move it up just a second.
That was actually right about here.
Okay. And we just learned that if you touch on that screen, it works too. Okay, Detective Moretti, if you resume your seat. Detective, did you have an opportunity with the Broward Sheriff's Office Aviation Unit to travel from the studio at 805 Northeast 4th Avenue
Yes, ma'am.
to the location of Pembroke Road and US 27 via helicopter?
Yes, ma'am.
Was there a video of that flight captured?
Yes, ma'am.
Does it fairly and accurately depict the points of travel that you referred to from the call detail records and the timing advance records you found with them?
Yes, ma'am.
So I also want to talk about, did you have an occasion at approximately 3:20 in the morning to go to 805 Northeast 4th Avenue in a vehicle?
Yes, ma'am.
Did you then travel from that location across 595 to I-75 to Miramar Parkway and then out to the location of Pembroke Road and US 27?
Yes, ma'am.
Was that filmed with video to fairly and accurately show the conditions at 4 a.m.?
Yes, ma'am.
Okay. So I'm showing defense counsel what's been previously marked as quadruple J for aviation and states quadruple K for the nighttime driver. Detective Moretti, approaching and showing you what's been previously marked for identification purposes only. The states quadruple J and quadruple K. Do you recognize those items?
Yes, my initials and badge numbers on it.
Did you have an opportunity to review those before you came in here to testify today?
Yes, ma'am.
Did they fairly and accurately depict
the flight from 805 Northeast 4th Avenue to the location, and as well as the dark condition driving.
Yes, ma'am.
Your Honor, at this time, the state would request to move in states quadruple J and states quadruple K at states 94 and 5.
May I ask one or two questions?
Yes.
And do it from here?
Sure.
I'm getting tired. What day did you do the helicopter trip?
About a month ago. I don't know the exact date. It would be on the video.
I'm sorry, a month ago?
About a month ago, sir.
2023?
Yes, sir.
So that would be June of 23?
Yes, sir.
While we were in trial?
No, it was before the trial started.
Picking a jury then?
I don't know, sir.
Okay, June of 23.
No, this is strange, it's not my fault, objection.
Well, it's to the predicate. I'm sorry, Judge.
No problem. Two of us can't talk at one time, but in any event, proceed, Counsel.
The nighttime driving at 3:20, you said?
3:20 in the morning, yes, sir.
What day did you do that?
It was probably about maybe 3 or 4 months ago.
So that would have been in
Maybe April.
April of 23?
Yes, sir.
Did you look at any of the conditions, whether or not there were any accidents in 19, 18 when this occurred?
No, sir.
Did you look at whether or not the weather conditions were the same as when you went out in June and April of this year?
No, sir.
Objection on predicate.
Can I see the
Foundation and relevancy.
Done? Are you done?
Yes, sir. I'm sorry.
Can I see sidebar, please?
Detective Moretti, I want to go back in terms of the weather conditions of October of 26th of 2018. Do you recall in terms of, were there any storms?
There was no storms, ma'am.
And how do you know?
We were outside most of the day.
Okay. And when you did the drive at nighttime, is there anything that would help refresh your recollection as to exactly when that was done?
We did the video, actually.
Okay.
The video should have a timestamp on it, as well as I think I produced a timeline for you as well. And probably a report from the crime scene technician who filmed it.
Okay, and that was with Miss
Carroll.
Okay. And do you have notes as to the time frame in which you did that video with you today? Or is that reflected in a report?
I'm not sure if I have those notes with me now.
Okay. So let me go ahead and what I can do is I can show you the video. I'll take it off of the computer here. Did you select a time and date to do the video so it would be the same in terms of the daylight savings time and the lighting conditions on that day?
We did it at the same exact time as the incident.
Okay. And so I'm going to show you what is marked for identification as states quadruple K. And looking on the date of the video creation, does that refresh your recollection as to when it was done?
Yes, ma'am.
And when was that done?
As March 10th, 2022 at 3 a.m.
And in terms of the weather conditions on March of 2022, were they the same or substantially similar to that of October 26th of 2018?
Substantially similar.
In terms of the lighting conditions, were they the same or substantially similar at the locations at US 27 as they were in 2018?
Substantially similar.
Have there been any additional lighting or street lights installed?
No, ma'am.
Have there been any removed from the location of Pembroke Road and US 27?
No, ma'am.
Does that video fairly and accurately depict how US 27 and Pembroke Road looked in both 2022 as well as 2018?
Yes, ma'am.
Has there been any development?
No, ma'am.
Any additional buildings?
No, ma'am.
Any additional businesses or anything for that there?
No, ma'am.
Here at this time, the state would renew the state's motion to move in state's quadruple K into evidence.
Any objection?
Yes, same objection.
Objection, no, it's overruled.
Okay, and then with regards to state's quadruple, I'm sorry, that was state's quadruple K.
Excuse me 1 second. What's the exhibit going to be? K? Quadruple K, I'm sorry.
Quadruple K will be states 94.
94 and ever.
And with regards to state's quadruple J, I'm going to show you that one now. And you previously looked at these?
Yes, ma'am.
In terms of the lighting conditions in state's quadruple J. I'm sorry, state's quadruple K. Travis, I think I mixed them up a little.
Excuse me 1 second, Counsel. Can you show the exhibits to Travis, both of them, wherever's been marked?
I didn't put the numbers on them, so the new thing switched with the pencil marking. Was that state's quadruple J, actually, that I just published the night 10 drive? I believe? Okay. Thank you.
So correct date, please.
So states quadruple
J.
will be states 94.
Thank you.
So showing now
Excuse me, is that the flyby or the drive-by?
driver.
Drive.
So in looking at what has been marked now as states quadruple K for identification, is the lighting conditions the same?
No, ma'am.
In terms of being able to accurately show the path of travel as determined, is this the most efficient way of doing it?
Objection leading.
Sustained.
In terms of doing this on a nighttime drive on that, were there changed road conditions?
The reason we filmed this during the day was because of the lighting conditions makes it more visible. The recording studio is no longer there. When we did the actual nighttime drive, there was construction on 595 and 95, so we had to divert. We didn't start. We had to extend the recording a little bit. So
in terms of the recording that is in right now is states 94 from the exit of Miramar Parkway and I-75 to Pembroke Road and US 27. Is that fairly accurately depicted?
yes, that's that.
So in terms of showing the actual road travel, how does the flyover show that better than trying to drive?
It's a more accurate depiction because it's at night. You can see it a lot easier. The construction is no longer on 95 and 595, so it clearly depicts the path that was taken that night.
Was there construction on October 26th of 2018 on those areas?
Not to my knowledge.
Here at this time, the state would renew its motion to put states quadruple K in as states 95.
Objection on relevancy, predicate, foundation.
Thank you. Objections notice overruled. It'll be admitted.
So states quadruple K will be states 95.
95. Perfect. Okay. So I would start with publishing states 95. So Detective Moretti, if you could please point out what we are looking at here first. Oh, and the lights, please, Travis.
Right here is the where the recording studio used to be.
And so at the top of the screen, is there a compass which indicates the heading?
Yes, right there. And then this is Flagler Street, which goes up to Sunrise Boulevard. And then this is Sunrise here. And you would make a left, which then would head west on Sunrise Boulevard. Take Sunrise west to 95.
Detective Moretti, when you did the drive of this, it took approximately how many minutes to get from the studio to Miramar Parkway?
Probably about 20 minutes, 20, 25 minutes, something like that. This is the 95 ramp here.
So which direction is the helicopter that you're in traveling now?
We are moving south now.
When you get to Broward Boulevard, at that exit, will you indicate, please?
We took 95 down to 595.
Understood. And just for purposes of keeping reference as to where it is, are you from Broward Boulevard and the other locations? Was that Broward that was just passed?
I believe so, ma'am.
Where is the helicopter traveling now at this point?
We are turning west onto 595. That would be the turnpike entrance. Still on 595 heading west.
And just so it's clear, you can indicate which road is the pointer on the big screen so everybody can see which road you're following.
We're still on 595.
And Detective Moretti, I think the next thing I'm going to ask you to indicate to the motor is when the express lane's toll booth is shown that we watched the footage from already.
We're going to be closer to 75.
Right, I'm going to ask you to go back to your Air Force days. What does an airspeed of 100 knots translate to?
I didn't fly in the military family. If you look to the right, it has the miles per hour.
Thank you.
passing hiatus coming up to Flamingo. Southwest 136. And that will be the
Southwest 136 right there, or, I'm sorry.
Well, it's 136 right here, and then there's the Sun Pass.
Okay.
And then we'll be turning south on I-75 heading south.
And just so you can indicate which road on this would be that direction. small for me. When it gets to, I believe, 16 minutes, we'll pause it and switch to the other viewer.
We just passed Sheridan Street. That's Pines Boulevard.
Captain Moretti, what is the exit just before Miramar Parkway?
Pines Boulevard. We're exiting Miramar Parkway now.
Okay, and that is at 15:07, and we're stopping it at 15.
I'm sorry, I can't hear you. What?
Sorry, I'm going to let it continue on until 15:30. Now publishing states 94. And Travis, I'm going to pass the other light as well, please.
Is that exhibit 94 or 95?
94.
94. Thank you.
So Detective Moretti, if you could explain where this video picks up.
We are right now on the off-ramp to enter onto Miramar Parkway from I-75. We are now on Miramar Parkway, heading west, approaching Southwest 160th Avenue, which is also known as the Dykes Road.
And to the right of the screen, what direction is that cardinal direction?
To the right of the screen, that would be the, we're traveling west now, so to the right would be the north.
Okay. And if you could, when you get to the Pollo Tropical, if you could identify that.
We just, there's a Chili's just past there. You're coming up to a target. That was the entrance to Regional Park, which is on the right side. We're still heading west. So there's the Boulder Truck Hotel right there. Gas station, we should be coming up to Southwest 172nd Avenue, which is a McDonald's.
And if you go north on Southwest 172nd Avenue, what is located at Southwest 172nd Avenue and Pembroke Road?
That would be the hospital, Memorial Hospital.
And if you indicate again when you get to 184th, which was the end of the walking, I believe you testified to by the officers in your mark, please.
Yes.
Okay.
This is 178th, which is Silver Lakes, Southwest 178 Avenue. The next light you see, the green lights, is going to be Southwest 184th Avenue.
To get to the entrance of 40th Street for Sunset Lakes, the guard gate, which way would you turn at 184th?
You make a left, and you would head south on 184th.
You turn right on 184th.
You head north into Pembroke Pines.
On Miramar Parkway, does it connect through to US 27?
No. This is 184th right here. You're turning right, which is heading north.
During the time of this video, are you operating the vehicle?
I am driving, and Miss Carroll is recording in the passenger seat.
Are you observing posted speed limits?
Yes.
Are you purposely driving slower than the speed limit?
I'm driving exactly. I'm driving exactly at the speed limit. We're coming up to Pembroke Road.
Does Pembroke Road connect through if you turn left there to US 27?
No. The red lights we're approaching is Hines Boulevard.
Does Pines Boulevard connect to US 27?
Yes, ma'am.
What is the next road? Let me rephrase. Is there another road in Broward County south of Pines Boulevard that connects to US 27?
No, ma'am. turn left, which is heading west on Pines Boulevard.
And when the Montessori Academy is on the left, because the
Correct.
just indicated.
This would be the Montessori School.
Okay.
to US 27. We will remain on the left, heading south. Coming up Pembroke Road.
Are there traffic light at Pembroke Road?
No. Left-hand turn, which will be east on Pembroke Road. this is Pembroke Road.
Approximately what time of the morning is this that you're doing this video at right now?
We're here approximately at around 4 a.m.
How many times have you been out to this location before you did this drive?
Several times.
And what vehicle just passed you?
That is a waste management vehicle going out to the dump. Now we're turning around.
Is there a particular reason you chose that spot to turn around?
That was the approximate crime scene location.
As we turn here on 27, you're allowed to submit this to be a logical place to break?
Yes, ma'am.
All right, your own lights, please. Thank you. All right, ladies and gentlemen, it's a little after 5, so my colleagues will break through today. Remember the admonition, do not discuss the case, don't form any opinion about the case, don't allow anyone to discuss the case in your presence. Concerning no research, just leave your notepads on your chair. You'll see everybody back tomorrow at 9. Thank you, ladies and gentlemen. Thank you. Let the record reflect the jury stepped out. Counsel remain along with the defendant, and the witness remains on stand. Anything for this witness tonight?
No, just check ready. I cannot contact you or speak to you in any way. If there's any emergency, please contact you in my office or the business data.
Yes, ma'am.
Thank you. We have an issue, Judge, we'd like to discuss outside the presence of this witness.
Sure. You step back, sir. Tomorrow, 9 a.m.
Hey, Dan. Dan.
All right, the witness. All right, the witness stepped out. Counsel, what do you want to discuss?
We need the assistance of the state to bring back Special Agent Collins when the state rests. We never anticipated that this witness would be qualified, able to testify to the coordinates or any of that, which is contra to everything that the FBI agent testified to in his deposition and what have you. And there's additional items to go through. In order for us to subpoena him, we have to go through the Justice Department, as the court probably knows, because we're defense attorneys and they're not that quick to respond to us, and we have to fill out paperwork and get permission. But since the state has called him, we would ask the state's assistance to get him in when and if we put on a case.
My understanding is Special Agent Collins was on a TDY. That was the information that's given to me. A TDY, which is Management Sort of Training Deployment, and will be out of the country for the entire month of July. That's why I had to rush to call him so early in the case. He told me to push back, delayed for the
start date, so he would be available last week if I needed to put him back as far as that, I think, but I don't believe he is in the country.
It's June.
It's July.
Oh, it's July.
Counsel, if you could just verify whatever it is and then speak to... I'm sorry, yes, sir?
I said, if they would assist us and let us know if he's available, fine. If not,
he might be available by soon.
So can you do that, check into that?
So I would say emailed him on a different issue, and he has not responded. So I don't believe he has access to his email. That's the only way I can get in contact with him. So I'm happy to try and assist on that.
Thank you.
But the defense still has to do the proper procedures before you'd be able to testify.
All right, but you're going to make some inquiries, and you'll speak to Councilman Adelstein and his cohorts.
In terms of the defense doing the proper procedures, Your Honor, that is a procedure that takes several weeks, if not months. So that's not feasible. That's why we're asking for the state's assistance in bringing him back. So because the hoops we have to jump through would have him here in September.
Thank you.
A one-page letter that has to be written around.
I don't know what it is, Counsel, but you said you're going to make inquiry, and that's what I'm asking you to do, to contact them, and we'll, once we find out where it's located, what is the next order of business, so to speak. So, how much more do you have of this witness, Counsel?
A lot.
So, are you going to be on direct for the rest of the day tomorrow?
I think we might start. We might start cross, perhaps. I said there's, a lot of messaging and phone data to go through and publish.
But you're going to be most of the day tomorrow, you think?
I think
so. Direct. And you have a substantial amount to go over on cross?
I would think so at this point. If they're going to take most of the day, I would ask that we not start crossing so far.
And we'll just see what time of the break, what time it is. I'm not guarantee anything, but...
No, I understand. But
after Detective Moretti, State intend to call any other witnesses?
Not at this time, right?
So,
there's something that might change, but...
Understood. So right now it's Monday, so tomorrow's Tuesday. You're going to be most of the day Tuesday. Counsel thinks if he gets to him tomorrow or not, he'll take at least half a day Wednesday. Is that about right, Mr. Adelstein?
Yes, sir.
So assuming you don't call any more witnesses, state would be resting, then you'd be prepared to bring some witnesses in either Wednesday afternoon or Thursday, depending on how it goes. Is that right, Mr. Adelstein?
I have to confer with co-counsel. I can't answer that right at this moment.
I'm just trying to get an idea, so you're prepared to go ahead. That's the way it sounds like to me. Am I correct, Ms. Bradley?
Yes, sir.
All right, so we're talking about sometime, this week you'd be calling witnesses.
Judge, the only issue on that is we had the deposition, the first part of the deposition of the defense's witness, Larry Daniel, was done on last week. Then we had agreed and came before Your Honor on Friday morning to bifurcate that deposition, and we agreed to do it on Saturday. I then procured a court reporter for 5 p.m. on Saturday at the request, and after Ms. Liberty had acknowledged she would produce the witness at 5 o'clock. However, then at 4:57, I got an email from Mr. Howard indicating that they were no longer going to be having their expert and producing their expert. So I'm going to have to need some sort of court intervention to make sure that that deposition happens in a timely fashion.
May I proceed, Judge?
Before somebody responds, are you still intending on calling Mr. Daniel?
We do intend to call Mr. Daniel. We do not intend to call Mr. Daniel to address the subject matter for which the state wants to further depose him. It's outside the scope of what he's being called for. And so we're not making him available for them to put him to task to review what the state would have him review that's unrelated to the testimony in its entirety. So remember,
I don't understand. I thought he was an expert originally in Cellbrite, and then he was switched over to Fitbit or something along these lines.
that to pedometer versus Celebrate. What the state is asking him to, the witness to do, is to go and review some Celebrate information and cell tower information so that the state can inquire of him on that subject, not regarding the pedometer testimony. And so we're not making him available for the state to go exploring and putting him to task. These things on our dime.
So he's going to testify as an expert regarding Fitbit.
If he testifies at all, that would be the pedometer. That would be the scope of his testimony.
Have you deposed him on that issue?
No, Your Honor. That was what the expert said he needed, the data from Celebrate, to look at the activity data because the information that was sent to him by Miss Liberty was corrupted. So then I helped out and sent him a brand new copy of the cell phone download so that he could review it. I am still trying to ask him questions specifically on the activity and location data that is found in the phone. And for most of the answers to the questions were things to the effect of, well, don't quote me on that, I have to check my notes. He was doing it from the side of the road in a car, so he has to go back and check his notes. They have not yet provided me these screenshots that he mentioned in the first part of the depo that he had said he had received. I'm just asking to have the information and be able to have the witness answer questions after he's reviewed everything. Because it's the state's deposition of the defense witness. And a deposition is wide latitude in the areas that you can cover, questions that you can ask. On that, the state wants to make sure we are prepared and in whatever area he is trying to answer questions, and if we need to file a dower. So the state needs to be able to complete the deposition, and we were prepared and ready to do so on Saturday before it was canceled 3 minutes before it was set to start.
She's not actually the forthcoming judge. She had actually asked if we could do it on Sunday. Mr. Daniels said he was not going to work on the Sabbath. This was something that he teaches on Friday. We explained to the state he teaches. He was actually traveling. I was trying to get this done so he could be in his house and do the notes. I offered him up Tuesday or Wednesday evening. I know Mr. Howard Joe has filed a motion on pedometers. I don't know if we need to argue that motion before we even determine, because if he's successful on his motion, I don't think we need to have the deposition. So I would ask that we have time to argue this motion maybe tomorrow morning.
So with regards to that, I wouldn't be prepared to argue the motion until I finish fleshing out their expert opinion on that. So I need to have to do everything in order.
That's not so. The basis of my motion is authentication concerning the state's introduction of the evidence and what is required in order for them to introduce evidence in the first instance. Our witness would be there to rebut the evidence that is being presented by the state. And so inquiry of the expert, of the defense expert, does not address or even implicate the question of whether or not the state has satisfactorily laid a foundation on authentication for admission of the evidence in the first instance. So Ms. Liberty is correct to the extent that we could obviate the need for any depositions if the court reviews the motion and rules favorably in defense position.
Anything else?
Yeah.
Anything else?
No, sir.
So let's do this. Take everything one at a time. Counsel's asked to take the deposition of your expert. She hasn't deposed the expert yet, is the way I understand it. So let's get the deposition done. I don't know where you would intend to call that witness, but you make them available. Work it out. What's good for you, Madam State?
Judge, I could do potentially Wednesday after court.
Is that good for you?
That's
Can you
fine.
check with your witness?
That's one of the dates I offered her originally, Judge. Yes.
So that's good. Set it for Wednesday after. All right? And then you take a look at your thing. I haven't seen the motion yet. The motion was filed.
It was filed at a late hour last night, but it...
haven't seen it. So...
hope you enjoy it.
Pardon me?
I hope you enjoy it. It's an effort to do.
I have no problem taking a look at it. You don't have a hard copy there, do you?
I actually do. I'll pass it up.
Just for the timing it was filed so I can check my email. You said late hour.
Around before 11 p.m. I want to say 10:26.
There's a problem sometimes where they don't, the clerk's office, even though it's filed, it doesn't show up on the clerk's system right away. I don't know why or what it is, but
there's a delay. I've been
There's
seeing
some
in a
delay.
lot of my cases.
I'm asleep at that hour. I'm an old man, Judge. So I would know, even if it was filed.
Why are you telling us something we already know?
Which is, you got to speak like that. And I got to get some levity in this courtroom somehow.
Thank you, sir. I appreciate that.
Thank you, Your Honor. I think it's the mere fact that filing shows such deficiencies in technology even in 2023 kind of goes to the heart of the motion. So,
All right. Well,
dovetails.
anything else to talk about, Mr. Hammond?
No, sir.
I just want you to be aware today, when I did make the objection, we did not have the full transcript of Brandon Collins, and I don't want you to be annoyed if I bring it up again tomorrow once I get the cross-examination. Just advise.
No problem.
Have a lovely
Good night.
Good night.